to go.
Call to order. Well, good morning, everyone. I decided this year to abridge the opening comments. It's always 15 minutes, and I never have 15 minutes worth of things to say, at least not right now. I usually do, as Roger knows. By the way, I'm Trevor Burris. I'm the editor-in-chief of the Cato Supreme Court Review and a research fellow here at the Cato in the Robert A. Levy Center for Constitutional Studies. And welcome to the Cato Institute. We're not in our usual environs in the F.A. Hayek Auditorium, which if you can peek in there, which we have Cato-branded hard hats, by the way. But if you can peek in there, it's going to be turned into a much more optimized for web streaming service, which is most of our audience today, actually, welcoming our audience on the web, welcoming our audience on C-SPAN, welcoming to you here for our 21st annual Constitution Day. Now, 21 years ago, when I was waiting tables and playing in metal bands and backpacking Europe, Roger Pilon and James Swanson there inaugurated this event and inaugurated the Cato Supreme Court Review, which this is my 4th one editing. I've worked on 12. I was an intern who did very bad site checking, I know. And that was my first Constitution Day, and this is my 12th. I asked James today, who came up with our citation style, which I've decided I'm going to change next year because I have that power. So respect to James, but we're going to change it to just Blue Book. You know, we're not going to be doing this stuff anymore. The Cato Supreme Court Review is the nation's first published law journal covering the most recent decisions of the Supreme Court term. And it's a quixotic endeavor. You have to publish this thing pretty quickly. I think I remember some of August, but not most of it. I did get through all the Star Wars movies though, because I put them on the background while I'm like doing hand edits at like 3 in the morning, so I got through them like multiple times. And I'm wearing a Star Wars tie to commemorate that. And today we commemorate, well, tomorrow, we commemorate the day 235 years ago that the framers of the Constitution decided to sign that document, a Constitution at the time, and of course it would not become the Constitution of the United States until it was ratified by the people and came into place in 1789. Ilya Shapiro is not here, but he will be here later. I also will call him out whenever he walks in. Today, the Constitution, of course, has many detractors from both the left and the right. It is regarded as antiquated by some, with outdated concepts. Of course, here at the Cato, we adhere to the Madisonian vision. Cato was doing, we adhere to the Madisonian vision of the Constitution, which is freedom and individual liberty through limited government. Now, this year, of course, was quite controversial. If you look at my forward, one of the things that I was thinking about this year was whether or not, in the course of a week or 6-day period when the Supreme Court decided a case about guns, and then a case about abortion you might have heard about, and then a case about climate change, there were a lot of people who said, well, here we go. We have Republican-appointed justices who love guns, hate abortion, and are skeptical of climate change, and that was how they interpreted the court's work. Of course, for originalists, we did something different, and many originalists said, well, no, guns is in the Constitution, so they enforced that. And then the abortion question was arguably not in the Constitution. We can talk about that, and Evan Bernick will be here to talk about that. And returning the legislative agency power to Congress. These were both pro-democratic decisions, but I think it's interesting to ask now whether or not a fully originalist court will be perceived as legitimate by the American public, which is what I write about in my foreword. Now, for the thanks, there's so many thanks here. I want to first thank Roger Pilon, who saved me from, I don't know probably corporate law when I was an intern and hired me. And as we gave me many dressing downs over the years and hard editing, and founded and created the ethos of the Robert A. Levy Center for Constitutional Studies. And while I'm at it, I'll thank James Swanson, who, by the way, if you don't know, wrote an excellent book called Manhunt, which is about the hunt for John Wilkes Booth, which is being produced into an Apple show. So that's good news for James. Of course, I'd like to thank all of my colleagues who helped with some of the editing, Jay Schweikert, Walter Olson, Clark Neely, who currently leads the department. And I'd like to thank Will Yateman for his edits on Jonathan Adler's piece. And I'd like to thank all the associates, Nicole Sayed-Bembridge, Gregory Mill, Isaiah McKinney, our intern Chris Condon, for doing this sort of editing and fly-specking stuff, which I quite frankly don't have the time for quite often because we do it so quickly, so I rely on them. I'd very much like to thank Tommy Berry, who is the managing editor of the review, which was my former position. He did an excellent job stepping up and helping out. I'd like to thank Laura Bondonk, who came in as my associate and had never worked on the review before in any capacity and had to learn all of that stuff herself. Of course, we have to thank our excellent events team, which is second to none as far as I'm concerned in this town. Linda and the whole events staff, Kiana, who used to work on this event, and Katie, who's standing right there, who had to also have a trial by fire to put this event on. Now, some of the logistics, we run a pretty tight ship here with the panels. You'll see in your packets who's going to be on the panels, and of course you have a copy of the Supreme Court Review. On that point, if you find an error in the Supreme Court Review, I do not want to hear about it. This is very important. I sent that off, and then it's just like, into your wind, and then they're gone. And so I don't want to hear about it, as I'm sure there are some. Now, bathrooms, since we're up here in the George M. Yeager Conference Center, bathrooms are just right there. You probably saw there's other ones downstairs next to the elevator, and if you go all the way downstairs, there's other ones down the hall. We'll be serving lunch in this room at 12, and then we'll come back for the panels. And we have the Looking Ahead panel, which will have Ilya Shapiro, who you can't really get rid of him as much as he could, but he'll be back to write. He wrote the article in the review. Although, see, he's not here. When he submitted the article to review, he edited 11 volumes of the Spring Review. His footnotes were all wrong. And I was like, are you kidding me? Seriously? I said, if he didn't, I think he was just trolling me, ultimately. And then, of course, we have Professor Akhil Amar, arguably the preeminent scholar, constitutional scholar in the country, to deliver the B. Kenneth Simon lecture at the end of the day, and then there will be a reception, I think assuredly on the roof. I don't think that rain is in the forecast, so it should be on the roof for closing out. And then after that, I get to not think about the Supreme Court review for 3 whole months. And I'm going to Iceland. So I'd like to invite, for the first panel, Will Yeatman coming up here. Will, is your public announcement or on your, Will is leaving Cato to go to the Pacific Legal Foundation, which is increasingly like a large, I feel like it's sucking up everyone in my life. Everyone works for Pacific Legal Foundation now. And we wish him well. I was telling Tommy today, I remember your very first Constitution Day. You were like, I've never moderated a panel before. And I was like, really? You've been in DC for 10 years, you've never moderated a panel? He was like worried, and then he got up here with his Will style, which he will show off now, easygoing and fun. And he also contributed an article to the review. He was complaining he didn't get it right about West Virginia, John, but you guys can duke it out. So I'd like to invite the first panel up to talk about constitutional structure, Jen, Ilya, John, and Will, and I will be back to moderate panel 3 and at the end of the day. So thank you very much.
Thank you so much, Trevor. I'll just note that PLF gave me the opportunity, one that Cato couldn't. I mean, I love Cato. The opportunity to work with my gorgeous wife. So welcome. My name is William Yeatman, or I guess that's already been established. I work here at the Cato Institute's Center for Constitutional Studies. For our first panel, we'll be discussing cases from last term that relate to constitutional structure. So this panel will reflect a recurring theme throughout the day. There was a lot to last term besides Bruin and Dobbs. As to how this will work, I'll introduce each of our speakers in turn. We'll start with Professor Jonathan Adler. I should have noted, we'll introduce each of our speakers in turn. They'll speak for a bit. We'll open it up to some back and forth, and then audience Q&A. So starting with Jonathan Adler. He is the Johann Verheij, did I pronounce that correctly? Thank you. Memorial Professor of Law at the Case Western Reserve University School of Law. So like all of our panelists, Jonathan has a sterling CV. To wit, I believe he's among the top 5 most cited administrative law scholars. That's no small matter. I did some poking around, and I learned that Adler has set up an amazing outdoor theater at his home, and that is because he's adamant about family movie nights. I thought that was pretty cool. Professor Adler will present his chapter on West Virginia v. EPA. So thank you.
I can time myself. There's a handy clock. Thank you, Will. It's a pleasure to be here. It's always fun to be back at Cato and to be here for Constitution Day, to see Roger, who I used to debate constitutional law questions with when I was a mere college student in the basement of the old Waterston House in my first summer being involved with Cato. And it's a pleasure to talk about West Virginia versus EPA, a fun case, a case that concerns the Clean Air Act, which is an act that some of us have learned to know and love very deeply, or at least have a love-hate relationship with. And just to kind of give the quick overview or the quick summary of my views about West Virginia versus EPA, I have very mixed feelings about this case. I think as a pure matter of law, the court reached what was clearly the correct result in that the EPA was asserting authority that Congress had never delegated to it. On the other hand, the sort of power that EPA wanted to exercise is, as far as climate policies go, certainly better than a lot of the alternatives that EPA has been delegated the authority, or at least has arguably been delegated the authority to do. The court reached the correct result in the case, but it's not clear the court should have heard the case, not because it lacked jurisdiction, as some claimed. It certainly had jurisdiction, and when you read the opinions, it's clear that the jurisdictional arguments were interesting, but never had much substance to them. But it's not really clear that the case should have been before the court anyway, and I'll say a little bit about that. And I also have mixed feelings because while I like the result, the opinions are underwhelming. All of them. None of the opinions in the case really take seriously the text and structure and operation of the Clean Air Act. The majority utterly fails to do the heavy lifting that certainly was done in some of the merits briefs and in some of the amicus briefs to really look at how the Clean Air Act operates, how Section 111 operates. And as a consequence, the dissent gets to pretend as if you can resolve the whole case by focusing on a single word, which was an interesting posture to see Justice Kagan take in an opinion, given some of the things she has said about statutory interpretation in the past. And the decision also missed an opportunity to bring clarity and principle to what is a very important underlying question, which is how do we understand the delegation of power to agencies? How do we understand and determine what power it is that agencies have been delegated by Congress? And this is an area of law where the court has given hints and made gestures, but has not really given the degree of clarity that it could have. And this case presented, in my view at least, a perfect opportunity to do so, and that's an opportunity missed. So let me give a little bit of background and then flesh out some of these points, and of course the paper fleshes out some of these in more detail. For those of you that have not spent years reading and rereading and trying to make sense of the Clean Air Act, let me give you a little sense of what this law or this case was about. So at a broad level of generality, it was about the scope of EPA's power to regulate greenhouse gas emissions from power plants. In particular, what EPA could do when setting standards of performance that power plants must meet in terms of their greenhouse gas emissions. There was a debate over whether greenhouse gas emissions should be considered pollutants under the Clean Air Act. That question was resolved definitively, I would argue erroneously, but nonetheless definitively in Massachusetts versus EPA. And since then, the court has recognized that, that while greenhouse gases are pollutants for purposes of the Clean Air Act, or assuming they are pollutants for purposes of the Clean Air Act, that does not give the EPA the authority to alter the Clean Air Act or its operation so as to make it operate better for greenhouse gases, because greenhouse gases are not traditional pollutants. They're not emitted in the volumes that traditional pollutants are. The effects they have are not the effects that traditional pollutants have. And the way, if one were to try to reduce them, the way one would try and reduce greenhouse gas emissions is not the way one would try and reduce particulates, nitrogen oxides, hydrocarbons, and so on, particularly if one wanted to do it in a remotely efficient way. But the Supreme Court had made clear long before this case that just because there are better ways to deal with greenhouse gases does not give EPA the authority to massage, to stretch, to rewrite, to repurpose provisions of the Clean Air Act that aren't a good fit. In the Utility Air Regulatory Group versus EPA case, the Supreme Court made that very clear in language that you can go back and pick out passages from UARG, and they tell you exactly what the court was going to do here. So So Section 111 of the Clean Air Act is a provision that allows the EPA to set standards of performance for specific categories of sources of air pollutants. And what the EPA does is it's supposed to determine what is the best system of emission reduction that has been adequately demonstrated considering cost and a few other factors. And then that is the standard that categories of that source are required to meet in terms of their emission reductions. And when it comes to greenhouse gases out of coal-fired power plants, if you do the thing that traditionally you do under Section 111, that you traditionally do under other provisions of the Act that anticipate technology-based or method-based standards, you do heat rate improvements or something like that, and you don't get much in the way of reductions. And that's just the way it is. Because the other things you might want to do, like carbon capture, well, it's hard to argue that at least at this point that's been adequately demonstrated considering cost, which is one of the other requirements of Section 111. And that was certainly true when the Obama administration was drafting the Clean Power Plan. So the Obama administration said, well, this language, best system of emission reduction, read in context, understood as it has always been understood since that language was written in the Act, the way the Act operated based on what was written in 1970, 1977, and 1990, that anticipates things you do at the facility, within the control of the firm that owns a particular facility. But that language, best system of emission reduction, certainly seems broader, certainly when taken in isolation. And if we're talking about power plants, we're really talking about facilities that are part of a broader system, the electric grid. And if we're concerned about that, well, then maybe we reduce emissions by saying you coal plants operate less, gas plants operate more, renewables operate more, and that sort of trading is a much more efficient way of reducing emissions. That's certainly true. And the Obama administration thought you could take this phrase, in some respects, read it out of context and say, well, this is a system of emission reduction. It's just not the type of system of emission reduction that had ever been anticipated by those writing, voting on, or implementing the Act ever before. And so that was the basis of the Clean Power Plan. Now you may wonder, again, if you haven't followed this case, well, why are we talking about an Obama administration regulation? We're talking about a decision that the Supreme Court handed down in 2022. Well, the Clean Power Plan was stayed by the Supreme Court, and that's a whole fun story, which if I had time, I'd get into it, but the Supreme Court stays the Clean Power Plan. The Trump administration comes in and repeals the Clean Power Plan, and it does so on the basis of saying the Obama administration misread the statute. We think the language of the statute is much narrower, much more constraining, and so that both means the Clean Power Plan is illegal, and an alternative that was referred to as the ACE rule is the only rule that is consistent with the statute. Like anything the EPA does of any significance, that was challenged in court just as the Clean Power Plan had been. The D.C. Circuit invalidates the Trump administration rule. I'll just note, and as someone who clerked on the D.C. Circuit, this was curious. A decision of this magnitude on a regulation of this importance was issued the day before inauguration. Unusual. The D.C. Circuit has tons of cases that it's dealing with in transition years and knows full well that as soon as the transition occurs, the new agency heads and the Justice Department may have opinions about which cases it's once stayed, which cases it once remanded to the agencies, and understands that adding a decision that may bind the agency's hands in one way or the other is something that might not be necessary. It was certainly curious that an opinion like this would come out on January 19th. Had it not come out, we would never, on that day, had it been held for a day, for 2 days, we probably never would have had this case. We had the decision come out, petitions are filed. Something else about why we should never have had this case, the Justice Department opposes certiorari. That's not a surprise. The Justice Department raises no jurisdictional concerns in its brief. It has a brief mention that, well, this might be an advisory opinion because we might decide to do something different because the Clean Power Plan's outdated, but never in the Solicitor General's opposition to cert does the Solicitor General suggest what is the obvious way to handle that problem, which is to ask the Supreme Court to grant vacate and remand, which is, again, a normal thing for the SG's office to do in this situation. There's an old regulation, it's out of date. The regulation that was just struck down by the DC Circuit, we don't want to defend because it's the other team's regulation, it's not ours. We don't want to defend that. We'd like a clean slate so we can come up with a regulation under the Act that is consistent with our policy and that makes sense given what's changed in the industry since then. That would be the routine thing to do, not mentioned in the cert stage brief. It is finally raised in the merits brief, but it's too late. You're not going to convince the court to do something like that in the merits briefing. If you want to convince the court to send the issue back as a mulligan, you'd have to do that at the cert stage. And again, curious why that was not done. So we get the case. When the case is granted, there was no question what the outcome was going to be. There was no question. The court did not take certiorari to do anything other than overturn the extremely broad interpretation of the Clean Air Act that the DC Circuit had issued. The only question was how the EPA would lose. There was some thought that maybe we would get a very narrow textual opinion, the sort of opinion that Clean Air Act geeks like me love, where really, rolling up your sleeves and getting into the bowels of the act. But again, odd case to take if that's really what you wanted to do. And let's face it, I don't think Supreme Court justices enjoy digging into the Clean Air Act as much as, say, DC Circuit judges. Another possibility a lot of people talked about was a broad non-delegation ruling, but that really wasn't in the briefs either. It was in the background. It was a looming presence because if you're talking about how broad is the power that an agency has been delegated, certainly the prospects of a non-delegation doctrine looms large in that context. But the briefs themselves were really just saying, look, conclude that EPA was not delegated this power. Major questions was on the court's mind. We knew it was on the court's mind because we had just seen the decision in the eviction moratorium case that made reference to the major questions idea. We knew the Osha case was coming. The question was really how the court was going to approach the major questions doctrine. Was it going to say the major questions doctrine, it's kind of like a canon of construction, a tiebreaker, something that helps us resolve an ambiguity in a statute, or is it going to be something we throw on the table right up front and say this is going to kind of predetermine our statutory interpretation? And the latter is what the court did, right? Chief Justice right up front in his opinion says, there's a way we normally interpret statutes in this sort of context. We read things in context, yada, yada. But there are extraordinary cases where we do something different. Cases of great economic and political significance. And this is one, and in effect loads the dice for the inquiry to follow, and in fact excuses him from having to actually deal with the details of the Clean Air Act. It's an easy way to deal with the case. It's a way for the court to avoid perhaps saying something about the details of the Clean Air Act that might be wrong and that might, hamstring the EPA or the DC Circuit going forward. But as a doctrine to be administered by lower courts, it's something of a squishy mess. Because the question now for lower courts is, well, is this the sort of case where we do the normal thing of looking at the statute and figuring out what power was delegated to the agency, recognizing perhaps the long-standing principle, the principle that was a staple of statutory interpretation cases and treatises in the late 19th century, that you should be suspicious of claims of implied delegation, that claims of broader delegation of authority require greater evidence than narrower claims of delegation. But instead, do this threshold inquiry, is this a major question? Are there enough zeros after the dollar sign? Were there enough segments about this question on CNN? Was the bill that was introduced in some committee ever given serious consideration so we can say Congress thought about addressing this? These are not inquiries that courts are really good at. But those are the sorts of inquiries West Virginia tells lower courts they're supposed to be doing. In terms of figuring out major questions. I've probably gone on longer than I'm supposed to, so let me just say two really quick points and then stop. The good thing about at least the way Chief Justice Roberts justifies his approach is that he does identify the underlying principle, which is an essential one, not a non-delegation doctrine, but what we might call a delegation doctrine, a doctrine that understands that agencies only have power if it has been delegated to them. Something the court has said repeatedly, something that agencies often forget. If they want to exercise power, any power, they have to find that Congress has delegated it to them. If there is no delegation, there is no power. If there's no delegation, there's no deference. If there's no delegation, there is no authority to tell power plants or anybody else what to do. The problem is that from that principle, one can actually spell out a meaningful way of thinking about the way instruments like legislation delegate power, how we interpret those sorts of instruments, how we think about them in terms of agency principles, not agencies in terms of administrative agencies, but agencies in terms of principal-agent relationships, and recognize the broader the claim of delegation, the greater the showing we should expect. Because we don't expect the drafters of instruments to hide elephants in mouse holes. But that doesn't suggest we should try and distinguish between major and minor questions. It means we should make sure that whatever power is claimed has in fact been delegated and is consistent with the text and structure of the underlying statute. The other thing that I think is somewhat good about the opinion, and again, this is my last point for sure, is that it recognizes one of the particular problems in this context arises from the fact that Congress doesn't like to revisit these statutes. And we have lots of contemporary problems that raise important policy questions that Congress has not spoken to. And we have a trend that is not new, that did not begin with the Obama administration. It goes back at least to the Clinton administration, of the executive branch saying, well, if Congress is not going to give us the power we want, we will figure out if there's something they gave us before which will do the trick. I kind of think about this it's like when I'm doing, some kind of amateur repair work at home, and I bring a wrench upstairs, and I realize I need a hammer. But I don't have a hammer. I grabbed the wrench. Well, if you turn the wrench on its side and you angle it just right, you can make it work like a hammer. And that's essentially what agencies have been doing. We've been given wrenches, but we'd rather have a hammer. Let's find a hammer. Let's make this system of emission reduction not be what Congress was actually giving the agency the power to do, but something that'll be more useful given the problem we're trying to solve. Let's pour new wine out of old bottles, because old bottles are all we have. And the majority opinion is sensitive to that concern. But again, I don't think it fully realizes that the way to deal with this is to just think more seriously and in a more principled way about how it is we understand what powers agencies have. And this is particularly disappointing to have come from Chief Justice Roberts, because he's pointed this out before. In a case called City of Arlington versus FCC, he identified these principles, albeit in dissent. And in some respects, the biggest problem with West Virginia versus EPA was that perhaps the Chief Justice had decided they'd overturned enough cases this past term, and they didn't want to overturn this obscure administrative law case in which he dissented before. But had he done so, we might have had a more workable doctrine resulting from West Virginia versus EPA. And I apologize for going on too long, and I will turn it back to you, Will.
Oh, no. Oh, there we go. For efficiency's sake, I'll just stay here while he gets up there. That was great stuff, Jonathan, and some of those metaphors I really dug. Our next speaker, Ilya Sohman, is a professor of law at George Mason University. So by my count, you have authored or edited 5 books?
6.
6 books. So I stand corrected. 6 books, nothing to sneeze at, on subjects ranging from democratic theory to immigration rights. I have it on good authority that Ilya organizes an annual Dungeons and Dragons game with his students that's sold at the Scalia Law Public Interest Auction. I think that's pretty cool, that both that you play Dungeons and Dragons and that you're using it for the forces of good. But without further ado, Professor Sohman will present his article on the vaccine mandate cases. So that's NFIB, the Occupational Safety and Health Administration, and also Biden v. Missouri.
Thank you so much. Thank you to Will for moderating the panel and Trevor for organizing this exciting event. Continuing the theme of ties to the Pacific Legal Foundation, my wife Allison, who will be here later today, actually works for PLF, so we have that going on. But my job here today is not to talk about PLF's important work or even to talk about Dungeons and Dragons, though I expect a talk about D&D might actually be more interesting to at least some of the audience. Rather, my purpose is to talk about the 2 vaccine mandate cases that the Supreme Court decided back in January. And at the time, they were, as President Biden said in another contest, a big effing deal that drew a lot of reaction from people. But since then, we've kind of forgotten about them because the COVID pandemic, fortunately, has waned somewhat since then. I don't know about you, but I heard rumors that there might have been some other Supreme Court cases that were decided later that caused even more controversy. So attention shifted away from these 2 decisions. Nonetheless, the decisions, I think, were actually important, both for their immediate policy consequences and for their long-term implications for the future. And they addressed 2 COVID-19 vaccination mandates that the Biden administration issued in November of 2021 in reaction to the Delta wave of the COVID virus, which was obviously, as I'm sure most of you remember, more contagious than the original version of the virus we had had up until then. So the administration felt tremendous pressure to try to do something about this. They came up with these 2 mandates. One, the Occupational Safety and Health Administration mandate said that any employer that employed more than 100 workers, they had to require those workers either to get vaccinated or to wear masks on the job and get tested for COVID-19 regularly. There were a few exceptions, but this covered some 84 million workers, it was estimated. The second was issued by the Center for Medicare and Medicaid Services, and that required healthcare workers in facilities receiving federal Medicare and Medicaid funds to get vaccinated against the COVID, and this probably involved up to several million workers around the country. Predictably, both of these mandates were challenged in court very quickly by various groups, including red state governments, but also employer organizations and others. And both of them rapidly made their way through the lower courts and then reached the Supreme Court in January under the so-called shadow docket, where the Supreme Court can take cases on an accelerated basis before they've been fully litigated, before even they get the usual full briefing in the Supreme Court. And on January 13th of this year, the Supreme Court issued decisions in both cases by a 6-3 margin. They struck down the OSHA vaccination mandate for large employers. On the other hand, they upheld the CMS mandate for the healthcare workers. I am one of the relatively small number of people who believe that the Supreme Court got both of these cases wrong. Right. They were right, even though there were parts of the reasoning that were wrong. Most people think either both mandates should have been upheld or both should have been struck down. But I think there are important differences between the 2 cases, and the Supreme Court got the correct result in both of them, even though I also think there were significant problems with some of the court's reasoning. So we'll talk first about the OSHA case. This was the more sweeping of the 2 mandates, and OSHA was trying to use in a provision of the OSHA Act of 1970, which allows for so-called emergency test standard, that permits OSHA to regulate on an emergency basis without going through normal notice and comment procedures. They can regulate threats where employees are, quote, exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards. And this power had been used only a few times before, from 1970 to the present, and courts generally had engaged in pretty aggressive judicial review. They struck down, at least in part, 5 of the 9 previous uses of this authority. It had never been used in this kind of sweeping way, but obviously it was attractive to the Biden administration because you could do this relatively quickly, didn't have to do notice and comment, and they thought they could squeeze this into the language. But the court, with the conservative majority on the court, they weren't having this, and they concluded 2 things. The first of which is that the OSHA was wrong to think that the text of the emergency test standard, ETS, applies to this because they said the OSHA statute is not about general threats to public health. It's only limited to threats that are specific to the workplace. And obviously the COVID pandemic, as we all know, applies in society generally. It's not really specifically a workplace threat. I think there is an obvious problem with this theory that the majority endorsed, and it was pointed out in the joint dissent by the 3 liberal justices, which is that nothing in the statute actually says that ETS is limited to purely workplace threats. All that matters is that the threat in fact exists in the workplace. Under the text, nothing says that it shouldn't exist or it should exist at a lesser level somewhere else. However, I think there's an alternative pathway for striking down this mandate that the majority missed, even though in the lower court it was actually pointed out by Chief Judge Sutton of the Sixth Circuit, and that is to focus on the words grave danger. The majority recognizes as actually OSHA conceded that they had found a grave danger to exist only for unvaccinated employees, not for the vaccinated. There's an easy way to avoid the grave danger, simply get vaccinated. And it seems like if a danger can be very easily avoided, particularly at a time when vaccination was already readily available to almost anyone in the United States who wanted to get it, then it's hard to argue that there truly is a grave danger. If anything can count as a grave danger under this ETS, even if it's easy to avoid through very normal, simple, cheap precautions, then ETS would give OSHA the power to regulate almost any workplace activity of any kind, because almost anything we do, if we don't take basic minimal precautions, or if we don't exercise common sense, it could potentially be dangerous. Walking down the stairs is dangerous if you don't look where you're going. Even drinking water could be dangerous if you drink too much, or aren't aware of how you have to be careful not to choke on it or whatnot. So I think the better way to go here would have been at least to find that not that the danger has to exist only in the workplace or primarily there, but rather that it's not a grave danger if it's easily avoided at little cost. And by OSHA's own analysis, that's the kind of danger that existed here. The majority also focuses, as in West Virginia versus EPA, on the major questions doctrine. And they said, essentially, look, this is clearly a major question. It impacts over 80 million people. It could be disruptive to massive numbers of workplaces, and therefore, at the very least, the doctrine applies here, and there's at least some ambiguity over whether ETS really gives OSHA the authority to impose this mandate. And under the major questions doctrine, which says that a major delegation like this can only be done if Congress spoke very clearly, here we don't have the requisite level of clarity. And I basically agree with that. I think while there certainly are fuzzy boundaries between what's a major question and what's a minor question, and the Supreme Court hasn't done a great job of explaining the difference, here it's pretty obvious that it is a major question given the enormous scope of what OSHA was trying to do. I recognize, of course, that the major questions doctrine is itself controversial, whether it should be used or not. If you just reject the idea in general, then you would reject it here. But if you accept it, at least in some form, then I think this turns out to be a relatively easy case here, given that there's at least some ambiguity, some significant ambiguity about whether ETS really gives OSHA this authority. And I do think also that, as Justice Gorsuch points out in his concurring opinion in this case, maybe the best way to look at major questions is as a tool for enforcing non-delegation. the idea that Congress cannot delegate the legislative power to the executive branch, and in principle, we could just go straight to the constitutional issue of non-delegation and not use the major questions doctrine. But in the imperfect world that we have, courts may be unwilling to go as far as they should on that, and major questions is a way to partially enforce it, while nonetheless giving Congress the ability to these delegations if it's clear enough. So I think, therefore, the Osha case came out correctly, although in part for the wrong reasons. They, I think, missed the boat on why this is not within the scope of the ETS provision of the statute. The other vaccination mandate case is Biden versus Missouri, which, as I noted before, was a mandate that healthcare workers at facilities receiving federal Medicare and Medicaid funds must be vaccinated against the COVID. And this case here, the court actually upheld the mandate by a 5-4 vote, with the Chief Justice and Justice Kavanaugh joining the 3 liberal justices. And I think this case, while you could say this is a pro-mandate case and the other one is anti-mandate, in reality, I think the two are actually quite consistent, because here the legislative authorization for what the administration did was simply much clearer. The relevant provisions of these statutes here give CMS the power to impose conditions on grant recipients which protect, quote, the health and safety of patients. And what counts as health and safety? It can be questionable in some cases, but I think it's pretty obvious here. You have here a deadly disease that is particularly dangerous for people who are already sick, and especially for the elderly, particularly in Medicare facilities. By definition, they're protecting or they're serving patients who are older, and therefore requiring vaccination against this for healthcare staff is pretty obviously protecting health and safety, while the vaccinated can still get the disease and still spread it. The amount of spread is significantly less than for the unvaccinated. In addition, if healthcare workers are vaccinated, if they do get the disease, they're less likely to get a serious case and be away from work for a long time, and that too protects patients in pretty obvious ways. I would add that a very large and disproportionate percentage of all U.S. fatalities from COVID were in fact in healthcare and long-term care facilities, nursing homes and the like. So it's pretty obvious here that you do have an issue of health and safety, though I readily grant there might be some other cases where things are fuzzy, and maybe there would be reason to question some other kinds of mandates which could come down. In his dissent, Justice Thomas said, well, maybe these health and safety provisions, they only relate to administrative matters like organizing workplace schedules and the like, and not to substantive protections of health and safety like vaccination mandates. I talk about this a little bit in the article. I just don't think there's anything to support this in the statute, and the idea of this kind of distinction just doesn't make a lot of sense. So although I think the court got this right, I worry, however, that they missed some issues that they should have addressed. In particular, this is a conditional spending case, and the Supreme Court and lower courts have a lot of jurisprudence on the issue of when the executive can attach conditions to federal grants. In particular, the conditions must be authorized by something that's unambiguously clear on the face of the statute. This issue was raised in some of the lower court litigation that this case reviewed, and it was mentioned in the briefs, totally ignored by both the majority and the dissenters. Similarly, we have the Federalism clear statement canon, which says that when Congress enacts legislation that upsets the usual balance between federal and state power, they have to speak very clearly, indicate that they're doing this. Public health and vaccination usually is a matter for the states historically in our system, not for the federal government. The Supreme Court blew past this issue as well. It is briefly raised in Justice Thomas's dissent. The majority doesn't bother to respond to it. In my view, if you take these things into account, the case should still come out the same way because I think vaccination against a deadly disease in healthcare facilities pretty clearly is unambiguous and falls within the health and safety requirement. And I think that would deal with these issues on both the spending clause and the clear statement canon, but the court should have addressed these matters and they didn't bother, and that's unfortunate. So, and I know I have only a minute or two left. I'd just like to briefly note the broader implications of these two cases. I think the Osha case strengthens the major question doctrine and indirectly the non-delegation doctrine, and it does so in conjunction with other cases like West Virginia versus EPA and also the eviction moratorium case. The case also makes clear that emergency powers will be subject to serious judicial review, and that's important, that just because you're using emergency power doesn't mean you get a free pass for the courts. The COVID emergency hopefully is ending, but there will be others in the future, and this is an important issue. Obviously, this decision was also significant because it did strike down a big sweeping mandate. Interesting, the majority did leave room explicitly for narrower workplace vaccination mandates in places where there's a special risk, where the COVID risk is higher in the workplace than elsewhere. But for whatever reason, the Biden administration did not take them up on this and didn't try to craft a narrower rule. One would have thought that if this was as important as the administration claimed, they might have at least tried to do that. Biden versus Missouri is also a significant case. It makes clear that you can use the CMS power on the conditional spending to require vaccination mandates and not just purely administrative rules. There are other diseases going around where there might be a case for requiring vaccination for healthcare workers, maybe even the monkeypox, which we've been talking about this summer. That might be an example of that. If not, there are likely other situations. So I think the implications here are significant, and the court got both cases right, but they also clearly flubbed important points of the analysis in both cases, and I do think that strengthens or bolsters some of the criticism that the court's use of the shadow docket has been subject to, and that one possible reason why they flubbed these things is that they were working on this really accelerated schedule. They were almost like the students who, the night before an exam, they do all their studying, or they finish the paper in the wee hours of the morning right before it's due. I'm sure none of you would make mistakes as a result of this, but some students do, and the Supreme Court justices may be the same way. So I don't know that there's a good solution to this. Sometimes you do have to hear cases on an accelerated basis, but this is part of the cost of doing so. So more could be said about these cases, but for now I conclude and I look forward to the discussion and questions. Thank you.
Thank you. Thank you so much, Ilya. That was great. Our third and final speaker, Jennifer Mascot, is an assistant professor of law and assistant professor of law at the Antonin Scalia Law School and co-executive director of the C. Borden Gray Center for the Study of the Administrative State. These titles are a mouthful. Jennifer has one of those resumes that depresses me with feeling, it just overwhelms me with feelings of inadequacy. She's accomplished so much. She has served at the highest levels of government across all three branches. I'll say this, in the course of researching this introduction, someone whose opinion I esteem very much said that Jennifer is going to become the greatest, most important voice in administrative law of our generation, conservative voice. And that was profound criticism. I'm sorry, profound, good gracious. I'm sorry. That was a profound compliment. It came from someone whose opinion really matters. But I'll note this as well. Jennifer is undoubtedly the only professor in the country who teaches not one course with Supreme Court justice, but 2 courses with Supreme Court justices annually, Justices Kavanaugh and Thomas. So that's pretty neat. That's quite a feather in her cap. Without further ado, Professor Mascot will present her article on Egbert v. Boole.
All right, thank you so much for having me. Good morning to everybody. And actually, the last time that I was here speaking at the Constitution Day event for Cato was in 2018, right in the middle of the confirmation proceedings for Justice Kavanaugh. And I think the theme of this particular panel, constitutional accountability and structure, is quite significant because it's been important to the court this past term. I think it'll be important many years to come. And I think with the advent of Justice Kavanaugh and now Justice Barrett to the bench and all the other changes, including Justice Breyer's retirement and Justice Jackson's advent to the bench, the kinds of opinions that we're going to be seeing in these areas are going to be changing, and the court's going to be more forward-leaning on accountability and structure. So my co-panelists have been able to talk about very grand opinions from the term, West Virginia versus EPA, and the emergency dockets cases at the very beginning of the year. My case in comparison is quite modest, Egbert versus Boulay. I think everybody could have easily predicted the way that the court was going to rule in this case, and I should thank Cato for even having me here because I probably am unusual in that I suggested and pitched the idea of writing an article on Egbert versus Boulay to the Cato Supreme Court review folks, and they were generous to let me do that relatively last minute, and also because I filed an amicus brief in the case on the opposite side that I think Cato's position would have been in the case. But I think in spirit and in principle, we hold a similar view on these issues. So I do think a major theme, and I think Egbert versus Boulay ties into what I see as a major theme of accountability from this past term, which picks up the theme of who decides, which institution in our government is to decide important questions. Chief Judge Jeff Sutton, I think, first coined the phrase or brought it more to the forefront in his book, Who Decides, dealing with the axis of federal versus state power. But the court this past term, I think, spent an awful lot of time thinking about executive branch versus the courts versus Congress. And obviously, the first two presentations today dealt with the axis a lot of Congress. What is it authorizing the executive branch or administrative agencies to do? Egbert versus Boulay touches more on Congress versus the courts. It just dealt with a relatively modest Bivens case. Bivens, as you all know, is the doctrine that essentially from the text of the Constitution itself, if one is bringing a constitutional challenge against a federal officer, that the Constitution itself needs to contain a remedy, and therefore monetary damages remedies can be inferred directly from the text of the Constitution. This was somewhat a groundbreaking idea in 1971, originated in the Supreme Court, I think, itself, but where I think I and Cato agree is that historically the theme of accountability was really important, and the mechanism of being able to sue officers actually was seen as an important mechanism for accountability. So just to sort of back up, often when the court is looking at cases involving constitutional accountability and structure, at least over the last decade, it's looking at accountability within the governmental structure itself. So who is supposed to appoint an officer? Who is supposed to remove an officer? Can Congress limit removal protections? We didn't really have cases like that this last term. We had this case, Egbert versus Boulay, which is looking at can the public or mechanisms outside of the government help to keep accountability for government officers? So obviously elections are an important mechanism for accountability. Potentially impeachment and conviction, although if you look historically, I believe, impeachment has been successful fewer than 24 times. Conviction, obviously, much fewer. It's very hard, even for Congress, to successfully impeach and convict a president who is charged with attacking the co-equal branch physically. And so perhaps that's not as effective of a remedy as the framers of the founding generation would have thought. There was a lot of evidence at the time of ratification, however, that the folks who were signing onto the Constitution, approving its ratification, thought that the mechanism of state common law liability for federal officer misdeeds, or just general officer misdeeds, was going to remain in place. And a number of scholars recently have written about how these common law actions were to work. Professor Bode has written some, Professor Jerry Mashal, Professor Amar has touched on this in his scholarship, and there was definitely an idea that folks were going to be accountable or be able to be sued for misdeeds, but it was going to arise in a way that's quite distinct, I think, or at least this was what my brief argued, from the Bivens relief that the court tried to derive from the Constitution in the 1970s. Essentially, somebody would bring a common law action, maybe for trespass, that kind of thing, and a federal officer would claim lawfulness of the search or the trespass in defense, and then the question would come up whether that could come up in the course of arguing the defense, whether it was a constitutionally valid action or not. Unfortunately, over the years, depending on your perspective, Congress has actually taken a lot of action, most significantly recently in the Westfall Act, to essentially preempt the ability to be able to bring these kinds of actions against officers. And so there's really a great need, if one believes in this kind of accountability being necessary, perhaps for the Supreme Court to be able to approve or grant Bivens relief. But going to the theme of who decides, Congress taking this liability away, perhaps the court should not be able to grant it back, and that's certainly the current Supreme Court's position. So I think Egbert versus Boulay in the end was a relatively modest holding because the litigants, Williams and Connolly, represented by Sarah Harris, had first asked the court to take up the issue of the constitutionality of Bivens actions. Clearly the court's been uneasy with it. Justice Thomas mentions ultimately his majority opinion in the case that on 11 occasions in the past 40 years the court has beaten back extensions of Bivens relief, but the court didn't want to bite on that question, maybe because it didn't think it was necessary in this case, maybe because it had a sense that it was going to be reversing or overturning precedent in other more pressing areas and didn't want to do too much in one term. So the case ends up being relatively modest. It's an interesting factual pattern, though. A gentleman has an inn near the U.S.-Canadian border. He's known to smuggle folks unlawfully entering the country, drugs, using his inn. He's unabashed about it. He drives around with a license plate with the word smuggler on the back of it. So he, perhaps unsurprisingly, is detained or searched by border agents who he accuses of slamming him against his SUV and then retaliating when he reports this. And so he's trying to get administrative relief. It doesn't work. He brings a Bivens claim, and this case makes its way to the Supreme Court simply because the Ninth Circuit, as it has a tendency to do, sort of blows by the court's most recent approach to Bivens claims and grants his Fourth Amendment excessive force claim for relief and First Amendment retaliation claim. And basically, on the denial of the First Amendment retaliation claim, all of the justices were unified. 5 justices were in majority with Justice Thomas saying the Fourth Amendment claim even was an unlawful extension of Bivens because it came up in a new factual scenario. And then Justice Gorsuch is in the middle, concurring but saying we should have given more reconsideration to Bivens. And then the three justices are in dissent on the denial of the Fourth Amendment claim. But I think this case sort of illustrates that Bivens is just not in the foreseeable future going to obviously be a form of relief for litigants. Congress probably, perhaps, will have to or should, to the extent that folks think that not only were claims against officers constitutionally, for monetary damages constitutionally permissible, but some think constitutionally required because of the need for accountability and the previous history. Congress perhaps will need to or should be a place to revisit this. Certainly, I think the court has demonstrated that its doors are going to be closed to this kind of relief in the future. So if this is not going to be an avenue for reconsideration of constitutional accountability in the court moving forward, how will accountability and structure continue to arise as themes? I think the current court is going to continue to take more and more cases with kind of the more grand Article II related constitutional accountability themes. I think it's going to be cases that look more similar to the ones that Professor Adler and Professor Sohman talked about today. I think perhaps in the near term we're going to see even more reconsideration of appointments of removable C. I mean, the court has 2 cases this year dealing with administrative agencies, Axon and Cochran, but they're dealing with jurisdictional components. They're not probably going to get to the core of how administrative actors should be kept accountable by their supervisors or by the president through removal. But there are cases percolating in the lower courts that might press this modern court or this current court to make some more far-reaching decisions. We'll see. I mean, I think the Chief Justice has been pretty capable of being able to stay within past precedent and try to reach issue rulings in a lot of these constitutional accountability cases that are relatively narrow, leaving big precedents like Humphrey's executor on the books. But we'll see what happens. There's obviously the Jarkissi versus SEC case in the Fifth Circuit, making some delegation and administrative adjudication related claims. You all can tell me if this is not right. As of last Friday, the petition for rehearing had not been acted on. I don't know if it's been acted on yet. So that may have a rehearing component before it goes up to the Supreme Court. But that could actually challenge or bring a merits challenge to the removal protections for SEC commissioners, and then even the amount of discretion, perhaps, that commissioners have in terms of bringing enforcement proceedings in-house versus into court. Another case that I think that's percolating that could be interesting, we'll see how it goes, was just brought fairly recently. Walmart has challenged, or I'm sorry, the FTC brought a complaint against Walmart, and Walmart, in its motion to dismiss the complaint, has raised some constitutional arguments that have at least been risen to the level of interest of the Wall Street Journal, which editorialized on the case last week, and it has some very high-profile litigants, and so I can tell you sort of briefly what the arguments and claims are. It's got the former head of the Civil Appellate Division for the Trump administration, and then Hashmupan, who's also was a Ludwig Scalia clerk, teamed up with Ramon Martinez, a former Assistant Solicitor General, Kavanaugh and Roberts clerk, who's at Latham, together with Walmart on this motion to dismiss. So it's a lot of big names. So I would imagine the case is going to move forward. But the claim there is actually trying to distinguish Humphrey's executor completely from the modern FTC and say that Humphrey's executor really does not govern the removal protections of the current FTC, because what the FTC is doing now is much more executive, according to the court's recent decisions in Saylor Law or Free Enterprise Fund, and therefore the preservation of the removal protections for quasi-legislative and quasi-judicial action in the 1930s era FTC no longer can be reconciled with what the agency's doing. So we'll see. The FTC's approach so far has been to kind of oppose amicus support in the case, and I don't know how much firepower the case will have in the district court, which obviously is bound by precedent. But I think in the years to come, in these areas of structure within the executive branch and between Congress and executive, we'll see a lot more play, even though as of this last term, the court has shown a lot more hesitance in re-evaluating the balance of power between Congress and the court itself.
Excellent. Thank you very much, Jennifer. A round of applause. That was incredible. A car alarm goes off halfway through, and you maintained your composure and even delivery. It was very impressive. I will exercise, well, first I'll remind online viewers, please send in your questions, and those get beamed to me right here. Before we open up questions to the audience and people online, I will exercise the moderator's privilege. Jennifer, so the Bivens, gutted. Federal Tort Claims Act, gutted. And the Westfall Act precludes state torts, which, as I learned from your article, that was the remedy at the founding era. Is it only Congress that can go about limiting the Westfall Act? And I don't know here, but are there any arguments to be made that this utter absence of access to the courts to vindicate one's rights or to pursue a tort have been, all these avenues have been effectively closed off? I mean, that is to say, are there constitutional arguments to be made against the Westfall Act itself, or are the courts now out of it, and it truly is up to Congress to?
Well, sure. I mean, Congress could obviously revisit the Westfall. I guess I should have, sure, I think somebody could perhaps bring a challenge to the constitutionality of, if there's, there hasn't been a strategy with that yet, but sure. That would obviously be another way to go about it. Whether the court would, agree or how that would be framed, I think is a good. I think it's a good question, but sure, sure, if they're not going to grant relief through Bivens, and one thinks it's constitutionally required, but of course you would have to make the showing, which I'm not sure. I think a lot of scholarship has shown the historical practice of the lawsuits existing. I think folks are just starting to make the arguments that the relief is constitutionally required. There are folks on many points along the spectrum, I think, of scholarship who might agree, even the Center for the Study of Constitutional Originalism out in San Diego, Michael Ramsey, for example, has written a little bit about this. But I think probably there would need to be more work done on the litigation side and study to make that kind of strong claim.
All right, interesting. Thank you for that answer. I'll offer the opportunity to panelists, any cross questions you have for one another. Along these lines, I guess I'll throw in a question. Ilya, you had mentioned that one of the vaccine mandate, NFIB, presents this obvious major question. Could you speak to Jonathan's criticism of the major questions doctrine that discerning major from minor is a real methodological killer?
So it's a problem, but the law is full of doctrines where the boundaries are fuzzy. The boundary between a reasonable search and seizure and an unreasonable one, or the many areas of law where something like reasonability or whatnot is a standard. So while I think the court can and should do more to explicate where this boundary between the major and the minor is, I also think there are many cases where it's pretty clear whether it's major or not. I think the Osha vaccine mandate case is pretty clear, an example where it's major. The nationwide eviction moratorium case decided last fall also is pretty clear that it was major. On the other hand, there's a vast range of government regulations and other kinds of laws where it's pretty obviously minor. So I recognize there's a long-standing debate between people who say everything in the law, or as much as possible, should be governed by bright-line rules, versus people who say standards are more acceptable. But even the biggest champions of bright-line rules, like the late Justice Scalia, still accepted standards in a wide range of situations. And it may be, at least for the moment, that having a standard is the best we can do in this area. I think over time, maybe the court should more fully revive and explicate the non-delegation doctrine, and more of these kinds of issues could be dealt with directly under non-delegation as opposed to more indirectly through major questions. But here, as in a lot of places, the best should not be the enemy of the good. So we have an imperfect and flawed and sometimes fuzzy major questions doctrine, and that can be worked on and improved, but it's still better than having an anything goes rule where there's no limit whatsoever to delegations, and where even relatively vague statutes can be read to delegate vast amounts of power to the executive's sole discretion. As I discussed in my article, even if you trust the Biden administration with this kind of discretion, do you trust Donald Trump or whoever the next Republican president might be? And if you trust the Republicans, do you trust the Democrats? I think the answer to both of these questions for many people is going to be no. And that's one reason why some sort of major questions doctrine is desirable, and it shouldn't just be simply left to the political process.
Jonathan?
Yeah, so let me, I guess, just kind of clarify where I think Ilya and I agree and disagree. First of all, I agree with him on both the COVID cases and that the court reached the right outcome in both of them. I also agree with him that the Osha case in particular the opinion was not as strong as it could have been, among other things, claiming that it was about workplace safety due to the threat of a disease, and then defining the rules applicability based on the number of people on the payroll. That should have been recognized as arbitrary and capricious. You don't even need to get to the larger questions. There was not even an effort to even say how many people are in the same building, let alone ventilation within the same workspace. Anything that would correlate with actual exposure. So a 99-person firm where everyone's in a single room, cheek to jowl, not covered. A firm of 101 people where folks work remotely 90% of the time, or because of time shifting are rarely in the same place together would be covered. I mean, it's just not a serious effort to use the authority that OSHA was actually given to address the problem that OSHA was given, the sort of problem that OSHA was given that authority to address. On the major question thing, there are bad criticisms of the major questions doctrine in these opinions that I think Ilya and I both reject. One of the bad criticisms is the idea that it was just made up in the last year, or even the last 10 years, or even in FDA versus Brown and Williamson. That's simply not true. The idea, while the court had not used the phrase major questions doctrine in a majority opinion, the idea had been well grounded in prior cases, particularly in the administrative law context, and going back even before FDA versus Brown and Williamson. So if the concern is, the court should just not be inventing new doctrines, that's not a fair criticism of either of these cases, because the court had been doing this in a range of cases and in ways that are particularly applicable to both of these cases. That is, taking a regulatory structure and repurposing it or refashioning it. You see that in Scalia's opinion in the MCI case in the 90s, for example. My concern is more that there's no principled reason why we want to have this on-off switch between major and minor delegations of power. And in fact, trying to make that somewhat rule-like, I think, really risks a lot of arbitrary results. Something that's actually more standard-like and more kind of a gradient that just recognizes the bigger the claimed power, the more robust we would expect the evidence that that power was delegated to exist. Again, it's the sort of thing that used to be understood in statutory interpretation, the sort of thing that has roots in basic agency law. It produces a standard, but it produces a sort of inquiry that we can expect courts to do reasonably well. Expecting courts to do the sort of major questions doctrine that we see in these two cases, where it's this kind of on-off switch at the very beginning of the inquiry. Do you go in the major questions box where the agency is almost certain to lose, or do you go in the not major questions box where we just do the normal statutory interpretation? Front-loading that sort of inquiry creates really bad incentives for litigants, as we're already seeing in briefs that are filed in a range of cases now, and gives lower courts a task that just isn't to their comparative advantage of, well, is this a big enough, is this expensive enough? And so, from the standpoint of courts have been doing this major questions thing, and so it's obviously something that should be part of the mix, I get that. I think unlike lower courts, and I agree with Ilya that the Sixth Circuit, the Sutton opinion below, the dissent below, was a much better opinion than the Supreme Court's opinion. Lower courts clearly have to make this part of the mix. The Supreme Court, though, had the opportunity to clarify, refine, and ground the doctrine in a more principled way, and it missed that opportunity. And that's the sort of thing you can criticize the Supreme Court for, even if it's not fair to criticize a lower court for that. And they really missed that opportunity, and I think it's going to make things harder for lower courts.
Just very quickly, I don't necessarily disagree with most of what Jonathan said. I would merely note, though, that if you replace the binary standard with a continuum, as I think Jonathan would like us to do, if I understand him correctly, you would perhaps get more fuzziness rather than less, because there would be questions of, how do we figure out where on the continuum we are? At what rate does the sort of degree of difficulty increase for the government, and so on? So that would still be a standard-based approach, not a rule-based approach, and it would still create fuzziness. Whether it would be on balance better than a binary approach, I'm just not sure. I would want to see, if the Supreme Court were to adopt that approach, I would be interested to see how lower courts would actually try to apply it to cases.
All right, some good back and forth. All right, so we have 6 minutes left. Any audience? Do we have questions from the audience? Please, yes, sir, right there. And I think they're bringing a microphone to you, my friend.
So to your question to Professor Mascot about the Westfall Act, I'm Akhil Amar. Here's actually what my answer would be, and it puts Bivens in a larger context. And I think folks at Cato should like this. So let's see if we can get some consensus. First principles. For every right, there should be a remedy. That's Blackstone and Marbury. Second premise, Constitution recognizes rights against the government itself, not just against government officers, but against the government itself. So there should be remedies against the government itself. That was part of the driving force of Bivens. Bivens shouldn't be cut back, it should be expanded. Now, if the Westfall Act is cutting off all the other remedies, it's not providing full remedies itself, there's a problem there, you see. And that's the constitutional argument. Now, Bivens itself had 3 tributaries, and one has dried up, but the other 2 remain quite robust. One thing that Bivens said, and I commend to all of you, Justice Harlan's concurring opinion, Bivens, where he actually said, hey, I changed my mind on this. And when a justice says that, especially someone as thoughtful as Harlan, we should pay attention to it. Here were the 3 tributaries. 1, we have implied causes of action for statutes. Why not for the Constitution, which, because it doesn't partake of the prolixity of a legal code, isn't going to always tell you who can sue for what and how. Well, implied causes of action for statutes are dried up. But the argument was, if you do it for statutes, a fortiori for the Constitution. Okay, that tributary is dried up. But here are the other 2. If you can have direct causes of action against the government itself under Ex parte Young, even if there's no common law tort, because merely initiating a prosecution isn't a common law tort under unconstitutional statute. If you can have injunctive relief under the Constitution, why not for damages? And that's still robust, although the SB 8 Act, SB 8 controversy kind of complicates that a little bit. But here's the other one unique to the Fourth Amendment. The Fourth Amendment now clearly goes beyond state common law trespass. In the 1960s, that was the Katz case. Even though there's not a trespass, there might be a Fourth Amendment violation if there's surveillance, for example. That's been built on. Kylo by Justice Scalia, pointing a ray gun at a house for thermal imaging. The GPS case of Jones, phone searches cases like California versus Riley. So if the Fourth Amendment right goes beyond mere state law trespass, and it does today, even if it didn't at the founding, Fourth Amendment remedies should likewise go beyond mere trespass. And if state law isn't going to do it, we should actually have a direct remedy under the Constitution. But at a minimum, when the Westfall Act takes away traditional state remedies and doesn't give you alternative, it's violating the Blackstone idea, the Marbury idea. You see, that's the argument. And when also and this is another Cato idea, I think we shouldn't have these broad qualified immunities and all the rest. We should have full remedies for constitutional rights. I think that's something that should unite left and right, especially those who are interested in limited government. So let's see if we can make it happen.
That's music to my ears. Jennifer, do you have anything to say to that? No worries if not.
Oh, no, I really appreciate Professor Amar weighing in. I think that's great. And of course, qualified immunity is obviously a very robust area of scholarship. And I also think Professor Amar speaking up and walking through that goes to a point I was making it at a conference that Jonathan and I were at last Friday, which is that this is like just a litigation point. I'm a humble law professor, so maybe don't take my word for it. But to the extent that folks here with groups and filing litigation, often I think groups like Cato and others are filing just for themselves. I think actually it seems like the court is, or courts are interested in individual law professor and other clients' arguments, and so to the extent that someone like a Professor Amar or others writing in these areas you could have as your client on your brief, I think could be effective in getting the courts to take a closer look, because academic arguments, particularly by sole professors making an argument in their own name for which they have to take complete blame or credit for its validity, I think is a lot more compelling, dare I say it, than just another, one of the 50 or 100 interest group briefs that the group filed that particular year. So,
nice.
Excellent.
Excellent. Well, we got 23 seconds left. Does anyone have a very, very, very brief question? Devin, can you do it? Can you make a 20-second question?
So for the So for the Federal Tort Claims Act, if that remedy is available, do you think that is sufficient, or should this unconstitution of the Westfall Act still apply?
I mean, no, I think to the extent that one believes that there needs to be, monetary damages relief or should be available, and that one thinks courts would sign on to or are comfortable with the broader scope of Fourth Amendment rights, that Westfall Act would be still, its constitutionality would still be relevant. I mean, of course, Professor Amar's arguments, it seems to me, do partly, not completely, but partly hinge on the court accepting or being comfortable with the more expansive scope of the Fourth Amendment. Obviously, I think some of the same justices who are peeling back Bivens are going to be uneasy about where we are with Fourth Amendment jurisprudence, so there's a number of, hills to climb there, but no, I think the Westfall Act, re-examining it is of utmost importance in this area.
Here again. All right, well, please, let's give a round of applause to our panelists. That was great stuff. So this concludes the first part of our program. The next part is lunch, and it's right out there. And we will reconvene at 1 p.m. right here.
just wanna move me with your loving.
All right, we're going to keep this conference running like a well-oiled machine, start right back up at 1. My name is Thomas Berry. I'm a research fellow here at the Cato Institute's Levy Center for Constitutional Studies, and I'm managing editor of the Cato Supreme Court Review, where I had a front row seat to just how insanely hard Trevor has to work to make this all happen, how insanely cooperative and timely and patient our authors are with us, and have to be to make this happen. And so my thanks to all of them, and to everyone Trevor named and thanked in the first panel. We almost always have a First Amendment panel at Constitution Day. It's smack dab in the middle of our wheelhouse here at the Levy Center, and usually there's no shortage of First Amendment cases at the High Court. This year was unusually light in one respect, as there was really, I believe, just one decision on core First Amendment speech, and you'll hear Professor Armijo speak about that. So we made the theme of this panel a little broader. We have one case on First Amendment speech, one case on First Amendment religion clauses, and 2 cases on the state secrets doctrine, which, although not directly governed by the First Amendment, arguably touches on many of the same values as the freedom of speech and of the press, namely the values of transparency and the open marketplace of ideas. On First Amendment speech, you'll hear about a case that might at first seem to concern a niche topic, municipal sign codes, but as you'll hear, the case actually concerned weighty questions with implications extending far beyond just signs, questions concerning when the government can discriminate against a speaker based on what the speaker says. Next, you'll hear about 2 cases concerning the state secrets doctrine, under which the government has claimed the right to withhold evidence and sometimes even dismiss lawsuits entirely based on claims that releasing the evidence could harm national security interests. How deferential should courts be to such claims? And when should courts themselves insist on reviewing the secrets in private to evaluate the government's claims? And finally, you'll hear about a case concerning either one or both of the religion clauses of the First Amendment, depending on which side of the case you're on. If a state offers a voucher-type program for public funds to go to private schools, can the state exclude religious schools from that program on the theory that public funding raises establishment of religion concerns? Or do such programs raise no establishment concerns, meaning that the denial of funds constitutes a burden on the free exercise of religion? And does it make any difference whether the funds go to religious education as opposed to merely religious affiliation? Here to discuss these cases, we have 3 distinguished scholars, and as always, we abbreviate the intros up here, leaving out their long list of accolades or accomplishments, publications, titles of nobility. You have more time to hear from the panelists themselves, and you can read their full bios in the back of the review, which you all have. I'd like to remind our audience online, you can submit questions on our event webpage at Cato's website, or in the comments on Zoom, Facebook, or YouTube, or on Twitter using the hashtag CatoScotus, CatoScotus. So first up, we have Enrique Armijo. He is a professor at Elon University School of Law, an affiliated fellow at Yale Law School Information Society Project, and a faculty affiliate at UNC Chapel Hill Center for Information Technology and Public Life, and he will be speaking on the City of Austin science case.
Well, thank you all for coming. Thanks to Cato and Tommy and Trevor. As Tommy said, I'll be talking about sign ordinances. Sign ordinance cases are really the perfect right after lunch topic. But as Tommy also said, part of my goal in this talk is to kind of try to persuade you that these cases are a lot more important than their narrow application that I'll be talking about. And we also, in the interest of keeping the blood flowing, have some visual aids, and once I kind of get into the talk, we're all going to get to play sign ordinance enforcer. So you have that to look forward to. I really have, I've got it on the monitor, but not on the screen. I've got, while they're working out the PowerPoint, I've got really 4 goals for the talk. The first is to talk about kind of this changing role that government purpose has played in content discrimination doctrine, how a 2015 case called Reed versus Town of Gilbert kind of resolved that and rejected analysis of government purpose in favor of a facial test for content discrimination doctrine. What the court decided this past term in the case that Tommy said I'll be talking about, Austin versus Reagan National Advertising, why that was a significant departure from the rule in Reed. And then if I have time, I'll talk about why Reed was actually the better First Amendment rule, at least in my view. So when I talk about content discrimination doctrine, more commonly referred to as content neutrality doctrine, what that basically stands for is the proposition that government cannot treat speech differently based on the content of that speech. I think those of us who went to law school remember that doctrine. If a court finds that that is what has happened, so if the speech has been treated differently because of its content, then the court, in reviewing that under the First Amendment, has to apply strict scrutiny. If that is not what has happened, the treatment gets at most intermediate scrutiny. And this rule goes back 50 years to a case called Police Department versus Mosley in 1972. Justice Marshall says that there's a picketing ordinance that a protester is arrested under, and Justice Marshall says that that ordinance discriminated on the basis of content because it made labor picketing in front of a school illegal, but it created an exception for labor picketing, picketing that was part of a labor dispute. So generally, picketing bad, labor picketing okay. Justice Marshall in 1972 says that does not survive First Amendment review. So in theory, as Mosley sets out, this is a facial inquiry, right? It looks to, in deciding whether or not content is being treated differently, it looks to the text of the statute, so a facial test. But as time goes on, in these content discrimination doctrine cases, these courts post-Mosley are using reviews of the government's underlying purpose or motivation to answer the content discrimination question. So how this shakes out in the lower court is that lower courts are saying that governments can refer to content in their statutes so long as that reference is not to express disagreement or disapproval of the content that the government is referring to in the statute. And this leads to a lot of speech-averse results, right? You have cases upholding statutes that refer explicitly to sexually explicit speech in the form of the much maligned secondary effects doctrine. You have panhandling bans being upheld under the First Amendment because you have courts saying, well, this is a panhandling ban, but it's not being passed because the government disagrees with panhandling, and that's not content discrimination. So what this version of the content discrimination doctrine really boiled down to is a search for evidence of discriminatory government purpose or evidence of discriminatory government motive. But what that actually means in application is confirmation of the absence of government motive to discriminate on the basis of content. Because you're almost never going to find a discriminatory motive on part of the government. And this is for several reasons, right? Justice Easterbrook said a long time ago, the legislator is a they, not an it. Justice Black in 1971 says that the legislature can always change its motivation, right? It can always say that in order to avoid judicial review, it can actually give a benign purpose to justify a reference to content. So if there's no evidence of discriminatory motive, then the government's going to win, at least on the First Amendment, or at least avoid strict scrutiny. And this is why I say, and I talk a lot about this in the paper, the original sin here was probably in calling the doctrine content neutrality, right? Because when you make the doctrine about neutrality, then judicial review looks for motivation. And as I just said, there's never discriminatory motivation. So unless you have something that rises to the level of animus, if the neutrality balance is met by no references or no discussion about negative motivation with respect to content, the courts give the government the benefit of the doubt. So that brings us to, I see him there. Oh, sorry. I guess you can look over there. That is Pastor Clyde Reed. So, Pastor Clyde Reed is from the Good News Community Church. He has a church, but no building. And the book of Matthew teaches us, right, as you see there, the quote, you don't need to have a building to have a church, but it's a lot harder to have church if you don't have a building. So what Pastor Clyde Reed does is puts up signs, and all of us have seen these signs, right? Signs that tell people who are driving around the streets of Gilbert, Arizona, where his church is going to meet. Under the relevant sign ordinance in Gilbert, Arizona, where the Good News Community Church is located, that is a sign for a, quote, temporary event. And what that means is that Pastor Reed can have his sign up 12 hours before church, 1 hour after church, then he has to take it down. Other signs under this ordinance are not restricted in the same way. Pastor Clyde Reed says this discriminates on the basis of content. The Ninth Circuit says this is totally fine. Why does the Ninth Circuit say this is totally fine? Because, as I said, under the purpose-based test that the lower courts were applying, the Ninth Circuit says there's no evidence that the town of Gilbert, Arizona did this because they didn't like the content of temporary purpose signs. There's no evidence of negative purpose with respect to a particular kind of content. No First Amendment problem. So you can treat these signs less favorably as long as you don't have a purpose in doing so that expresses disapproval or dislike of the content of the sign. Clyde Reed goes to the Supreme Court in 2015, and the Supreme Court reverses the Ninth Circuit. So this is what the court says, and this is an opinion by Justice Thomas. Justice Thomas says, sorry, that one's there you go. So Justice Thomas says, content discrimination doctrine is a facial inquiry. You look at the text of the statute. If the text of the statute refers to content, then the statute is content-based and strict scrutiny applies. If it doesn't refer to content, if the text of the statute does not refer to content, then you ask the question, does the statute have a content-based purpose? And if the answer to that question is yes, then strict scrutiny can still apply. So what's happening here is that a content-based purpose can doom the law, right, under the First Amendment, but it can't save the law under the First Amendment, as was happening in the lower courts. So Justice Thomas cleans this up in Reed versus Town of Gilbert in 2015. There was a lot of consternation about this decision. If you want to hear about it, you can read an article that I wrote called Reed versus Town of Gilbert, Relax Everybody. So obviously by the name of the title, I thought there was too much consternation about it. But basically, the court is clarifying and cabining the role of government purpose in content discrimination doctrine. Fast forward 7 years later. So I'm not going to be able to show you the signs, but I think I can explain them to you. The city of Austin has an ordinance that says a sign distinguishes between on-premises and off-premises signs. An on-premises sign can be built or modified. An off-premises sign cannot. So this is challenged in the Supreme Court as content-based, right? So that's the text of the statute. The Austin Ordinance says that, as I just said, if it refers to if the sign refers to something that takes place on the premises, it can be built or modified. If it does not refer to something that's on the premises, it cannot be modified. So based on Justice Thomas's hypothetical at oral argument, he says, I think Justice Thomas likes barbecue, or at least one time liked barbecue, and he says, what about a sign that says, eat at Franklin's? So some of us know about, some of us may even stand in line for hours at Franklin Barbecue, right? And now I think this is reading all the times that I click this and panic, so sorry about this not being synced up with what I'm saying. But so assume that the sign says, eat at Franklin's. That's an on-premises sign. No First Amendment problem. That sign can be changed or modified. Eat at Franklin's, that sign's perfectly okay. But assume, as you see on the slide now, that the owner of Franklin's puts up a sign that says, Texas, keep your laws off my body. That is not an on-premises sign, right? That sign can't go up or modified because it's off-premises under the statute. Third hypothetical, assume that the owner of Franklin's Barbecue is a strong believer in the community of meat smokers. Franklin's Barbecue runs out of barbecue really quickly, so he puts up a sign that says, sorry, I'm out of barbecue, go to Black's instead, right? That's an off-premises sign because it does not advertise a service that is at that location, that sign can't go up. One more example, Stubbs. Again, if you know anything about Texas barbecue, all sounds familiar to you. Let's say the owner of Stubbs puts up a sign, in addition to his sign advertising Stubbs, that also says, "Be saved." Well, that seems to be an off-premises sign, but you might know, Stubbs has a gospel brunch on Sundays. So the enforcer of the statute has to say, does that sign advertise something that happens on the premises? And the answer is, I don't know, right? It's up to the ordinance enforcer. And I argue in the paper that this is what the content discrimination doctrine is really about. And this is what Reed got right. So what the content discrimination doctrine is most worried about is discretionary charging by the enforcer. You don't want references to content in statutes that permit the enforcer to then discriminate against speech that the enforcer dislikes. That's what Reed got right. So the City of Austin ordinance is challenged in the Supreme Court by a group of people who, actually it was a billboard company. So in the City of Austin, the billboard company couldn't modify its billboards, couldn't digitize them. They say this violates the First Amendment. And the Fifth Circuit comes to the obvious conclusion. If you have to read the sign, that violates Reed. The sign under the old test under Reed refers to content. That's a content-based sign. That gets strict scrutiny. That's under the First Amendment. The Supreme Court says that the Austin ordinance is fine and it upholds Reed. So how in the world did this happen? How can you have a content discrimination rule that permits Austin to have this ordinance? So here is what they do. They put a gloss on Reed that says, this is the doctrinal answer, and then I'll give you the real answer in a second. So there's always a doctrinal answer and a real answer. So the doctrinal answer says, the court says, what we really do in Reed is ask whether or not the law refers to substantive categories of content. The town of Gilbert sign ordinance said yes. You had temporary signs, you had political signs, you had commercial signs. If the answer to that question is yes, then we apply the rule in Reed, right? Content-based, apply strict scrutiny. But the court says under the Austin case, there also can be references to content in text that do not refer to substantive categories of content, that are just general references to content, such as the one in the Austin ordinance. Those are now okay, especially if they have a content neutral purpose. So I say in the article that what used to be a two-step under Reed is now a backwards tango ocho, right? This is incredibly difficult to apply, but more importantly, what it does is it increases the ability of the government to interfere with speech. It actually encourages the government to speak generally when it's referring to speech, to avoid the Reed rule, but so long as what the court says, so long as what the court calls the ordinance has a content agnostic purpose, then the First Amendment is perfectly fine. And what I say in the paper is that this is a reintroduction of analysis of government purpose in the content discrimination doctrine, and I think that's a real problem, and I look forward to your questions and comments. Thanks.
All right. Next we have Liza Goyten, who is the Senior Director of the Liberty and National Security Program at the Brennan Center for Justice at NYU School of Law. She will be speaking on the state secrets cases from the previous term.
Great, thank you. Well, first, you can go up too. I'm hoping to hear or stand up.
I think podium is better for the main remarks.
Gonna grab my water then.
Great, thank you. First of all, I want to thank Cato for inviting me to contribute to their Supreme Court review and for inviting me here to speak with all of you. I'm going to be talking about the state secrets privilege and the two cases that the Supreme Court issued in March on the privilege, United States versus Zubaida and FBI versus Fazaga. The state secrets privilege applies when the disclosure of evidence through litigation would harm national security. And the way it works is that the head of the relevant agency submits an affidavit to the court explaining why disclosure would harm national security, and then the court determines whether the privilege actually applies. And in doing that, the court may review in camera and ex parte the evidence, but often the courts just rely on the government's affidavit. There are two versions of the privilege. The most common by far is the one established in United States versus Reynolds, which treats the state secret doctrine as an evidentiary privilege, meaning the privileged evidence just drops out of the case and the case without it. I think I'm going in it. Is this still working, the microphone? Okay. Sorry, I can't hear it. But the second version was established in United States versus Taunton, Taunton versus United States, and it operates as a justiciability bar. It's been applied almost exclusively in cases involving secret contracts between the government and covert operatives or defense contractors involving classified matters, where the contracting parties were on notice that contract disputes would be non-justiciable. For decades, this privilege, in both of its forms, generated very little controversy. It was invoked quite sparingly. But then after 9/11, assertions of the state secrets privilege became much more frequent. And the government also began to explicitly conflate the Reynolds and Taunton doctrines, so that in cases having nothing to do with contracts, the government would argue that the case could not be litigated, that it had to be dismissed at the outset, because the very subject of the case was a state secret. Some courses have accepted that Taunton can apply outside of contracts cases, but even courts that have purported to stick to Reynolds have dismissed cases at the pleading stage before the relevant evidence has been identified, let alone reviewed for privilege. And even where plaintiffs could make out a prima facie case without using any privileged evidence, courts have still dismissed the cases when the government has claimed that it would need privileged evidence in order to mount a defense. To be clear, that is not how evidentiary privileges work in any other context. Normally, as I said, the evidence just drops out of the case and the chips fall where they may. Sometimes the plaintiff is advantaged, sometimes the defendant is advantaged, but under the state secrets privilege, it's become a heads we win, tails you lose scenario for the government. So if the plaintiffs need privileged evidence to prove their case, the plaintiffs lose. If the government needs privileged evidence to mount a defense, the plaintiffs lose. The result of this misapplication of the privilege, along with some other problematic doctrines, is that 20 years after 9/11, there has still been no accountability in the courts for the major civil liberties abuses that the government perpetrated in the wake of those attacks, including the NSA's warrantless wiretapping of Americans' communications, the FBI's surveillance of mosques, or the CIA's programs of torture and extraordinary rendition. So, having teed up the main area of controversy in this area of law, I'm going to pull a bait and switch on you because the court actually did not address that issue. And in fact, I think the most notable aspect of the court's rulings was its failure to shed any light on the major questions that lower courts are wrestling with when it comes to the privilege. So what did the court rule? In Zubaida, the court set a disturbing precedent by holding that the state secrets privilege can apply to information that's in the public domain. The case was brought by Abu Zubaida, whom the CIA wrongly believed to be a high-level al-Qaeda operative and tortured, including waterboarding him 83 times in the span of a month. Some of this torture took place at a CIA black site in Poland, and Polish prosecutors are currently investigating individuals who may have been complicit. They sought to depose James Mitchell and John Jessen, the American contractors who helped the CIA develop the torture program. To secure the contractors' testimony, Abu Zubaydah, from his cell in Guantanamo, filed a lawsuit under 28 U.S.C. 1782, which allows courts to issue subpoenas requiring people to give testimony in foreign proceedings. The United States intervened and claimed the state secrets privilege, seeking to quash the subpoena. Both the district court and the Ninth Circuit held that the existence of a CIA site in Poland and Abu Zubaydah's torture were very much in the public record, and therefore the state secrets privilege could not apply to them. The Supreme Court reversed. It held that any testimony Mitchell and Jessen gave that confirmed the existence of a CIA Poland by the state secrets privilege. Now, the European Court of Human Rights had found, by not a preponderance of the evidence, beyond a reasonable doubt, that there was a CIA black site that operated in Poland. The former president of Poland, who was president at the time, has acknowledged that there was a CIA black site in Poland. There is no doubt on this question. Nonetheless, the court found that Mitchell and Jessen's testimony would serve as official confirmation of this well-known fact, and that could harm national security, according to the court, because foreign intelligence services in the future might be less willing to cooperate with the United States if they thought that the U.S. might not respect the confidentiality of the relationship. This reasoning fails on its own terms. There was no confidentiality left to respect. Whatever reputational harm Poland might suffer from disclosure has already happened. But even if that weren't the case, the question that the court should have asked and didn't ask is, does it truly serve national security to honor a promise to conceal participation in war crimes? Doesn't it serve national security in a broader sense a little better to adopt a rule, sort of the equivalent of the crime fraud exception to the attorney-client privilege, that the protection courts afford to secret agreements between US and foreign intelligence services will not extend to the commission of war crimes and human rights abuses. Professor Shirin Sinar at Stanford has an excellent piece coming out soon in the Harvard Law Review Forum that explores this aspect of the court's ruling more deeply. In any case, the court's ruling is extremely problematic because it extends the reach of this extremely powerful privilege from the realm of actual state secrets, which was actually large enough as it is, to the vast world of public information that might in some way touch on national security. Let's move to the court's ruling in Fazaga. Fazaga raised the issue of whether a provision of the Foreign Intelligence Surveillance Act, or FISA, displaces the procedures that would otherwise apply when the government claims the state secrets privilege. And it's one of the stranger rulings I've encountered. The case was brought by 3 Muslim Americans who were caught up in a campaign of surveillance the FBI conducted in 2005 and 2006 against Muslim American communities in Southern California. It was undisputed that the plaintiffs could make out their case without using privileged evidence. But the FBI claimed that it would need to use privileged evidence in order to mount a defense, at least against the plaintiffs' religious freedom claims. The district court agreed and dismissed the entire case. In the Ninth Circuit, the plaintiffs were foreclosed by circuit precedent from arguing that the state secrets privilege doesn't justify dismissal to protect the defendants. However, the plaintiffs did argue that 1806F of FISA basically prohibited dismissal. Section 1806F establishes procedures that courts must follow in cases involving electronic surveillance when the government asserts that disclosing information through litigation would harm national security. Under these procedures, the Attorney General first submits an affidavit that asserts the claim. The court must then conduct in camera and ex parte a review of the surveillance materials. That in camera review is not optional, and the court has to accept the claim of national security harm, but the court also has to review the materials and make its own determination as to whether the surveillance was lawful. So the evidence doesn't get removed from the case, but it does get removed from the adversarial public proceedings. The government argued that this provision of FISA applies only when the government wants to use evidence, generally in a criminal proceeding, and the non-government party wants to suppress it. The plaintiffs pointed out that nothing in 1806F suggests this, quite the contrary, and the Ninth Circuit sided with the plaintiffs. The Supreme Court was actually faced with two questions. There was the 1806F question, namely, does that statutory provision apply in this category of cases, and if so, does it trump the procedures that would otherwise apply under the state secrets privilege? But second, there was also the question of whether the defendant's privileged information can justify dismissal of the case under the state secrets privilege. That alternative question or grounds for affirmance was foreclosed at the Ninth Circuit level, but not at the Supreme Court level. The court answered neither of those. Instead, it held that even if 1806F applies in civil cases like Fazaga, it doesn't displace the state secrets privilege because, quote, nothing about the operation of that provision, FISA, is at all incompatible with the state secrets privilege. In other words, neither approach displaces the other. They can simply coexist. That's because, in the court's words, quote, the statute and the privilege require courts to conduct different inquiries, authorize courts to award different forms of relief, and direct the parties and the courts to follow different procedures. I find this analysis to be borderline nonsensical. The clash between 1806F and the state secrets privilege exists precisely because they require the courts to do different things when faced with exactly the same threshold circumstance, namely information that could harm national security if disclosed through litigation. Those differences are what render 1806F and state secrets fundamentally incompatible. A court cannot both rule on whether disclosure would harm national security, state secrets, and not rule on that question, 1806F. It cannot both assess whether the surveillance was unlawful under 1806F and not make that assessment under state secrets. It cannot both grant relief to the non-government party, as it's required to do under 1806F if the surveillance was unlawful, and dismiss the case, as it does under state secrets. The court just wished away this obvious conflict, but the conflict is there. And so the effect of the ruling is to allow a common law privilege to prevail over a clearly incompatible statutory provision, something that goes against the court's own case law. More broadly, I think this decision probably puts the nail in the coffin when it comes to civil litigation challenging unlawful surveillance. FISA surveillance materials are always classified. The government will always assert the state secrets privilege over them, and the government will always claim that it needs them to mount a defense. My takeaway from both these cases is Congress needs to step in because the court is dodging key questions and is doing so in a way that is allowing the privilege to metastasize in the lower courts. There are a number of things Congress can do to ensure that the privilege is in fact treated as an evidentiary privilege, and to ensure that the privilege doesn't turn national security policies into an accountability-free zone. And I'd be happy to talk about some of those things during the Q&A. Thank you.
All right. And finally, next is Michael Bendis. He is a senior attorney at the Institute for Justice. He'll be speaking on Carson versus Macon, a case he's uniquely qualified to speak on as he was counsel of record for the winning side. Michael?
Thank you, Tommy, and to everyone at Cato for inviting me here today and for inviting me to submit an article in this year's review. And this is a panel, obviously, about the First Amendment, free speech, free exercise, and certainly Carson is a free exercise case, and it's a tremendous, in my view, victory for religious liberty. But I'm going to focus a little bit differently on Carson as a school choice case. I'm not a religious liberty litigator per se. I am a school choice litigator. IJ defends school choice programs around the country. And so I'm going to focus on Carson from that perspective while it's certainly addressing the religion clause issues that came up in the litigation. Now, since the modern school choice movement was in its infancy back in the early 90s, The big unresolved question was whether choice is permissible under the Federal Establishment Clause. Opponents of choice argued that because some parents might choose religious schools, that somehow constituted a state establishment of religion. And thankfully, the Supreme Court roundly rejected that argument back in 2002 in a case called Zellman versus Simmons-Harris. The court said, as long as the program is neutral toward religion, meaning religious and non-religious schools can participate, and so long as the program operates on the private choice of the parent, it's perfectly fine under the Establishment Clause. But the opponents of school choice are a dogged bunch, and so they didn't just pack up and go home at that point. They retrained their focus to state constitutions, and specifically to provisions in state constitutions that you might have heard of. They're called Blaine Amendments, and they're found in some 37 state constitutions, and generally speaking, they prohibit public funding of religious, or typically the term is sectarian, schools. And opponents of school choice, ever since Zellman, have seized on these to attack school choice programs in court, arguing that they violate these Blaine provisions. Now, you might think that there's a problem if a state constitutional provision singles out and targets religion for disfavor, that could create some problems under the Federal Free Exercise Clause, and we certainly think it does. But over the last 5 years or so, the opponents of educational choice have had a theory as to why that's not the case. And that theory is something called the status-use distinction. Basically, what it says is that while it might be unconstitutional to withhold a public benefit from someone because they have a religious status or a religious affiliation, it's perfectly permissible to withhold a public benefit from someone because they might put it to a religious use, such as procuring a religious education. In other words, these folks recognize that it's not constitutional to discriminate because someone is religious, but it's perfectly permissible to discriminate because they might do religious stuff. And that, in my view, is absurd. And thankfully, in Carson versus Macon, the case I'm here to talk about, the Supreme Court seemed to agree and killed the status-use distinction. Now, before we get to the happy death of the status-use distinction, it's important to look at the origin story of the distinction. The status-use distinction was born on June 26, 2017 at 10:09 a.m. It's at that time, on that day, that the Supreme Court handed down another decision, Trinity Lutheran Church of Columbia versus Comer. Now, Trinity Lutheran involved a playground resurfacing program that the state of Missouri had. Basically, the state provided monetary grants to nonprofits so that they could resurface their playgrounds with scrap tire material in order to protect the knees of the kids playing on the playground. Trinity Lutheran Church, which operates a preschool, applies for one of these grants. It's denied. And the state's justification for denying it is the state Blaine Amendment. Missouri has a Blaine Amendment that prohibits aid to sectarian institutions. And so the state says, sorry, Trinity Lutheran, you can't get it. Trinity Lutheran challenges its exclusion. The case goes up to the U.S. Supreme Court. And thankfully, the Supreme Court concludes that that violates the Free Exercise Clause of the United States Constitution because it singles out and excludes an entity from this public benefit program simply because of its religious status, simply because of its identity as a church. But then the court, or more accurately, 4 justices in the majority, drop a footnote in the opinion. It's a 27-word footnote, and it says this: "This case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination." Now, again, this was 4 justices signing on to this footnote, not a majority of the court. And the footnote doesn't say there is a status-use distinction. It just says we're not addressing whether, a use-based exclusion. We're simply addressing an exclusion that turns on religious status. But nevertheless, school choice opponents immediately seized on that footnote, on those 27 words, to argue that state law could bar, that Blaine Amendments could be used to attack school choice programs on the theory that they allow parents to put their benefit to the use of procuring a religious education. Now, Like other members of the 27 Club, this 27-word footnote was not long for the world. And so, as we'll see, it went the way of Jimi Hendrix, Janis Joplin, Amy Winehouse, and other members of that club. Now, we thought we might get some resolution on this issue, on the constitutionality of use-based exclusions in another case, Espinoza versus Montana Department of Revenue. That case concerned a school choice program in the state of Montana. As originally enacted, it allowed religious schools to participate. But then the state agency charged with implementing it promulgates a regulation that says no religious schools. So we challenged that on behalf of families eligible for the program, and the case goes up to the Supreme Court. The Supreme Court holds correctly that that exclusion violates the Free Exercise Clause. Montana, like Missouri before it, had said, well, we have a Blaine Amendment. It prohibits state funding to religious institutions. And the court said, look, this is basically a straightforward application of Trinity Lutheran. We said you can't exclude an institution simply because of its religious status in Trinity Lutheran, and that's precisely how your Blaine Amendment is being applied in this situation. So a great win, but the court dodges the question of use-based discrimination and its constitutionality. But the status use distinction thankfully dies in Carson this term. Now, Carson involves another school choice program in Maine. Maine is a rural state. There are not many public schools. And if a town doesn't operate a public school or doesn't contract with another school to educate its resident students, it has to pay tuition to the school of the parent's choice. It can be a public school, it can be a private school, it can be in-state, it can be out-of-state, it can be out of the country. But the one thing it could not be was religious. Maine, since 1981, has had a statute that specifically prohibits, quote, sectarian schools from participating in the program. So we challenged this exclusion in the wake of Trinity Lutheran, and we thought it should be an easy win in light of Trinity Lutheran. But Maine wised up. After Trinity Lutheran and after Espinoza, the state adjusted its justification for the exclusion. It says, we're not really excluding these schools because they're religiously affiliated. We're excluding them because they do religious stuff. They teach religion, and that's different. And the Supreme Court didn't address that in Trinity Lutheran. It didn't address that in Espinoza. And the Maine pointed to footnote 3, that 27-word footnote, and said, this is perfectly fine. The First Circuit bought that reasoning. It upheld the exclusion, again pointing to footnote 3 in Trinity Lutheran, and also by redefining the benefit. Remember, the benefit is tuition to attend a public or private school. The First Circuit said, well, really the benefit's a substitute for a public school. And of course, a public school has to be secular. Therefore, Maine can permissibly require that the schools that children attend under this program be secular. We appealed that decision to the Supreme Court, and the Supreme Court agreed with us that is just as unconstitutional as the discrimination that was going on in Trinity Lutheran and Espinoza. The court starts out the first half of its opinion by basically saying this is a straightforward application of those cases. In fact, Chief Justice Roberts, for the majority, says this is simply an application of the unremarkable principles of Trinity Lutheran and Espinoza. And when I got to that point in the opinion, the day it came down, I'm like, great, we win, but the court again dodges the question of the status use distinction. But Chief Justice Roberts went on, and he took issue with what he called 2 recharacterizations that the First Circuit engaged in, a recharacterization of the benefit and a recharacterization of the exclusion. Now, with respect to the benefit, remember the First Circuit had said, really the benefit here is a substitute for a public education. Chief Justice Roberts says, it's no such thing. The statute defines the benefit as tuition at the public or approved private school of the student's choice. It says nothing about a substitute for a public education. And if you look at how the tuition program operates, it doesn't do anything to ensure that these schools are like public schools. The participating schools in the tuition program, while they had to be non-religious, could be unlike public schools in a whole host of respects. They could charge tuition, number one. They didn't have to accept all comers. They didn't have to follow state curriculum. They didn't have to hire state certified teachers. They could discriminate on grounds that public schools could not. They could be, and many were, single sex. So Chief Justice Roberts says, no, this is not a substitute for a public education. The First Circuit was simply recharacterizing the benefit in order to justify the very discrimination that Maine was engaged in. And then Chief Justice Roberts turns to the status-use distinction. And as he accurately says, the First Circuit's opinion is really recharacterizing the exclusion in this case. He begins by saying, look, yeah, there was this footnote in Trinity Lutheran, but we never suggested that use-based discrimination is any less offensive to the Free Exercise Clause. And then he explains why. And he correctly points out that the very purpose of a religious school, that is a school with a religious status, is to engage in the conduct of providing a religious education. And he cites the court's earlier decision in Our Lady of Guadalupe, where the court says that educating young people in their faith, inculcating its teachings, and training them to live their faith are responsibilities that lie at the very core of the mission of a private religious school. So again, he's pointing out that it is the very religious status of schools that impels them to engage in the use or the conduct of providing a religious education. So there's no meaningful distinction between status and use. And then he also points out that if we were to give effect to Maine's exclusion and to allow them to parse out religious uses, then we're really just inviting the state to engage in scrutiny of religious schools' curriculum to determine, what's sufficiently irreligious, what's too religious, and that just invites government entanglement with religion and denominational preferences. It allows the government to pick winners and losers in terms of which schools are too religious to participate and which schools are sufficiently irreligious. And the Establishment Clause prohibits both of those things. And so the court holds, regardless of how the benefit and restriction are described, the program operates to identify and exclude otherwise eligible schools on the basis of their religious exercise. So real quickly, what does Carson do for the school choice movement? What does it not do? Number one, it puts to bed the status-use distinction. It also puts to bed the Blaine Amendments. Now, you'll notice when I talked about Trinity Lutheran and Espinoza, I talked about Blaine Amendments. Maine, interestingly, doesn't have a Blaine Amendment, even though it was the home of their namesake, James G. Blaine. It excluded schools based on state statute, not a state constitutional provision. So you might think that Carson has little to say about Blaine Amendments. That's not the case. The court, in the opinion, actually equates Maine's statute with a Blaine Amendment, specifically with the Blaine Amendment that was at issue in Espinoza. The court says, while the wording of the Montana and Maine provisions is different, their effect is the same. So the state is saying it doesn't matter whether this is a statute-based exclusion or a constitutional-based exclusion, you cannot single out and exclude religious options this way. And that's important because many states have Blaine Amendments that use kind of use-based language. Many of them target schools and institutions with a religious affiliation or status, but many target particular religious conduct. And so, for example, Arizona, Utah, Washington, their Blaine Amendments all speak to religious worship, exercise, or instruction. They prohibit government funding of those things. And so now it's clear that even when a Blaine Amendment speaks in that kind of use-based language, it cannot be applied to single out and exclude religious options from a school choice program. Now, what doesn't Carson resolve? I think three big issues in the educational choice sphere. The first is whether or not states can condition participation in school choice programs on certain admissions or employment policies. Specifically, can a state say you can't participate if you consider sexual orientation or gender identity in employment or in admissions? The reason the court didn't speak to that in Carson was because Maine didn't concern itself with that. It excluded all religious schools, and the Kent School found out the hard way when it applied to participate in the program. The Kent School does not consider sexual orientation or gender identity in hiring or admissions, yet it was nevertheless excluded because the state deemed it a sectarian school. So that question, the extent to which participation can be conditioned on employment and admissions policies, is going to be resolved presumably at some point in the future. In fact, there's a case, Yeshiva University versus YU Pride Alliance, which is making its way through the courts now, that may speak on many of those issues. And then really quickly, the two other things that Carson does not resolve for the school choice movement. Number one, the permissibility of applying what I call public-private Blaines to bar school choice programs. These are Blaine amendments that exist in a handful of states that don't single out and exclude religious schools specifically, but rather all private schools. And so they don't, at least on their face, discriminate against religious schools, and Carson doesn't speak directly to them. But as I point out in the article in this year's review, I think there are a number of constitutional problems even with those facially neutral Blaine amendments that render them just as problematic as the more traditional Blaine amendment. And then finally is the charter school question. A lot of media in the run-up to the decision and in the wake of the decision suggested that it was opening the door to religious charter schools. It doesn't. It doesn't speak to that issue. Charter schools, while often typically privately operated, are nevertheless public schools, and therefore you have completely different establishment clause concerns when you're dealing with whether or not a charter school may be religious or engage in religious instruction. But nevertheless, Carson resolves the last remaining major constitutional issue concerning choice. Zellman held it's permissible to include religious options. Carson now makes absolutely clear that state law may not be applied to exclude them. Thank you.
All right, thanks to all three of our panelists for those great remarks. We've now got about 23 minutes for questions and answers. I'd like to remind the audience online, they can submit questions on our event webpage at Cato's website, or in the comments watching on Zoom, Facebook, or YouTube, or on Twitter using the hashtag CatoScotus, CatoScotus, and I'll see them pop up on all of my myriad devices here. But first, do we have any questions? I have some questions in reserve, but only if we don't have a hot bench here. So are there any questions here in the audience? Got a shy audience to start. All right, I'll start with one for Enrique. Several of the plaintiffs, maybe all of them in this case, owned billboards. And Justice Alito wrote a partial concurrence, partial dissent, where he distinguished between billboards which are not attached to any building at all versus like the sign attached to the restaurant, like the Franklin's barbecue sign. And I thought that was pretty convincing. It seems like there's a strong case that really the problem is for signs attached to buildings, not billboards. I wonder if you think, if one, you agree with that the court should have distinguished those two, and two, do you think maybe it hurt the case, or maybe this wasn't the ideal posture, the fact that the main plaintiffs seem to be billboard owners rather than, say, a restaurant owner?
Well, thank you for the question. I think Justice Alito is exactly right. The city of Austin is more than welcome to say, no more billboards in the city of Austin. The city of Austin is more than welcome to say, no one in Austin is allowed to digitize their sign, right? Those two ordinances raise no First Amendment concerns at all. What the city of Austin was trying to do was to distinguish, based on the connection between the sign and the place, to favor on-premises signs. And I talk about this in the paper, to really favor property owners, right? Because if your sign is on your property, you can do anything you want with it. If your sign is not on your property, like the billboard owners in the case, they can't do anything to it. So I think what Justice Alito is getting at, and I think what the Fifth Circuit recognized to a much better degree than the Supreme Court did, was that there are lots of other ways to regulate signs that don't implicate the First Amendment at all. So if I could just add one more thing, I think I forgot to say the actual reason, what was actually going on in the case, put aside the very convoluted doctrinal reason that I gave. So this is in the very first line of the opinion. This is an opinion that's written by Justice Sotomayor, who actually was in the majority in Reed. And the first line of the opinion says there are thousands of jurisdictions across the country that have ordinances like this. And as soon as you're worried about that, you're going to uphold the ordinance, right? And Justice Roberts is in the majority in both Reed and the city of Austin. And if there is anything that John Roberts hates, it's a bureaucrat. So when they see this challenge that's brought by these billboard operators, what they see are these thousands of lawyer hours paid by taxpayers to try to figure out what all of these state and local sign laws say as a result of some incentives in the Highway Beautification Act. We're going to have to, all of this work is going to have to go into figuring out which of these sign ordinances can survive Reed and which ones won't. But instead of doing that, they just create an exception, say, no, the city of Austin isn't worried about content. They're only worried about content to the extent there's a connection between the sign and what the sign says and where it is. We're going to carve out an exception to this very elegant rule that we came up with in 2015 to try to prevent all this work on the part of all these cities.
Thank you. And then, Liza, I wanted to accept your invitation for talking about congressional solutions a bit during the Q&A. I wonder if you could expand on those a bit and also specifically speak to the extent you can, how do you convince people with political concerns or the sort of risk averseness that you might expect to run any risk of national security concerns, and what's sort of the elevator pitch to the congressperson who thinks the last thing I want to do is pass any law that has any chance of letting the terrorists get away with something?
I just want to point out, first of all, that the litigation we're talking about is litigation that has been bubbling up for about 20 years and has to do with government programs that are basically no longer in place and has to do with terrorists who are no longer in place. And so the notion that actually hearing these cases through and having some kind of accountability for these abuses that happened 20 years ago is going to harm our national security today I think I would try to reassure Congress that that's not an issue. Of course, they would also have concerns looking forward to the future. But let me first say what I think Congress needs to do. And the first thing they need to do is to make sure that courts are not ruling on whether the privilege applies to certain evidence based on the government's predictions about what the evidence in the case will be. Again, there is no other evidentiary privilege where a court will actually dismiss a case based on one party's predictions about how evidentiary disputes will be resolved once the parties know what the evidence is. So what that means to me is that Congress should essentially should prohibit dismissal on the pleadings for that reason, for the state secrets privilege. There may be other reasons to dismiss, standing, other things like that. But the parties should go through discovery and go through the exercise of identifying what the evidence in the case will be through discovery. To be sure, if responding to a discovery claim, a discovery question would require the government to disclose privileged evidence, then at that point the issue is joined and the court should review the evidence and make a determination. But this should not be a blanket determination about the evidence in the case before the court even knows what that evidence is. The second thing I think Congress should do is to make sure that courts are scrutinizing the government's claims a little more carefully. And in this regard, I want to point out that the original case that established the evidentiary version of the privilege, that's the Reynolds case, the government claimed in that case that it could not disclose an accident report about an Air Force plane crash. This was a lawsuit brought by widows of people who were killed in that crash. And the government said, oh, there'll be all kinds of information about secret equipment in this report. We can't disclose it. The Supreme Court did not look at the evidence and said that the lower court should not look at the evidence. They should simply accept the government's affidavit. The case was not dismissed, but that evidence was excluded. Years later, decades later, the accident report was released. There was no information in that report about secret equipment. There was proof of negligence on the Air Force's part. So there are many reasons, with Reynolds being only one of them, for the court to scrutinize these claims more carefully. And Congress should require the courts to review the actual evidence in camera to make sure that the government's description of the evidence is accurate, not to second guess the government's national security judgment, but to see what the evidence actually is. And the third thing that I think Congress should do is to think of some creative solutions for situations where evidence might be privileged to allow the case to go forward. There's another law that applies when classified information is at issue in criminal proceedings. It's called the Classified Information Procedures Act, and it provides a good model for this. It provides for redacted versions of evidence, summaries of evidence, admissions of fact in lieu of introducing the evidence, various different creative ways that will help both plaintiffs and defendants to go forward with litigation in cases where there's privileged evidence. So those are the main features that I would propose in legislation. And what I would tell Congress is this is your responsibility. Congress has authorized these lawsuits that are being shut down. So this is not just an issue of the executive branch's Article 2 authority to protect national security information. This is intruding on Congress's Article 1 authority to authorize legislation in these cases. It is intruding on the court's Article 3 responsibility to adjudicate cases and controversies. So this is really necessary to uphold the constitutional balance of powers, to make sure that there is accountability for abuses in national security policy and not create this accountability-free zone, and to restore the privilege back to the way the Reynolds Court conceived of it. I think they did a misstep in terms of not reviewing the evidence in camera, but the Reynolds Court said it's an evidentiary privilege, it falls out of the case, let the chips fall where they may, and the lower courts have gone too far from that. That was a long answer.
Oh, it's a great answer. Thank you. And then, Michael, I'll have one for you as well, and then I'll see if we have any in reserve in the audience. One of the cases that the opposing side relied on heavily was an older case called Locke versus Davey, which was about public funding. Correct me if I'm making it too simplistic, but essentially a case where public funding went to someone studying for the ministry specifically, to be a minister. And the Supreme Court basically said, no, you don't have to fund that. I'm wondering at this point, what do you think is the status of that case? Is that in tension with where the current doctrine lies? Can it coexist with it? And if it can exist, is it basically now limited to just literally studying for the ministry, or will there be any difficult line drawings going forward between that versus just general religious education?
Sure, great question. So the fact that Locke has caused mischief for so long is always been interesting to me, because the case involved a scholarship program in Washington State. It was a need and achievement-based scholarship that kids could use. They could attend religious schools, they could take religious courses, they could take compulsory religious courses. The only thing they couldn't do was use the program if they were majoring in what the state called devotional theology, which was specifically a theology program designed to train future ministers. And the Supreme Court upheld that exclusion in a 7-2 opinion. But in doing so, it did a couple of things that, in my mind, should have cabined the decision from the outset to just that situation. Number one, it said the only state interest we're addressing in this case is the state's interest in not funding clergy. That should have been enough right there to say that's all this case is about. Moreover, the court said that the case turned on the unique historical state interest in not funding clergy, which was commonplace. There were commonly in the early state constitutions prohibitions on a state-funded clergy. And so the court said that there's, historically, this exclusion is well-founded. That also should have cabined the decision. But opponents of school choice read Locke far more broadly as allowing any kind of religious exclusion in a scholarship or financial aid program. And many lower courts bought that argument, and including the First Circuit, which in a previous case, striking down the religious exclusion in the main program, pointed to Locke and said that this was justification to exclude religious options from education programs more generally. In Carson, the Supreme Court finally says no. Locke is limited to one thing and one thing only, and that is exclusions that, again, are for students who are studying for a career in the clergy, vocational religious instruction. I don't think there's any more wiggle room. The only thing, as I say in the article, the only other, things the court could have done to make it any more clear was either overrule Locke outright, which I wish it had, but it didn't, or limit it to litigants named Gary Locke and Joshua Davey. But short of that, there was nothing else that the court could have done more clearly to say, there is no more traction in Locke. It dealt with a very unique, specific, historically rooted state interest in not funding clergy. It doesn't speak to religious exclusions any more broadly than that.
Great, thank you. Questions? We have one right here, front desk.
Thank you. This is David Schneer. I want to pose this to Mr. Bendis. There's been a significant amount of attention given to the effect of both COVID and trans and other kinds of sexual-related or gender-related activities that has been causing families to attempt to leave government schools to go to private schools. And I'm wondering, a particular case in which a parent did not want trans and gender studies for their child to be part of the school curriculum, were then accosted by the government claiming that they were abusing their child and had the child taken away from them. And I'm wondering if you could look forward a little bit and talk about what the government interest arguments might be for those who are promoting gender studies and those who are demanding COVID protections and particular shots in public schools.
Goodness. Those are difficult questions, and I'm not sure I'm competent to speak to them as a school choice litigator. But I would say, from my perspective, it's the more interesting question is not what is the state interest for teaching certain things in state schools. They are, after all, state schools. And while, I guess I would say that while no one is compelled to attend them, certainly we have compulsory attendance requirements, and for many families, perhaps most families, opting out of the public school system is not an option financially. After all, we assign kids to schools based on zip code, based on where their house is, which is just a proxy for wealth. But nevertheless, it's a difficult question because nevertheless, after all, they are government schools. And I think that's the beauty of school choice, is that it provides another option for those families who can't exercise, can't opt out of those things by moving to a different public school district or paying tuition out of pocket. And so I think we've seen a proliferation of school choice programs in the last 2 years. I think most of that is probably attributable to what parents saw during the pandemic. Perhaps some of it has to do with some of the other issues you mentioned. Inevitably, there are going to be clashes about the extent to which states can condition school choice participation on schools adopting some of the policies that you are mentioning that exist in the public school system. It's kind of not my area of expertise. Institutionally at IJ, we don't have a position on some of these issues. But I would say Carson does address some of that, at least with respect to religious schools, indirectly. And that is, remember that I said that it relied a decent amount on Our Lady of Guadalupe. That case was all about religious autonomy. It concerned religious schools' ability to avoid employment discrimination claims based on alleged sex discrimination, and the court, relying on principles of religious autonomy, held that the church-run schools in that case could not be subjected to those lawsuits. And so the fact that Carson relied heavily on Our Lady of Guadalupe and that kind of its principle of religious autonomy perhaps forecasts where the court will come out on some of these issues that lie ahead, whether government can condition participation on certain admissions policies or employment policies. But again, you know, I wish I could say something more beyond that. I'm not sure I've even begun to answer your question, but again, it's just not, you know, it's an area that's out of IJ's kind of institutional focus, and you know, something that inevitably will be litigated, and we'll have to see how those come out. But I would keep an eye on that yeshiva case that I mentioned, particularly with respect to the sexual orientation, gender identity stuff.
More questions? Professor Amar? Wait for the mic just a second.
For Attorney Bendis, you mentioned the public-private Blaine Amendments, which are formally neutral, but that you have some concerns about. What are those concerns? And if they're about, you know, specific legislative history of discrimination, fine, but if they're not, would that be a thin edge of a wedge that would require basically vouchers everywhere? Just, you know, and say the public school monopoly is itself unconstitutional.
You know, I don't think my theories would go that far, and after all, in Carson and in Espinoza before it, the court says point blank, the state is not required to subsidize private education. But once it chooses to do so, it can't discriminate based on religion. As to my theories as to why public-private Blaines are just as problematic, I would really say three things. Just as a traditional Blaine conditions a public benefit on a parent's surrender of her free exercise rights, a public-private Blaine conditions a public benefit based on a parent's surrender of her, her rights under Pierce versus Society of Sisters to select a private school for their children. So it conditions a right just as the more conventional Blaines do. Number two, so long as Smith is still good law, even operating within that framework, public-private Blaines burden a hybrid right. A hybrid right mentioned in Smith itself, which is free exercise coupled with the right to direct the education of your children. And so I think there's an argument that even under Smith, although these provisions are facially neutral, they should still be subject to strict scrutiny because they do burden a hybrid right in that respect, which Smith says still gets strict scrutiny. And then the last thing I would say is that in my view, there's an equal protection problem, and this goes back to Romer versus Evans, where, remember, Colorado adopted a constitutional amendment that prohibited any aid or preferred status to gay and lesbian citizens. The court invalidated that, saying that a state constitutional provision that makes it, in the court's words, more difficult for one group of citizens than for all others to seek aid from the government is I forget the exact words, but by definition, an equal protection problem. And public-private Blaines do the exact same thing. They impose a structural barrier that make it more difficult, actually impossible, for parents who choose a private school for their children to seek aid from the government. So those are the arguments that I would make.
Another question? Devin?
My question is to Elizabeth. I know that having in-camera review in these cases would be a step of improvement for the current status quo, but in my opinion, that doesn't go far enough. We really need adversarial briefing in cases like this. And what I would like to see is, the government say, this is a top secret document. You got to have a top secret lawyer with a top secret clearance to be able to represent you. He might not be able to share with the client all the details, but in that kind of case, you can have an adversarial proceeding with people that have the appropriate security clearances, or if it's even more restricted, have the government give a list of 10 lawyers that the government would trust to be able to securely handle this kind of information.
I agree 100%. And am I on? Yes. I agree 100%. And I gave you the Reader's Digest version of what I would like to see Congress do. I'd like to see them not make predictions about evidence. That was the first part. The second part, when I said I'd like them to review the evidence more closely, I left out, just for brevity's sake, another aspect to that, which is to increase the adversariality of that review through exactly the mechanisms that you're talking about. And such mechanisms are contemplated and often used in SIPA, the Classified Information Procedures Act. So we have a model for it. We know it can work. Now, in certain circumstances, in some of these cases, we have seen courts try to get the government to agree to clear the plaintiff's attorney. The government has dragged its feet. It's behaved very badly. It is pointed to a Supreme Court case that says that the executive branch has complete and total control over to whom it grants clearances. So I'm not saying that it would go entirely smoothly, but it would certainly be another improvement over the current system. So thank you for that point.
All right. Well, it's right at 2:15, so we're going to have to end there. If you have more burning questions, you can. If you have more burning questions, you can find our panelists somewhere getting refreshments. We're going to take a 10-minute break. Refreshments are available in the conference center foyer. We'll reconvene for panel 3 at 2:25 p.m. But first, let's thank all of our panelists.
Dave Kopel is. One minute warning. Please reconvene. Okay. We're back for the most subdued and uncontroversial panel of the day. I'm sure no one spent any part of June debating relatives over a certain opinion or other opinions. I think, well, so Dave, where is Dave, by the way? Well, he's here, so Dave gets guns, Kelly gets opioids, and Evan gets abortion, which he took the reins of that ably. I will introduce them before they speak. So we're going to start off, for no discernible reason, with abortion. And we'll start off with Evan Bernick, who I first met when he was a Cato intern in the spring of 2013, and he has gone on to bigger and greater things as a professor of law at Northern Illinois University College of Law, where he teaches con law, crim pro, admin law, and legislation. From 2021, he was a visiting professor at Georgetown University Law Center and executive director of the Georgetown Center for the Constitution. And I'm in the middle of his excellent book with Randy Barnett on the 14th Amendment for a future podcast. And hopefully that book will be, I think it will be, one of the definitive books on the 14th Amendment going forward. So, Evan?
So Trevor generously failed to notice that I was a very obnoxious and irritating Cato intern, and hopefully a little bit less obnoxious and irritating as an academic, although opinions of that are split roughly down the middle. So it was hard enough, even with the aid of the patient and diligent editors of the Cato Supreme Court review, to summarize and critique Dobbs and predict the future of abortion in America in 44 pages. I only have 15 minutes, but I'm going to try my best. In Dobbs, the Supreme Court overruled Roe v. Wade and Planned Parenthood v. Casey. As of this day, before Constitution Day, abortion has been banned in 16 states. Other states are expected to follow suit. A federal ban on abortion after 15 weeks has been proposed. No Supreme Court decision has so quickly resulted in the criminalization of so much conduct that was once afforded the highest constitutional protection. Now, in one sense, Dobbs was unsurprising. Roe Casey's days were numbered since the appointments of Justice Amy Coney Barrett produced a solid 6-3 conservative majority. In another sense, however, Dobbs is shocking. Justice Sam Alito's opinion for the court takes a scorched earth approach. It strives to leave nothing left of Roe or Casey. It's had an immediate impact on the lives of millions. It's already generating new legal conflicts, and it's cast a cloud of uncertainty on the status of other constitutional rights. Now, as you may have already gathered, I regard Dobbs as a disaster, and I'll say a bit about why. Mostly, however, I want to explain how we got to Dobbs, what it says, and where it leaves us. And we need to start with Roe. In 1973, when Roe was decided, abortion was a crime in most states. Most criminal abortion laws were the product of an anti-abortion campaign led by elite physicians that began in the late 1850s. These criminal laws marked a break with the common law of abortion, which generally permitted abortion before quickening, roughly 10 to 14 weeks into pregnancy. By the late 1960s, a majority of Americans believed that abortion shouldn't be a crime, but decriminalization efforts had stalled. Pro-choicers who were reeling from high-profile legislative losses, who were concerned by pro-life arguments for prenatal constitutional personhood, shifted to constitutional litigation themselves. Before the Supreme Court, lawyers representing Norma McCovey, Jane Roe, and the state of Texas both argued that the Constitution took sides on abortion. Texas defended its abortion ban by arguing that the 14th Amendment required states to protect prenatal persons. Texas lost 7-2. At the time, criticism of Justice Harry Blackmun's opinion was primarily limited to pro-life circles, but today, Roe is generally regarded as a mess of an opinion. And so it is. For example, Justice Blackmun says that the answer to the question whether the Constitution protects abortion turns on the right to privacy. This right was central to Griswold v. Connecticut, recognizing the right to use contraceptives. But Blackmun never identifies where in the Constitution this privacy right comes from. And then we get this momentous declaration. This right of privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Why? Blackmun doesn't explain. He states that during the early stages of a pregnancy, strict scrutiny of abortion restrictions, the highest level of constitutional scrutiny reserved for fundamental rights, is constitutionally required. He then sketches a framework for balancing abortion rights against state interests, in the context of which the most important stage of the pregnancy is viability, the point at which the fetus has the capability of meaningful life outside the mother's womb. Why? Again, Blackmun doesn't explain. Roe's failure to answer such basic questions about its constitutional premises was the basis for Harvard professor John Hart Ely's memorable charge that Roe is not constitutional law and gives almost no sense of an obligation to try to be. His critique resembled conservative then Yale law professor Judge Robert Bork's critiques of Griswold and later Roe. Both regarded the use of the due process of law clause of the 14th Amendment to protect fundamental rights with great skepticism. Bork considered the doctrine of substantive due process illegitimate, as did later Justice Antonin Scalia. Roe didn't start the abortion wars. Republican strategists seeking to appeal to pro-life Catholics whom they thought they could dislodge from the Democratic Party successfully lobbied Richard Nixon to campaign against abortion on demand in 1972. And what began as a strategy for targeting Catholics was expanded to make conservatives more generally into Republicans. Still, Roe helped make control of the Supreme Court a central issue for rank-and-file Republican voters and thereby for Republican presidents. It's President Reagan who first prioritized anti-Roe judicial selection. When Reagan's Republican successor in office, George H.W. Bush, replaced pro-Roe Justices William Brennan and Thurgood Marshall, Roe's overruling seemed certain. That didn't happen. In Planned Parenthood v. Casey, 5 Republican-appointed justices voted to preserve Roe. But a 3-justice, all-Republican plurality replaced Roe's trimester framework with an undue burden standard that was more deferential to the government. Now, even before viability, states had a lot of space to restrict abortion, but they still couldn't ban pre-viability abortion. Casey produced several separate opinions, the most significant of which was Justice Antonin Scalia's stirring dissent. A major theme in Scalia's dissent was majoritarian democracy. Because the Constitution's text doesn't speak to abortion, Scalia argued that such value judgments are left to democratic majorities. Yet another theme was tradition. Scalia cast Roe as a particularly damaging variation on a broader theme in the court's substantive due process cases. He accused the court in case after case of ignoring long and clear traditions, clarifying ambiguous constitutional text. In Washington v. Glucksberg, involving a claimed substantive due process right to assisted suicide, the courts enshrined Scalia's traditionalism as substantive due process law. Glucksberg held that only rights deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty would qualify as fundamental. And a claim right had to be given a careful description. In application, careful meant narrow. Consider Angel Raich, who challenged the constitutionality of the Controlled Substances Act, arguing that the act infringed her fundamental liberty rights to preserve her own life. She claimed that it did so by prohibiting her from using marijuana to ameliorate a life-threatening wasting syndrome. The Ninth Circuit, applying Glucksberg, didn't look to history and tradition for a right to preserve one's own life. Rather, it looked for a right to preserve one's own life by using medical marijuana. and unsurprisingly concluded that no such fundamental right was deeply rooted in the nation's history and tradition. Now, the court's commitment to Glucksberg proved unstable, thanks in large part to Justice Anthony Kennedy. A swing vote on a court roughly evenly divided along ideological lines, Kennedy authored two substantive due process opinions worth commenting on here. In Lawrence v. Texas, the court held unconstitutional a Texas ban on same-sex sodomy. In Obergefell v. Hodges, the court held that same-sex couples have the right to marry. Lawrence didn't mention Glucksberg. Obergefell discussed it only to decline to apply it. But Glucksberg didn't disappear, and the court applied it in recognizing substantive due process rights to keep and bear arms and not to be subjected to excessive fines. On the 2016 campaign trail, Republican nominee Donald Trump promised that if elected, he would appoint pro-life justices. As president, he had the opportunity to appoint 3 justices: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Dobbs arose from a challenge to Mississippi's ban on abortion after 15 weeks, well before the point of viability. And on May 3rd, 2022, Politico published a leaked draft opinion indicating that the court was about to overrule Roe. It did not substantially change from draft to final. Justice Alito's opinion for the court in Dobbs closely resembles Justice Scalia's Casey dissent in both its tone and traditionalism. Justice Alito's analysis begins not with substantive due process, but with his summary dismissal of an argument that abortion restrictions violate the Equal Protection Clause by discriminating on the basis of sex. Alito pronounces this argument squarely foreclosed by precedents. He does take note of an amicus brief by the American Historical Association, which documented how arguments in favor of late 19th century abortion laws were saturated with sexism. But he declined to give weight to this evidence, stating that this court has long disfavored arguments based on legislative motives, and pointing out that the evidence in this brief consisted only in statements from supporters of the laws, not legislators. Then we get the main event, substantive due process, the argument that liberty includes abortion rights. Here, Alito applies Glucksberg. He dives into abortion history, sweeping through common law and founding-era authorities. All authorities indicate that the abortion of a quick child was a common law crime. None indicates that abortion was ever a legal right. And most significantly to his analysis, by the time the 14th Amendment was ratified in 1868, many states banned pre-quickening abortion. Alito then distinguishes abortion from other substantive due process rights. He doesn't say that rights to marry a partner of the same sex, use contraceptives, or have sex satisfy Glucksberg. But he does say that they don't implicate fetal life. So how are judges to review abortion laws going forward? Scholars have long observed that the court's standard of review of government restrictions on non-fundamental liberty rights, rational basis review, can take 2 forms. One form, rationality review, is meaningful. The court has held unconstitutional under rationality review a number of government actions upon demonstration that the government wasn't plausibly pursuing any legitimate goal. The other, conceivable basis review, essentially dictates victory for the government. Dobbs applies conceivable basis review. Alito writes that a law regulating abortion must be sustained if there is any rational basis on which the legislature could have thought that it would serve a legitimate state interest. Doesn't matter whether it actually did think that. The court easily upholds Mississippi's 15-week ban. So much for the summary. Now for the critique. On Alito's account, Roe and Casey were badly reasoned because they neglected text, history, and precedents. Roe talked a lot about history, but Alito is right that a lot of that talk was inaccurate. Roe made important errors about the common law, and it neglected the significance of the rise of pre-quickening prohibitions on abortion prior to the 14th Amendment's ratification. But it's downhill from there. Alito's textual critique focuses on Roe's trimester framework and the viability line. Obviously, neither of these are specified in constitutional text. But then, neither are the tiers of scrutiny on which Alito relies in dividing fundamental rights from non-fundamental rights, or the conceivable basis test he applies to abortion rights. You can't simultaneously blame Roe for going beyond the text and then go beyond the text. Still weaker is Alito's criticism of Roe and Casey for neglecting precedent. Alito criticizes them for neglecting a prenatal life distinction between abortion and other fundamental rights, but offers no text or history in support of this distinction. The only cases that he cites in support of this prenatal life distinction? Roe and Casey. Alito's own inquiry into the meaning of the 14th Amendment is dictated by precedent. He applies Glucksberg. Is Glucksberg originalism? Alito, Barrett, Gorsuch, and Thomas have all identified as originalists. And it does seem intuitively obvious that focusing on legal history would help us understand what a constitutional provision guaranteeing liberty originally meant to people present at ratification. But Glucksberg doesn't just require an inquiry into whether a right is deeply rooted. It requires that rights be defined narrowly, at a low level of generality. And no originalist defender of Glucksberg has ever persuasively answered why that is. Why is framing rights at a low level of generality more likely to capture the original meaning of liberty? Why think that either the framers or the ratifiers or an ordinary member of the public would be more likely to read liberty to encompass narrow rights rather than broad rights? How could one defend what originalists take to be the uncontroversial proposition that Brown v. Board of Education is correctly decided if one looked to determine whether there existed a narrow right to attend non-segregated public schools in 1868, as opposed to a more general right of citizens to be free from racist exclusion from public institutions? Speaking of discrimination, originalists generally agree that the 14th Amendment imposes some kind of anti-discrimination requirement on the states. They've drawn extensively upon abolitionist and Republican constitutional argumentation in the years leading up to and following the Civil War. There is not a word in Justice Alito's opinion about any of this. The anti-discrimination argument against abortion restrictions is the best known, most elaborated argument that Roe is correctly decided, despite being badly reasoned. It holds that abortion restrictions discriminate on the basis of sex because they force some people, and not others, to perform a particular social role, motherhood. They require some people, and not others, to endure physical and psychological burdens that range from the nausea-inducing to the extremely painful to the life-threatening. By the way, Alito says nothing about whether the Constitution might require life or health exceptions to abortion restrictions. And so the argument goes, they do so because of stereotypes about women. In one paragraph, Justice Alito dismisses this argument. He disregards evidence of discriminatory intent because he says all we have is evidence of the intentions of the supporters of 19th century anti-abortion campaign, not legislators. But legislators worked together with leading supporters of the campaign as documented in the amicus briefs that Alito cites in his opinion. And in a concurrence in a different case, documenting the anti-Catholic roots of state prohibitions on public aid to sectarian schools, Alito didn't cite a single legislator responsible for the prohibition at issue, and yet was able to make a convincing to him case that the prohibition was the product of bigotry. Alito's attempt to withdraw the court from the field of abortion-related conflict will also fail. Prenatal constitutional personhood has always been a prominent constitutional position within the pro-life movement. Dobbs doesn't embrace fetal personhood, but Alito's prenatal life distinction invites pro-life arguments that the Constitution protects prenatal life. Pro-life legal scholars have submitted amicus briefs and published op-eds and essays arguing that the Equal Protection Clause requires states to prohibit abortion and called for Congress to enact prohibitory legislation. And just in the past few days, Republican Senator Lindsey Graham floated a ban on abortion after 15 weeks to the applause of the conservative editors of National Review Online. Nor will reproductive rights advocates cede constitutional ground anytime soon. The view is ascendant on the left that the Supreme Court isn't capable of bringing about transformative social change. But the prescriptions that follow from this critique often involve congressional and executive action that will inevitably end up before the Supreme Court. State conflicts over abortion will generate a range of legal questions. What if an abortion-restricting state seeks to punish a local newspaper for advertising abortion that's available in an abortion-permitting state? The court that decided Roe held this unconstitutional under the First Amendment, but it's an open question whether that precedent will hold up after Dobbs, based as it was on abortion being a constitutional right. State-federal conflicts will also arise. The FDA regulates medication abortion drugs. Are states permitted to regulate a drug more harshly than the FDA? We'll see. Finally, there will be conflicts over other substantive due process rights. Some pro-lifers consider contraceptives that result in the destruction of fertilized eggs to be abortifacients. Is a state's sincere belief that a drug that acts as an abortifacient is enough to justify a prohibition, even if that belief runs against the current scientific consensus about whether it does. It may be hard to imagine the court overturning Obergefell and Lawrence and allowing states to ban marriage between same-sex couples, prohibit same-sex sodomy, same-sex marriage pills pretty well. Then again, so did Roe. So we end where we begin, with constitutional conflict. Roe didn't start it, Dobbs won't finish it. There will be more battles. It's conceivable that the court is aware of and prepared for this. But after Dobbs, it doesn't seem plausible.
Thank you, Evan. I'm sure no one has any questions, but we'll get to that later. Coming up next is Kelly Deneen Gillespie, an associate professor of law and director of the health law program at Creighton University's School of Law, where she teaches healthcare law, bioethics, torts, and public health law seminars. She holds a PhD with distinction in healthcare ethics from St. Louis University before attending law school, and this is a very interesting part of the case she will discuss, and it's in her article. She was a nurse in neurosurgery and transplant ICUs, clinical research, as well as with functional neurosurgeons caring for people with chronic persistent pain. So she's uniquely qualified to talk about RAW in the United States, which deals with prescribing of opioids. Kelly?
All right. Thank you, Trevor, and thanks to Tommy and Katie and everybody at the Cato Institute that put this together and the review. It was my honor to be part of this. I want to start by acknowledging a couple of people. The first is Professor Jennifer Oliva, who is a professor of law at UC Hastings, who was my co-author on two amici briefs we wrote on behalf of professors of health law and policy in this case. And the other person I would like to thank is Dr. Jamie Henderson, who's a functional neurosurgeon now at Stanford, with whom and for whom I had the honor of working in the late 90s and early 2000s, in part taking care of a small cohort of patients with chronic and persistent pain refractory to other medical treatment. Those and other experiences I had at the bedside and in nursing deeply inform the work I do now in a very different place. All right. Drugs always elicit very, very strong, sometimes visceral reactions, so I want to make one disclaimer before I say more. My disclaimer is that, yes, drug poisonings and drug-related harms are among our most serious public health problems in the United States, okay? Where I have deep disagreements are with the public policy responses to these crises, as they are almost never tailored to the underlying goals of decreasing the overall harms related to drugs, okay? And I want to acknowledge, because when I talk about this case, I often am viewed as the person defending the quote-unquote pill mill doctors. I want to acknowledge that there were and will be a very small number of physicians and other authorized prescribers who will use their professional licensure at the state level and their certificate of registration from the Drug Enforcement Agency to engage in a criminal enterprise, okay? To engage as drug dealers, distributors, as conventionally understood, right? And those are the very people that Section 841A1 of the Controlled Substances Act, those are the very people for whom there should be the potential of conviction and the possibility of even lifetime in prison and $1 million in fines, all right? But that number is far smaller than the number of prescribers who have been investigated and prosecuted in recent years as federal law enforcement and some federal judges have transformed, to use a metaphor from this morning, their existing wrenches into hammers to erode the standards for prescriber convictions under Section 841 to the point that at least 3 circuits had transformed a crime written with scienter requirements of knowledge or intent, which did and remain the scienter requirements for laypersons prosecuted under the exact same statutory provision, to a strict liability offense, such that proving that the prescriber, quote unquote, departed from the usual course of professional practice was enough to secure a conviction for this felony offense, full stop. And worse yet, that standard was judged not even by the rigorous standards for determining the standard of care and breach in a civil state tort action, but judged by this sort of amorphous, pseudo-national, general accepted standards of medical practice in the United States, which is very much a quasi-standard of care, and would not, both the evidentiary basis for that and the qualification of experts would not be allowed in state courts. And in our second brief, our brief on the merits, Professor Oliva wrote a beautiful section at the end that details what that would actually look like in Alabama. And it's very persuasive, but I can't take credit for it. Okay. These sort of over-deterring types of responses, in particular the interpretation and erosion of standards under 841, were just one of a myriad of incoherent law and policy responses to the growing awareness of the quote-unquote opioid crisis, which is truly a drug poisoning crisis that really reached the public in a significant way in 2013. But I have argued elsewhere that these responses were part of an availability cascade or a moral panic in which doctors, or so-called bad and undefined term overprescribing doctors, became the folk devils in this moral panic. And these responses were pretty universal in their oversimplicity, but they were also pretty devastating universally in their effects. And the evidence continues to roll in that targeted laws, or laws targeted at the supply only of opioids, in particular prescription opioids, actually increased the death count and drastically increased the number of patients in urgent need of care who had been driven away from doctors and the medical field altogether and into the shadows, which was another repeat of what we saw after the passage of the Harrison Narcotic Tax Act in 1914, where we knew by 1925 at the latest that we had succeeded in not only through this federal action creating the first real illicit underground, drug market, right? But we had succeeded in taking people with addiction out of the medical realm and into the criminal realm. Okay. The effects of such ham-handed legal intrusions into the nuanced area of clinical care have a well-documented history in specializing in overdeterrence, overregulation, and inducing a rush to the safe middle of medical practice, where innovation in care for especially complicated patients, like those with substance use disorder or those with chronic persistent pain, where that dies. Even confusion or mistaken beliefs about what clinical behaviors promise legal scrutiny are powerful drivers of behaviors by clinicians that are adverse to the well-being of their patients, but are self-protective and are rational, right? One need look no further than the aftermath of the state laws that have emerged after Dobbs to see that even in states where certain procedures aren't illegal, right? And that's the argument. No, that's not an illegal procedure. The fear and the uncertainty about the line between lawful and unlawful conduct drives behaviors that are bad for patients. Okay. Criminalization of otherwise appropriate clinical care and patients in need of care always induces harm, and harms that tend to be disproportionately harmful to those who are already in stigmatized, minoritized, and marginalized groups. These are not unintended consequences. They are foreseen and represent a choice about who matters most in society. And with that, I want to turn to just the language of the statute in the opinion. Okay. So the Controlled Substances Act, passed in 1970, was an attempt to marry a whole diversity of drug laws and bring them under one umbrella under the authority of the Department of Justice, what is now the Department of Justice. And along with efforts to control the legitimate and illegitimate supply of drugs, these efforts included explicit findings in the legislation that patients in need of care were not getting it under the previous regimes. And so there were, at least initially, real efforts to try and bring people back into the fold, right? And one provision of the Comprehensive Drug Abuse and Prevention and Control Act, the Controlled Substances Act, starts with the finding that many of the drugs that are so-called controlled substances, which this act created, this schedule of controlled substances, have legitimate and useful medical purposes. This is the first line, okay? So Congress expresses that they have concerns about making sure people still get care. Okay. So Section 841 says, in relevant part, except as authorized, comma, it shall be unlawful for any person knowingly or intentionally to distribute a controlled substance. That is the language of the statute under which prescribers are prosecuted, just like anyone else is prosecuted for drug distribution. And yet, under the language of that statute, at least 3 circuits had removed knowing and intentionally from the law. But we have to know what authorized means, and of course that's not clearly defined, so that definition has to be sort of cobbled together from an array of statutory provisions and regulations, and there is one main regulation that is foundational to these cases, which is the effective prescription regulation, which requires that a practitioner prescribe a controlled substance for a legitimate medical purpose in the usual course of professional practice, okay? A legitimate medical purpose in the usual course of professional practices. And so for the first 30 to 40 years of the Act, the circuits generally applied this law with what we called in our first brief a sort of shaky consensus among the circuits, right? But they all included a mens rea, right? They had some version of the good faith defense that until very recently was seen as, was operated not so much as a defense, but as negating the requisite mens rea, right? And they also interpreted, at least initially, that legitimate medical purpose in the usual course language conjunctively, meaning the government had to prove that the doctor or prescriber had done neither of those, okay? But we start to see, beginning about 2017, to be honest, is this steady erosion in 3 areas. The first is some courts began reading legitimate medical purpose in the usual course disjunctively. And worse yet, most of them chose to interpret that to mean that the government only had to prove that the doctor had knowingly or intentionally departed from the usual course of professional practice, okay? Some of them, including the 10th Circuit, had this strange bifurcation where a subjective good faith belief applied to a departure from legitimate medical purposes, and an objective reasonable belief applied to the usual course departures. So that made prosecution much easier, and of course, most of the time they chose to prosecute under that prong, right? The good faith defense, especially the objective good faith defense, was gutted in the 4th, 10th, and 11th Circuit by collapsing the idea of a reasonable belief into reasonable action, okay? So you only had a good faith belief if your prescriptions were reasonable, which was then interpreted to mean a reasonable prescription was one that hadn't departed from the usual course, right? So it was meaningless. Good faith was meaningless, right? And then in Con, and I feel like this should be a warning to everybody, if your judicial opinion says, unlike all the rest of criminal law, and that's basically what it said, unlike all the rest of criminal law, the mens rea here only applies to the act of writing the prescription. So the good faith defense, right, only negated the idea that you didn't know you were writing a prescription. So you had a defense if you wrote in your sleep or in the midst of, a seizure, right? Because that happens a lot and, it makes sense, right? Okay. And so the court eventually takes the Braun case, consolidates it with Con, and there were a number of questions presented, but at their heart, and we pointed this out, at their heart, they were really aimed at the scienter requirement. Whether you're talking about what the good faith exception means, right? Or whether you're dealing with this issue of putting knowledge into just meaning something about being aware that you're doing something like a volitional act rather than a knowing act. They were about the scienter. And this is where the court, in a unanimous opinion that was kind of crammed in sort of an otherwise busy week, that didn't get a ton of attention, right? Understandably, written by Breyer, focused on that and based its decision not on the federalism concerns, which there are a lot when you're talking about the regulation of medical practice, right? But squarely on the language of the statute and longstanding important principles in criminal law about scienter. And in cases like this, the ability of would-be defendants to know the line between unlawful and lawful behavior, right? Especially when they're engaged in activity in which controlled substances prescribing is part of the everyday good practice of medicine, right? And so there were some procedural questions that went with that, which we can defer to the questions period because I am out of time. And with that, I thank you very much for listening.
Thank you, Kelly. For those who maybe were not completely aware of how things are in the medical practice, I definitely commend her article to you. And the part where she talks about the difficulties of doing that as a nurse and figuring out how much pain medication a patient needs within the bounds of the law while cops are basically practicing medicine. Coming up next is David B. Kopel, who's an adjunct professor at my alma mater, the University of Denver Stern College of Law, my former professor. I was his research assistant. He helped me get the internship at Cato. And he's the reason I do gun policy. I didn't know anything about guns before I didn't even own a gun. There's no one more qualified than Dave to talk about the Bruin case, which dealt with the right to carry a gun. Dave?
Good afternoon. The U.S. Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, in one sense, is fairly narrow in its effects because it directly affects only 3 particular states where the right to bear arms was completely negated: New Jersey, Maryland, and Hawaii. And it also affects parts of 3 other states where the right to arms was respected in some places within the state, but not in others. And those would be California, Massachusetts, and New York. But in addition, Bruin announces a new rule for how a new judicial standard that applies to all gun control laws. And the standard is, and this was based on what the court had done in Heller and McDonald, but lower courts weren't exactly going along with it, as we'll discuss. The gun control laws that are constitutional are the ones that are consistent with the American tradition of the right to keep and bear arms and the lawful regulation thereof. And laws that are not consistent with that tradition are not constitutional. 1 week after Bruin was announced, the court vacated 3 decisions from lower federal courts of appeals that had upheld bans on common rifles or on magazines in laws from Maryland, Connecticut, and New Jersey. And the court remanded those cases to lower court, back to the courts of appeals to reconsider in light of Bruin. And then just a few weeks later, in Colorado, United States District Court, Judge Raymond Moore, who was appointed by President Obama and unanimously confirmed by the Senate, issued a temporary restraining order against a gun and magazine ban that had been enacted by the town of Superior, Colorado, which is within Boulder County. And soon, similar laws, bans in other Boulder municipalities and in the county itself were also brought under temporary restraining orders, and those TROs will remain in effect until January, when there's going to be a hearing on a preliminary injunction motion. And U.S. district courts in other states have also issued some important rulings against the constitutionality of some other gun control laws. What happened in just last June is a big change from what had been judicial torpor in enforcement of the Second Amendment. There was a period of torpor that began after 1939 when the Supreme Court upheld a federal tax and registration system on sawed-off shotguns. And then for decades thereafter, the Second Amendment only appeared in Supreme Court cases in cameo roles, such as in Justice John Marshall Harlan, the second Justice John Marshall Harlan's famous explication of 14th Amendment liberty in Poe versus Ullman. And in 1989, the court began taking some cases that involved the rights of gun owners, but they were always argued and decided on issues other than the Second Amendment. And one of those cases was Prince versus United States. Congress in 1993 had enacted a law requiring background checks for buying handguns in gun stores and had ordered local law enforcement to carry out the check. Sheriffs all over the country sued and said, Congress, if you want to get this done, go hire some federal employees to do it. You can't commandeer us to carry out a congressional statute. The Supreme Court agreed by 5-4 in an opinion by Justice Scalia, joined by Justice Thomas. But in that case, he also concurred to point out that there was a Second Amendment issue in this case, and he suggested that it was time for the court to start addressing that. As he wrote, perhaps at some future date, this court will have the opportunity to determine whether Justice Story was correct when he wrote that the right to bear arms has justly been considered as the palladium of the liberties of a republic. And the court eventually did that 11 years later in the Heller case written by Justice Scalia, and then in 2010, McDonald versus Chicago by Justice Alito held that the Second Amendment is applicable to the states via the 14th Amendment, just as most of the rest of the Bill of Rights is. And then the court went back into torpor. Now, some post-Heller, some lower court judges, including then Judge Brett Kavanaugh of the D.C. Circuit, observed that the Heller decision had been based on text, history, and tradition. And he argued that lower courts should follow that same methodology. But he was in the minority. Most of the lower federal courts post-Heller adopted the test that Justice Breyer had proposed in his dissent in Heller, and which had been specifically repudiated by the Heller majority. Under this approach, judges engage in interest balancing, and then they decide for themselves if an infringement on traditional Second Amendment rights is acceptable. Now, this should have been called the Breyer test, but the courts somewhat euphemistically called it the two-step test or the two-part test. And there certainly were an important number of lower court judges who really conscientiously applied that test. But many others skewed the rules even further so that the government would always win. For example, many adopted a principle that all the government had to do was introduce some evidence in favor of the law, and that would be enough. And the fact that the challenger of the law had also introduced evidence which undercut the government's evidence, that was irrelevant. The Second, Fourth, and Ninth Circuits were particularly egregious. In the Ninth Circuit, there were decisions sometimes before three-judge panels where a Second Amendment litigant would prevail, but then the full circuit would always order an en banc rehearing, even if none of the parties had requested an en banc. And en banc, the government always won. So out of the 50 post-Heller Second Amendment cases decided by the Ninth Circuit, the government won all 50. Now, Justice Breyer's interest balancing test is similar to intermediate scrutiny, but without intermediate scrutiny's sub-rules, so it's all the easier for the government to win. Law professor Alan Rostern, who was a former lawyer for the gun control group Handgun Control Incorporated, accurately called the lower court's behavior Justice Breyer's triumph in the third battle over the Second Amendment. And the Supreme Court, while all this was going on, only took one Second Amendment case. In 2016, they struck down in a per curiam, reversed a Massachusetts ban on stun guns, since the Massachusetts Supreme Judicial Court had been particularly flagrant in thumbing its nose at Heller by upholding the ban based on the fact that stun guns didn't exist in 1791 and they didn't seem to be militia arms, both rationales which the court had expressly repudiated in Heller. And then in 2020, the situation appeared even particularly bleak. The court had granted certiorari in a case involving New York City's rule that licensed handgun owners who live in the city could never take their handgun out of the city, not to a target range in New Jersey, not even to a second home outside the city. And the Second Cert upheld it in a rather brusque manner. Then the Supreme Court granted certiorari. New York City asked for extensions of time, which are common in Supreme Court cases. They used the extension to modify the law, partly giving the plaintiffs some but not all of the relief they had sought. And then, as the merits briefing was going on, 5 Democratic U.S. senators, Sheldon Whitehouse, Mazie Hirono, Richard Blumenthal, Richard Durbin, and Kirsten Gillibrand, sent the court a threat letter in the form of an amicus brief, and they warned that unless the Supreme Court dismissed the case as moot, they would restructure the court. And for whatever reason, 6 justices complied and dismissed it as moot. Justices Alito, Gorsuch, and Thomas dissented, and then a month later, the court dismissed all 10 pending Second Amendment decisions. Justice Barrett joining the court changed everything. And soon the court granted the certiorari in New York State Rifle and Pistol Association versus Bruin. Under New York statutes, an applicant for a concealed carry permit, which is the only way it's lawful to carry in New York, had to have a proper cause. Many jurisdictions in New York said, proper cause could include lawful self-defense, for example, the exercise of constitutional rights. But in many others, such as Rensselaer County, the appellants had to prove a special need for self-protection distinguishable from that of the general community. Well, the opinion in Bruin by Justice Thomas and for 6 justices explained the constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. And therefore, the New York law and its analogs in some other states were unconstitutional. Bruin affirmed that using text, history, and tradition as the basis for a decision is the correct methodology in Second Amendment cases, not interest balancing. In other words, the government has the burden of proof to justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. And as with everything else, judges don't have to be experts in legal history. It's the burdens on the government to come forward with the evidence, and it's not even that burdensome on the government because these days virtually every case where gun control law is challenged, either Michael Bloomberg's Everytown organization or the Giffords Law Center will come in and advise the local government and provide all the historical research possible. Now, Bruin says this tradition can be looked at in two ways. Sometimes the government's going to win because a particular law is very similar to a historic law. For example, laws against reckless discharge that say you can't just shoot off a gun in the air inside a municipality. But the government can also win with analogical reasoning, which means a well-established and representative historical analog, not a historical twin. And this is meant to be neither a regulatory straitjacket nor a regulatory blank check. So the question to ask is whether a modern gun control and its alleged historical analog are relevantly similar. And Bruin says there are at least two things to consider: the how and the why of the regulation's burden on law-abiding citizens' right to armed self-defense. How means whether modern and historical regulations impose a comparable burden on the right of armed self-defense. And why means whether the burden is comparably justified. So, for example, there might have been in the past fire prevention laws regarding the storage of certain quantities of gunpowder, because the black powder of that time was easily ignitable, including by accident. But modern gunpowder, invented in the 1870s and 1880s, is not. And so you couldn't have gunpowder storage restrictions just because you don't like people making their own ammunition at home today with quantity limits that might have been justifiable in, say, 1750 based on fire prevention. So what are some of the permissible controls on bearing arms? Well, as of 1791, carrying a firearm openly was lawful in every state, and so was carrying a firearm concealed. The first state law against concealed carry was enacted by Kentucky. In 1813, the Kentucky Supreme Court held it violated the Kentucky constitutional right to arms. But most other concealed carry laws were upheld in other jurisdictions. Bruin adopts that and says the legislature has discretion to regulate the mode of carry, whether it's open or concealed. Concealed carry was considered sneaky in 1870, but now it's preferable socially. If you went to a shopping mall in any of the 44 states that were already obeying the Second Amendment, you certainly would be encountering people carrying concealed arms. But they're concealed, so nobody gets upset about it. And that's more compliant with modern social standards. Additionally, carrying can be prohibited in what are called sensitive places. Heller had said laws forbidding created a rebuttable presumption in favor of laws forbidding the carrying of firearms in sensitive places such as schools or government buildings. The Bruin opinion, citing a law review article I wrote, added to this list some other historic examples: legislative assemblies, polling places, and courthouses. And so the opinion says, as for new types of places, not old places that already existed, but new types of things, airplanes, rocket ships, among others, that courts can make analogies to those historic sensitive places limits. Now, even though permits weren't needed in 1791, and even though they're not needed today in the majority of states for open carry and in 25 states for concealed carry, Bruin holds that a licensing system can be valid, what's called shall-issue licensing, or like with a driver's license, but stricter and tougher, but you have to meet certain objective criteria. And in Bruin's view, that's perfectly fine, and it would only become a limit if exorbitant fees were charged or there were lengthy waiting times or other abuses of the licensing process. And in terms of how New York's, the ban in some parts of New York on carry lined up against history, the New York Attorney General didn't come close to carrying her burden of proof. There were some examples to cite. For example, after The United Kingdom conquered New Netherland and took it from the Dutch. What we call New Jersey today was two separate colonies, one of which was East Jersey, the part near New York City. And for 8 years, they not only banned concealed carry, they forbid frontiersmen from carrying handguns at all, either openly or concealed. But this solitary example, as Justice Thomas put it, lasting at most 8 years, did not create some tradition. Likewise, for a law enacted in the 1870s in Texas, which banned handgun carrying in most cases, while allowing long gun carrying. And conceitedly, broad restrictions on the right to carry did become more common in the 20th century, as in New York's infamous 1911 Sullivan Act that was at issue in Bruin. But, said the court, as with their late 19th century evidence, the 20th century evidence presented by respondents and their amici does not provide insight into the meaning of the Second Amendment when it contradicts earlier evidence. Justices Kavanaugh and Roberts joined the opinion in full, but also reiterated Heller's sort of safe harbor list of the rebuttable presumption in favor of certain gun controls. Justice Alito also joined, critiqued the dissent's argument, which was a laundry list of all the bad things people do with guns, and said, what does this have, stuff about suicide and mass shootings have to do with licensed, trained adults carrying firearms? And Justice Barrett, in concurrence, pointed to an issue that may become important in the future, but is essentially, as you do Second Amendment originalism, how much does the 14th Amendment period come into play? And she cautioned, as the majority does, of don't put too much weight on restrictions from the late 19th century, because they don't really illuminate the original meaning. Thank you.
Well, we have a little bit of shorter Q&A period here, so I can get to it. I do have the first question actually for Kelly from Twitter. Where's Trey? From Ken Cuccinelli, former Attorney General of the state of Virginia. He asks, in the sentence of your paper, I would appreciate you explaining more detail of innovative pleas, such as in the sentence, in other words, prescribers can no longer be convicted under Section 841 for innovative, mistaken, negligent, or less than careful prescribing. So what do you mean by innovative care?
Well, I mean, anytime doctors are trying to, push the boundary. So, for example, many physicians who take care of people with opioid use disorder have found that the dosage needed to properly treat somebody with a pretty significant opioid use disorder of buprenorphine is much higher, right? That's innovative, right? Their research is ongoing, but the preliminary results are promising, right? But the government can certainly find people to say, gee, that's a very high dose, right? That's a very high dose. So that would be an example of an innovative practice that now that, oh, here we go. All right. How much of that do you want me to repeat?
There you go. Keep going.
Yeah. So there are examples, right, in addiction medicine, for example, with buprenorphine dosing, right, that there is evidence and some preliminary evidence and research ongoing that higher doses are needed, higher than what had previously been considered sort of within the standard of care. But if, say, somebody was prosecuted for that now, reading the opinion, right, the government would have to prove that they actually knew that they were exceeding their authorization, meaning they weren't practicing in the usual course. Whereas it seems quite reasonable that an addiction medicine doctor would say, I have this certain group of patients who only do well on this much higher but innovative dose, right? And so the government might find somebody who, and certainly would, find an expert to say that that was outside the usual course, but now the doctor would be saved by knowledge, right? That they don't think they believe they're practicing legitimate practice of medicine, right, in the usual course.
Thank you. Another one from online for Dave Kopel. Are you aware, or maybe you want to assess the possibility under Bruin, of any challenging the NFA's regulations on SBRs, silencers, regulators? Is there more possibility there post-Bruin? The National Firearms Act.
Yeah, exactly. The National Firearms Act of 1934, which imposes not a prohibition on short-barreled rifles or sound moderators, suppressors. They don't really make a gun silent. You have to pay a $200 tax and go through a registration process that takes months. Yes, it's theoretically possible, and under Bruin, I think there's some good arguments to be made. Nevertheless, I'm not that optimistic about wins on that, because I think at a minimum, courts are going to be comfortable with normal people having normal guns, and that's the big picture. And unless they're convinced that these things are in fact normal, then however good one's arguments, I don't expect victories out of that. I think you can make arguments that they're normal. Sound suppressors are common in lots of European countries, actually often typically sold with a gun because it reduces noise pollution from the neighbor's point of view, and it protects hearing. And short-barreled rifles actually are quite common in Puerto Rico, because the National Firearms Act, which is a tax measure, doesn't apply in Puerto Rico, and they don't seem to be a big problem in Puerto Rico. So the answer is maybe, but don't plan on it soon.
Who's doing my mics? Yeah, okay, Nick, Roger Pawan. Yeah.
Thank you, Trevor.
46 seconds, Roger.
Yes, okay. My question is for Evan Bernick. I quite agree that the opinion of Alito left much to be desired, not least because of its reliance on Glucksberg. But I wonder if you think that the result was right in sending the issue back to the states. And I'd give you this. If a doctor took the life of a baby a day after birth, we would have a clear criminal law case. Well, what's the difference if the doctor took the life of the baby a day before birth, or 2 days, or 3 days, and so on down the line? In other words, we've got a question of when does murder begin. That is a criminal law question properly decided under the state police power, which is exactly the result that we get. And this is a result that was pointed to by no less than Ruth Bader Ginsburg in her Madison lecture in 1992 at NYU. So what say you about the idea that this is properly decided by the states, given that we've got an issue about which reasonable people can have reasonable differences?
I do not think that you can extract from the original meaning of the 14th Amendment a plausible defense of Roe v. Wade. I do think, however, that the idea that states, because they are free to define and punish crimes generally in some reasonable ambits, have anything resembling an unlimited discretion to define and punish crimes however they should choose, is something that is dependent upon premises about the status of prenatal persons under the Constitution in important respects that can't quite be captured by a leave it to the states approach. Let me be a little bit more concrete about that. There is no doubt that compelling people upon pain of incarceration or fines to go through pregnancy and to give birth is an infringement upon their liberty. In order to justify that under the police powers, you are going to need to make a reasonable argument that you are furthering an interest within the proper scope of the state's police powers, the protection of life, liberty, or property. And so the question is, what is the status of a prenatal person? And I don't think that if you left it entirely up to states to decide that, you could get to a police powers doctrine that is limited in scope in any meaningful respect. There's got to be some floor on what states can do. And insofar as that's the case, I think that while Roe is probably indefensible and arguments to defend it on originalist grounds are probably unsuccessful, I regret the degree to which Alito cast this to the states without even intimating that there might be constitutional limits on what they could do in the space of abortion, not even to the extent of Chief Justice Rehnquist's dissent in Roe, in which he said it would doubtless violate the 14th Amendment's ban on irrational government treatment to compel people to give birth even at the risk of their own lives.
All right, we got 1 minute. Professor Amar, I saw you had your hand up. Can you ask a question in 1 minute? And maybe take it up after.
Congratulations to David Kopel for all your work and your triumphs. In principle, analogic reasoning is good but imperfect because no analogies are perfect. Cost-benefit analysis is good but imperfect. Is analogic reasoning sort of in principle better, or is the real problem that the lower courts just weren't taking seriously a kind of serious analysis? There's the question.
I'd say in the First Amendment on freedom of speech, there's plenty of cost-benefit analysis. You know, that's what the strict scrutiny and intermediate scrutiny are. And I think that works out pretty well. You know, I think the state of speech in this country is pretty good. So I think the answer is your other choice, that only some courts were treating the Second Amendment intermediate scrutiny the same way they would treat First Amendment intermediate scrutiny, and too many were just blowing things off and allowing the court to get, allowing governments to get away with anything.
All right, perfect. Great answer. Well, join me in thanking our panel. We will have a 15-minute break, so get some coffee, and then we'll come back with the return of Ilya Shapiro. Can't get rid of him. Walter Olson, Amy Howe, and Amy Saharia. Thank you.
could take your seats, we'd like to start on time. Welcome back to Cato's Constitution Day. My name is Walter Olson. I'm a senior fellow at Cato's Robert A. Levy Center for Constitutional Studies. And you have made it through the day to the fun panel. Traditionally our most popular, traditionally our most fun, in which you get to hear about the upcoming Supreme Court term and hear from some of the top experts that we could line up. Now, the order in which our three panelists will speak varies slightly from the program that you might have seen, and it's reverse alphabetical order. I'm going to introduce the three of them all at once and then take a seat. You might even hear from me later on about one of the cases that the court will be hearing that I've been involved with for Cato. But we're going to start with Ilya Shapiro. Ilya, for us, will always be the one who got away. He is at the Manhattan Institute, where I spent so long in my career. He is now the Director of Constitutional Studies and a senior fellow. However, probably all of you know him for the many years that he spent at the Cato Institute, culminating in succeeding Roger Pilon as being director of Cato's Center for Constitutional Studies. He was publisher of the Cato Supreme Court Review and published 11 volumes of that. He has testified before. Published 4 and edited 11. Okay, you were responsible one way or another for 11 volumes. And how many amicus briefs have any of you filed before the Supreme Court? I'll bet it's quite a few, but I'll bet it hasn't been more than 500. That is the extraordinary accomplishment and distinction that Ilya has here. He is associated with many other nonprofit institutions, and he is the author of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, out in 2020, and a book that continues to do very well. And he's on TV all the time. Now, Amy Mason Saharia is with Williams & Connolly, where she focuses her practice on appellate litigation, including high-stakes appeals in the U.S. Supreme Court. And she has argued in the U.S. Supreme Court, filed dozens of briefs in the Supreme Court and appellate courts nationwide. From 2010 to 2011, Amy Saharia clerked for Justice Sonia Sotomayor on the U.S. Supreme Court. Amy Howe, and I'm going to try not to just use first names a lot this afternoon. Amy Howe is known to a great many of you for her work at SCOTUS blog, where she served as editor and reporter for many years and continues to contribute articles that I read all the time there. She also argues before the Supreme Court and other tribunals. She served as counsel in over 24 merits cases at the Supreme Court and argued 2 cases there. She has co-taught courses in Supreme Court litigation at both Stanford Law School and Harvard Law School. And she holds a law degree from right here in DC at Georgetown University. So Ilya, start us off, please.
Great. Thanks very much, Wally. It's wonderful to be back here. I think this is my first time in the building since I left in January, but it'll always have a special place in my heart because I actually got married at Cato and had the reception right here in this room. Trevor, where are you? Is Trevor not in the room right now? Well, he made a joke at his opening remarks about his 4 volumes that he's now edited, which is great. That means he's done over a third of what I did. So even if his longevity at Cato beats mine, I hope I can still remain the Federer to his Nadal or Djokovic, having won the most Wimbledons, and hopefully put out the record for editing the review that Trevor won't reach. And finally, Wally, you missed out. You left out an interesting part of my biography. You know, my recent stint in higher education, and I realized that I had to maintain credibility with this audience, I had to leave Georgetown and resume a more legitimate position with Manhattan. So anyway, look, last term, as you've heard all day, this is not a case, a term where, I do a lot of Supreme Court reviews, and some years you kind of have to put lipstick on a pig and try to make sexy some bankruptcy or ERISA or tax cases or something. Didn't have to do that last term. Some on the left especially are concerned that there's a reversal of the Warren Court's civil rights gains of the 60s, but really what we're seeing is a stripping of Warren Burger's gaudy legal wallpaper of the 1970s. These are glasses from last night's Competitive Enterprise Institute Gala, always a good time. It had a 70s theme. But really, that's, I think, what's going on, and that leads me into the first case that I'm covering, which is the Harvard and UNC affirmative action case. Because if I'm right that the court is really reversing the excesses of the Burger Court, not the Warren Court, well then the next precedent from the 70s in the crosshairs is Bakke versus Regents, which in 1979 established our modern jurisprudence regarding affirmative action, regarding racial preferences in higher education. And this was an unusual case in that 4 justices said that you cannot use race as a criterion for college admissions. 4 justices says absolutely you can use race however you like to remedy past wrongs. And 1 justice, Lewis Powell, the deciding vote, said, well, neither of these is right. I think diversity, but Powell says diversity is a compelling government interest, but race can only be one of many factors to achieve this compelling interest in educational diversity. And so on that 1 justice's opinion was this whole edifice that has now borne the rotten fruit of DEI bureaucracies was born. And so now, more than 40 years later from Bakke, we have a challenge to the oldest public and oldest private university in the country, Harvard and UNC, using race. How? Well, we don't know. That's part of the problem. There's this black box with a so-called holistic review. But it sure seems like, based on the statistics and based on how much harder it is, depending on your race, to get in at the equivalent level of resume, whether a GPA or SATs or extracurriculars and what have you, and especially among Asian Americans who are the plaintiffs, or at least the theory on which this challenge is brought by an organization called Students for Fair Admissions. And they say that it's, in Harvard, for example, that the intangible score, the personality score of Asian American applicants was downgraded on purpose so that they could be rejected even if they're more qualified than others, et cetera, et cetera. And so the question is, after the Supreme Court in 2003 expanded upon that 1 vote and had 5 votes to allow the consideration of race as one among many non-determinative factors, but not strict quotas or other mechanical point systems, will the court overturn that kind of Grutter allowance? And I think it's good that after initially taking up the Harvard case, the court added the UNC case, because all of the previous modern jurisprudence, starting with Bakke and UC Davis, then Grutter and Gratz with Michigan, and then the UT Austin cases, involved public institutions. Now, under current jurisprudence, there is no difference between public institutions and private ones that take federal educational funding under Title VI. And I don't think this case is going to differentiate. This is not about the treatment of, private institutions taking public funds versus the direct constitutional application of the 14th Amendment. Nevertheless, it's a 4-square, full-on challenge to the use of race in admissions, and indeed potentially to the idea of educational diversity being a compelling interest that allows the use of race which in other contexts may not be. And this is one area where, if you had to bet, you would think that the Harvard case would end up 6-2 with the new Justice Jackson recused, and the UNC case ending up 6-3. This is not an area where Chief Justice Roberts, who's seen as the most gettable vote for progressives, is squishy. He, after all, was the one who, in a 2007 school busing case, famously wrote, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." And in his very first term on the court, he said, "It's a sordid business, this divvying us up by race." So it's still possible that there could be some sort of compromise, middle ground to pillory Harvard, but salvage the diversity rationale for the racialist shenanigans that we see all across higher education. But depending on what Justices Kavanaugh and Barrett do. But I wouldn't bet on that. The more likely thing is that if they overturned Roe, I think they're equally likely to overturn Bakke. Now, moving from the most important, or the highest profile case of the term, to the very first case of the term. That first Monday in October, the court takes up Sackett versus EPA. If that rings a bell, it's because there was a Sackett versus EPA 10 years ago. That's how long some of these cases last. This is a property rights / environmental regulation case under the Clean Water Act involving an Idaho couple who's been prohibited from building a home on their property because their lot allegedly contains wetlands that qualify as navigable waters under the Clean Water Act. Now, the problem is the standard for what navigable waters means under the Clean Water Act is unclear, and again depends on one justice from a fractured Supreme Court opinion in 2006, a case called Rapanos, where Justice Kennedy did his Kennedy-esque thing and waved his hands, and it was good enough for that, but didn't give much guidance to lower courts. 10 years ago, the Supreme Court unanimously agreed that the Sacketts could bring their lawsuit, could challenge certain administrative compliance orders that stopped the construction, stopped the development, subject to fines of $75,000 a day. They could challenge that before the EPA took them to court. Well, for a decade later, they've still been going through the court system and it's all stuck on this issue of the definition of navigable water. I won't bore you with the way that the EPA has issued various guidance documents trying to either comply with or sidestep this convoluted test. But presumably the court will now take the opportunity to adopt the test from the four-justice plurality, which would allow wetlands to be regulated only when they themselves have a continuous surface water connection to regulated water. So if you have a puddle on your property and it rains heavily and has a larger puddle, that would not suffice. You actually have to be navigable water, actually has to be navigable water. That's presumably what is going to happen here. Moving from water to pigs. In 2018, California voters approved Proposition 12, a far-reaching law to prevent animal cruelty, requiring all pork, veal, and eggs in the states to satisfy how the animals were raised, how they were confined, etc. Now, California has regulations in lots of industry areas that effectively set the standard nationwide. If you're a car manufacturer, you're not going to have one type of fuel emissions for cars sold in California and another kind for the rest of the country. It sort of sets the standard. Well, this dynamic is particularly egregious for the pork industry, which has very little presence in the state. Only 0.2% of the country's breeding sows are in California. And moreover, the industry is highly integrated in interstate, so you can have cuts that are pigs raised in Illinois, slaughtered in North Carolina, distributed somewhere else, packaged all over the place, and you don't know where any given sausage, not just how it's made, but where it comes from. And the problem is, of course, that the Constitution gives Congress the power to regulate interstate commerce, not the states. But Congress doesn't have any sort of regulatory scheme for this kind that's relevant to this case. And so this raises the issue of the negative or dormant commerce clause, which, trust me, is no sleepy area of law. And it tends to cut across ideological lines. In fact, Justices Thomas and Gorsuch are among the most hostile to claims of the invocation of the negative commerce clause to go against state regulations or extraterritorial applications. You know, with my theme of my 70s glasses, the Dormant Commerce Clause governing standard is this multi-factor balancing test from 1971, the Pike case, which again, I won't go through. It's, you know, undue burden this, and it's unclear, and that's the problem. So I think whoever wins here, and it's very hard to predict, I do predict firmly that there will be a new, clearer standard for evaluating negative Commerce Clause claims. And so Pike's half-century balancing test, which has allowed plenty of lawyers to bring home the bacon, will be retired and replaced by something perhaps that will be a more clear regulation. And finally, the last case I want to talk about is, let's call it Masterpiece Cake Shop Revisited, but without the cake. That is a website designer in Colorado, like Masterpiece Cake Shop was. Remember the cake baker that didn't want to make a custom cake for a same-sex wedding. Was he a free speech martyr or a half-baked bigot? We don't know. The Supreme Court ruled 7-2 that Colorado had displayed anti-religious bias and sort of remanded it and didn't decide any of the pithy issues in what I believe was Justice Kennedy's very last case before he retired. Well, here we have a website designer, so there's no debate over whether there's First Amendment protected expressive activity. This isn't cake baking or floristry. This is website design. And ran afoul, or at least before running afoul, filed a declaratory judgment suit about not wanting to be fined, not wanting to be compelled to create these websites to celebrate same-sex weddings, with which the Laurie Smith, the designer, had religious beliefs against. And the 10th Circuit, curiously, and I think the only example of this kind of reasoning in this type of case, said that the market for any service provider is that particular service provider. That is, Laurie Smith here creates a unique custom product. So the market is not, it's irrelevant that there are other website designers available, what their prices are, how close they are, things like that, because every business owner is its own market. It's remarkable, really. I'll tell you, even if Laurie Smith loses here, which I think is unlikely. I think this court is likely to rule for her. But if she loses, it will not be on the 10th Circuit's rationale, which is just bonkers. But to be clear, the court will only hear the case on the issue of whether compelling someone to speak to comply with anti-discrimination law violates the free speech clause. There are some other issues of free exercise or employment division versus Smith, which I'm sure some of you know about, but not at issue here. Simply about compelling speech in the context of anti-discrimination laws. Now, the court could slice and dice and find another narrow way to avoid resolving the thorny constitutional questions, but again, I don't think, I think almost certainly it'll be a win for Smith, and it will not be a 10th Circuit style analysis. So I think I'll end it there, and let me just say that I, for one, am here for a reversal of the Berger Court.
Okay. Thank you, Ilya. Now we'll hear from Amy Saharia.
Hi, everyone. Thanks for having me. I wish I had some cool props, but I don't, nor do I have any pig puns to offer today. But I do have to offer some thoughts on 3 cases coming up this term. 1 blockbuster, 1 maybe blockbuster, and 1 probably not blockbuster. Let me start with the blockbuster. That's Moore v. Harper. This is the case in which the Supreme Court is going to tell us whether the independent state legislature theory is just a theory or actually a doctrine of constitutional law. The case involves the Constitutional Elections Clause. That clause provides that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. The case comes out of North Carolina. The North Carolina Republican-dominated legislature drew the districts for the 2022 federal election. The state Supreme Court, which is dominated by Democrats, then vacated that redrawing as unconstitutional under the state constitution on the grounds that political gerrymandering violates the state constitution. And the Republican legislators who are defending the redistricting say, under the Elections Clause, the legislature has the exclusive authority to regulate the time, place, and manner of federal elections. State courts, you have no authority to interfere with that activity, and the state constitution just has no application when state legislatures are drawing districts or otherwise regulating federal elections. That is the theory. That's the independent state legislature theory. The Supreme Court has never adopted that theory, but it has been floating around for a while. Justice Rehnquist floated this theory, this reading of the Elections Clause back at the time of Bush v. Gore. The petitioners came to the Supreme Court, said, please stay the decision below so that our original districts can be in place for the election, and the Supreme Court denied that request by a 6-3 vote. Justice Alito wrote the dissenting opinion for himself, Justice Gorsuch, and Justice Thomas, saying, this is really important, and I think they're going to win. We're going to adopt this theory. We should stay the decision below. Justice Kavanaugh wrote a concurring opinion saying, this is a really important issue, but it's just too close to the election for us to interfere, and that's why he voted to deny the stay. So no stay, but then the court grants the petition, and so the case is going to be heard in the fall, maybe December, and what's going to happen? Well, I'm not an expert on this doctrine. In fact, I think we have an expert on the doctrine who's speaking after this panel, but I venture to say that if 4 justices voted to grant the petition, and we know there are 4, the fourth stage, pretty good prediction that they think they have a 5th vote already, that vote likely being Justice Barrett. So I think if you were betting, you would bet we're going to have this doctrine after this term, but it's not totally clear what it's going to look like. There's a very aggressive reading of the doctrine, which would hold that that state courts simply have no authority ever to pass judgment on state regulation of federal elections. State constitution has no role whatsoever to play. There's a kind of a narrower reading that Justice Alito floated in his dissenting opinion at the stay stage, which is when what the legislature is doing is really something that feels like legislating and not just traditional judicial stuff. But in this case, redrawing districts on the ground that they were gerrymandered, that's too much, and that's when this clause has some role to play. So I don't know what it's going to look like, but I think there's a good chance that the court is going to adopt this doctrine and more. So that's the big blockbuster, and it has big consequences for federal elections, not state elections. That this doctrine applies only to federal elections. The second case is Mallory versus Norfolk Southern. This is the court's latest foray into the sexy field of personal jurisdiction. The case involves a plaintiff who is a former employee of Norfolk Southern. Importantly, he lives in Virginia. He claims that Norfolk Southern injured him in Virginia and Ohio, but he brought this suit in Pennsylvania, and that's kind of the crux of the case. Norfolk Southern is not incorporated in Pennsylvania. It's not headquartered in Pennsylvania. So under the kind of traditional personal jurisdiction rules that the Supreme Court has announced in Goodyear and Daimler, Norfolk Southern is not subject to general personal jurisdiction in Pennsylvania. But Pennsylvania has long required corporations to register to do business in the state, and its long-arm statute provides that if you register to do business in the state, you are subject to general personal jurisdiction in the state. So the Pennsylvania courts have construed that to mean you consent. Once you register to do business in Pennsylvania, you consent to jurisdiction in all kinds of cases, whether or not they have any tie to Pennsylvania. The question is whether the Due Process Clause prohibits a state from requiring a corporation to consent to personal jurisdiction to do business in the state. The Pennsylvania Supreme Court said yes, the Due Process Clause does prohibit states from doing that. The Supreme Court has taken a very narrow view of general jurisdiction for corporations in recent years. If they were to rule for the plaintiff in this case, it would essentially undo all of those recent cases and allow states a fairly easy mechanism to unrun those cases and hail companies into their states on any kind of claim, whether or not it has any connection to the state. In the wake of those recent Supreme Court cases, and most notably Daimler, this issue really came to the forefront because a bunch of states had this kind of consent principle. And I think at that time, it was quite obvious to me that the Supreme Court would never allow states to do this. It's a little less obvious to me now. I still think that the company will win, but it's not as clear as it once was. This is a different court. Last year in the Ford case, Justice Gorsuch wrote a quite interesting concurring opinion, which was joined by Justice Thomas, kind of calling on the court to reconsider its personal jurisdiction jurisprudence, calling on the court to kind of go back to an originalist view of what personal jurisdiction was before the time of International Shoe, which is the kind of canonical case in this area. And calling into question the fact that seemingly it's harder to sue corporations than individuals, and asking whether that makes a lot of sense. So I'm really just curious to see what he is going to do in this case in particular. I still think it's likely that the company will win, but it's not as much of a slam dunk as I think it would have been in the prior court. Third case I'll touch on is United States versus Texas. This is a challenge by Texas and Louisiana to federal policy guidelines prioritizing which undocumented immigrants should be arrested and deported. Since the United States can't deport all 11 million of them, the government promulgated some guidelines. Texas and Louisiana sued in district court in Texas, claiming that these guidelines violate federal law. A different coalition of states led by Arizona filed in Ohio district court. The district court in this case held that Texas and Louisiana have standing to challenge these guidelines and that the guidelines violate federal law. And the Fifth Circuit denied to stay the district court's nationwide injunction. At the same time, the Ohio case reaches up to the Sixth Circuit, and in an opinion by Judge Sutton, the Sixth Circuit went the other way. Judge Sutton held that the states had no standing to challenge these guidelines and also ruled against them on the merits. The Solicitor General went to the court on an emergency basis, said, please lift the district court's injunction in Texas, and the Supreme Court denied that request by a 5-4 decision with no reasoning. Interestingly, the 4 dissenters were Justice Sotomayor, Kagan, and Jackson. It was Justice Jackson's first recorded vote on the court, and Justice Barrett was the 4th dissenter, which is not a normal coalition of 5-4. But although the court denied the stay, it construed the motion as a prejudgment cert petition and granted it, meaning the case went immediately from the district court in Texas to the Supreme Court on the merits and jumped over the Fifth Circuit. There's several issues in the case. Because we're here to talk about the Constitution, I'll just highlight the constitutional issue, which is whether Texas and Louisiana have standing to challenge these kind of enforcement guidelines. The theory the district court accepted was that the enforcement of these guidelines will result in more undocumented non-citizens kind of out on the streets in Texas and Louisiana, and that will cause them to incur more money, and it could lead to more crime. The Solicitor General challenges that in its merits brief before the court, and it kind of offers the court an array of different ways it could hold there's no standing. It could hold that when a state sues a federal government, it needs to allege direct injury and not this kind of indirect injury. It could hold that as a kind of general matter, plaintiffs can't challenge enforcement decisions because those are dependent on decisions of third parties. And it just kind of takes on the district court's reasoning on its own and says this is speculative assumptions about what these enforcement guidelines will lead to. I think Judge Sutton's opinion is quite good and offers the court a pretty good roadmap to hold there's no standing here, and it kind of offers the court some pretty narrow grounds on which it could resolve the case. So whether this turns out to kind of have broader implications or narrower implications, I think remains to be seen.
Amy Saria, and we'll hear now from Amy Howe.
Thank you. It's great to be here. And I'm not sure I've ever been on a panel with another Amy before, so this is very exciting.
Another Ilya before.
You have?
I'm going to talk about two cases. One is a blockbuster, one is a little bit lower profile, and then I'm going to look ahead at the September 28th long conference when the justices will meet to map out new cases for the upcoming term. I'm going to start with a case called Reed versus Getz, which involves the statute of limitations and DNA testing. In 2009, in a case called District Attorney's Office versus Osborne, the Supreme Court held that if an inmate has a right under state law to prove his innocence with new DNA evidence, then those procedures for the testing must be fundamentally fair. 2 years later, in a case called Skinner versus Switzer, the court held that inmates can pursue a federal civil rights claim to obtain DNA testing of crime scene evidence. They said they have to show that the state law has denied them their right to due process. So the question before the court in Reed versus Getz is when the statute of limitations to bring that federal civil rights claim starts to run. Does it run when the state trial court rejects your request for DNA testing, or does it run later after the state court appeals process has run its course? The question comes to the court in the case of a Texas inmate, Rodney Reed, who was convicted and sentenced to death in 1998 for the 1996 rape and murder of Stacy Stites. All of this time, Reed has maintained his innocence. He admits that he was in a relationship with Stites, and he suggests that someone else, perhaps her fiance, who was a police officer, may have ultimately been responsible for her rape and murder. So after his federal post-conviction claims had run their course, he tried to have DNA testing conducted on some items that were found in and around Stites' body and her truck, which she often drove. The state trial court turned him down in 2014. The Texas Court of Criminal Appeals, which is the highest state court for criminal cases in Texas, turned him down in April of 2017 and then denied rehearing a couple of months later. So Reed went to court in August of 2019, which would have been timely under the 2-year statute of limitations, which is borrowed from Texas law, for 2 years from when the state criminal court denied rehearing, but too late for anything else. So he went to federal trial court, the court threw him out, and the Fifth Circuit ruled that he had brought his civil rights claim too late, that he should have brought it within 2 years of the trial court's denial of his request in 2014. So he came to the Supreme Court asking the justices to weigh in and asking them to adopt the 11th Circuit's ruling, the 11th Circuit's position, which provides that the statute of limitations for DNA testing only begins to run when all of the state court litigation has run its course, including any appeals. And he says that this state criminal court ruling is the authoritative construction of the state's DNA testing laws, and it didn't exist until then. There is, in terms of sort of why this matters, not just to Reed, but to others in the criminal defense community, there's an amicus brief in his case from a police accountability group that is arguing in favor of the more generous interpretation of the statute of limitations. They say that post-conviction claims for DNA testing are often the only remedy available to people convicted as a result of police mistakes. The Texas District Attorney says that the trial court's 2014 order was an authoritative construction of the statute, but at the very least, even if you go further to the Texas Court of Criminal Appeals, that it was the decision turning him down in April of 2017 that actually interpreted the statute, not the simple order denying rehearing. They also argue that the court has no power to hear the case. The second case I want to discuss is one with which I think many of you will likely be familiar. It's a case called Merrill versus Milligan involving Section 2 of the Voting Rights Act, which bars election practices that result in a denial or abridgment of the right to vote based on race or color. And so under the statute, you establish a violation of Section 2 by showing that under the totality of the circumstances, that elections are not equally open to participation by minorities. The Supreme Court, in a case called Thornburg versus, now is it, I'm going to ask my panelists, is it Jingles? Jingles, okay, because I listened to it on Oyez, and if it was wrong, I was going to have to blame Warren Berger. So, outlined a test for vote dilution. There were 3 conditions for plaintiffs in Section 2 cases to satisfy before you then move on to look at the totality of the circumstances. And I'm not going to outline all 3 of them here, but the focus in this case is on the first one, which is whether the minority group can demonstrate that it's sufficiently large and geographically compact to constitute a majority in a single member district. So that this case, Merrill versus Milligan, is a challenge to the state redistricting map for the House of Representatives that Alabama enacted in 2020. Remember that every time we have a census, we need to draw a new map. So Alabama drew a new map for the House of Representatives. Alabama has 7 districts. Black residents of Alabama are 27% of the population, and the state drew 1 majority-minority district. So the challengers went to federal court. They argue that this plan, and this is voting terminology, packs black voters into 1 district known as District 7, and then cracks the rest of them into multiple districts, diluting their vote. They say that the state should have drawn another majority black district, and that its failure to do so violates Section 2 of the Voting Rights Act. The lower courts agreed with the challengers. They agreed that the new map likely violates the Voting Rights Act. They put the map on hold and ordered the state to draw a new map. So the state went to the Supreme Court this winter, asking them to put the lower court's order on hold. The Supreme Court, by a vote of 5-4, granted that request, put the order that would have required the new maps on hold, and set the case for oral argument in October. So that means that Alabama went forward in the May 2022 primaries with the new map, will go forward in the November 2022 general elections with the new map. The 4 justices the 4 justice group in the dissent yielded 2 separate opinions that staked out different positions on the merits, which give us a good hint as to where this case could be going. Justice Kagan wrote an opinion that was joined by Justices Breyer and Sotomayor, and she said, look, the district court properly applied Section 2 here. I'm not sure why we're putting this case on hold. The Chief Justice, John Roberts, did not join that opinion. He wrote his own. He too would not have granted the request to put the district court's order on hold. He would have allowed the elections to go forward, would have required the elections to go forward using new maps. He said, because it's consistent with current voting rights laws. But, he said, there is uncertainty about what the proper standard is in a vote dilution claim. And so I would allow these elections to go forward, but I would also hear oral argument in this dispute over the maps. Justice Brett Kavanaugh filed a concurring opinion, and he said, in addition to the questions surrounding Section 2, I'm also voting to put this order on hold because of a principle with which many of you, I expect, are familiar, known as the Purcell principle, the idea that federal courts should not interfere in state elections too close to the election. Justice Kagan fired back in her dissent. She said, it's 4 months until the May 2022 primaries. It's 9 months until the general election. This is not too close to the election. Alabama frames the argument before the Supreme Court as whether or not the Voting Rights Act requires Alabama to intentionally create a second majority black district. And there are a couple of different arguments. One of them, a key question under Section 2, it says, is whether or not the political processes are open to all. And to show that a district is not equally open, the plaintiffs would have to show that the districts diverge from race-neutral principles, from a neutrally drawn map. And then the second one is focused on the jingles factor. It's the first jingles factor, the idea that plaintiffs can show that they can draw a geographically compact map. And they say essentially for the first jingles factor, plaintiffs can't draw their alternative maps by prioritizing race. You need to show that you can draw this second majority-minority district using race-neutral principles. A related constitutional argument that they make is that requiring the state to prioritize race when it's drawing its maps is unconstitutional. The challengers are supported by the Biden administration. They stress that the state is very polarized in its voting, and they say that Alabama's argument would drastically upend the court's cases interpreting Section 2, would have a significant effect on majority representation across the country. They say that by requiring plaintiffs to show that a state's plan is not neutrally drawn, the state is effectively imposing an intent requirement that Congress rejected in 1982. And then talking for just a couple of minutes about some of the cases on the long conference. The long conference is kind of reporters' worst nightmare these days because there are thousands of petitions that are before the justices. And it used to be that every time the court had a conference, you'd have to try and figure out what the most likely cases were. But these days, in almost all of the other conferences besides the long conference, the court has very helpfully adopted a practice of only granting review in cases that they have already considered at least one conference. And there are a couple of these that are repeat players that have actually been around since the summer, since before the court took its summer recess. But one of the really interesting ones that I'm following is a case called Gonzalez versus Google. Section 230 of the Communications Decency Act provides that no provider or user of an interactive computer service shall be treated as the publisher of or speaker of information provided by another information content provider. Congress passed this law in 1996 after a New York court held an internet service provider liable for defamatory messages on its message board. 2 years ago, in a statement regarding the denial of certiorari, Justice Clarence Thomas suggested that maybe it was time to revisit Section 230. He said the court should consider whether the text of this increasingly important statute aligns with the current state of immunity enjoyed by internet platforms. So the question that the justices have been asked to decide in the Gonzalez case is whether or not Section 230 protects internet platforms when their algorithms actually target users and recommend content. The lawsuit was filed by the father of a woman who was killed in an ISIS attack in a Paris bistro in 2015, and he says that Google assisted and aided ISIS's recruitments by recommending YouTube videos, ISIS videos, to its users through its algorithms. The Ninth Circuit ruled that Section 230 does in fact protect these recommendations as long as the internet service provider is treating all of the content on its website similarly. But it said, we feel like we're bound by another Ninth Circuit case on this topic, and if we were to decide it with a clean slate, we would in fact rule that Section 230 would not protect a provider's content recommendations. I know you talked about the American Hospital Association versus Becerra case already today. There is a trio of cases all carried over from the previous term involving the Chevron Doctrine. One is called Buffington versus McDonough, the case of an Air Force veteran who is seeking disability benefits. The Federal Circuit, which hears veterans' appeals, he says should have applied a presumption in favor of veterans before finding the laws, in this case, ambiguous. He said, but if you decide that it's ambiguous, you should overrule Chevron. And then there are two cases, Pashian versus Garland and Gun Owners versus Garland, that are challenges to machine gun regulations. They do not ask the court to overrule Chevron directly. The questions in those cases is whether the courts should defer to Chevron when the federal government has affirmatively disavowed Chevron deference, and then whether or not Chevron should apply to statutes like these with criminal law applications. Last term, the Supreme Court in the American Hospital Association case turned down an invitation to overrule Chevron. They essentially ignored it. And so I'm really interested to see what they do with these petitions, either at the petition stage or on the merits. And then we're about to hear a lot about term limits at the Supreme Court, which I'm really looking forward to. There was a Michigan case challenging the constitutionality of term limits for Michigan lawmakers. In a 1992 amendment to the Michigan State Constitution, voters enacted 2 sets of term limits for the state's legislature. For members of the state's House of Representatives, you can serve no more than 3 2-year terms for a total of 6 years. If you're in the Senate, you can serve no more than 2 4-year terms for a total of 8 years. So a group of former state legislators went to the federal court arguing that these term limits violate their First Amendment right to freedom of association and individual expression. The lower courts disagreed with them, and so now it is coming soon to a Supreme Court near us.
Well, thank you to all of our panelists. I'm going to take a couple of minutes to talk about a case that hasn't been mentioned yet, which Cato and I, and for that matter, Ilya, have been involved with, because Ilya was involved back when he was with Cato last fall, and that is Holland versus Burkine on the application of the Indian Child Welfare Act and its constitutionality. And it's a topic that has long troubled the Supreme Court, long interested the Cato Institute for its conflict of rights. The Indian Child Welfare Act, as many of you know, was passed by Congress, which was angry at some of the ways in which state governments had trampled on the rights of parents in Indian tribes, taking away their children without good cause. And it assigns a great deal of power to Indian tribes over questions of child custody. And a lot of that is not terribly controversial, but there are edge cases, particularly involving adoption, in which it has become tremendously controversial. The late Justice Antonin Scalia once said in an interview that a case called Holyfield, an ICWA case, was the most troubling case he had ever had to rule on in his tenure on the court, because the plain meaning of the statute so clearly favored the tribe and its rights, and yet the individuals before him, including not just the infant, but also an Indian couple who wanted the adoption to go through, but could not make it go through because ICWA had taken away their own rights, although they were themselves tribal members, and awarded the rights to their tribe instead. But in that case, Scalia, as he was known to do, upheld the letter of the law at the expense of what he thought was fairness. The issues did not go away, in part because there is this tremendous tension between the general course of Supreme Court rulings on race, which are that government may hardly ever properly take race into account in adjudicating individual rights, and its general course of ruling on Indian law, in which it has said that because of Congress's plenary power over Indian law, that it may always appropriately take into account Indian status. And of course, what makes these in conflict is that largely, though not entirely, eligibility for membership in an Indian tribe is a racial matter. It has to do, in most cases, with blood quantum. That's not the way it works with all tribes, but it is a very typical way in which it works. And so you have had the Supreme Court declaring what are possibly two contradictory things in statutes like ICWA, in which individual rights are made to hinge on not just tribal membership, but in the case of these infants, eligibility for tribal membership, in the case of infants who have never lived in Indian country or in tribal relations, and whose parents may not either. Well, the Supreme Court last dealt with this in 2013 in a case called Adoptive Couple versus Baby Girl, anonymized on both sides of the V. And what they did, you may not be totally surprised to learn, was to duct the constitutional issues using the always handy doctrine of constitutional avoidance, which says that if you can twist yourself into a pretzel to avoid taking on a possible unconstitutionality by interpreting other things just right, it's okay to do that. And Justice Alito, writing for the majority, played kind of fast and loose with some of the statutory language. At least so said Justice Sotomayor in her dissent, and I thought she really had a point, which is that Alito was not taking the most obvious reading of some of the statutory terms, but he was arranging things so as to conjure away the constitutional difficulties by finding a statutory reading that would let the family or the baby, or call it what you will, win. Well, 10 years will have gone by, probably by the time the court decides Holland versus Pukin. And some of you have already guessed that one really big thing that has happened in those 10 years is that Justice Neil Gorsuch has joined the court, who has thought about Indian law with a depth that is seldom matched in justices of the modern era, whose rulings in McGirt and elsewhere have been tremendously influential, and everyone will be, I think, waiting to see how he transforms, because he is likely to transform the court's thinking on Indian law in this area. So that's not the only case that we've heard mentioned that Cato was involved in. In this case, Cato joined a brief filed by the Goldwater Institute of Arizona and the Texas Public Policy Foundation. So with that, I will turn to our panelists and ask if they have any reaction to each other's comments or cases.
One thought occurred to me as Amy was talking about reporters' difficulty with the long conferences. I don't know if you all have considered making a certain pool of your own to divvy up the various cases.
I
guess because you're competing with each other for scoops, I guess it's hard to do.
Yeah, it's an interesting question. I think it may have sort of inertia. I think probably what happens is that everyone has their own approach, both in terms of what cases they think are likely to be taken and then how you would approach them. But it's an interesting idea.
Well, I think we can all accept that SCOTUS blog is the paper of record for these sorts of things. So petitions to watch, it's where to go.
Sure. As a practitioner, we always want our petition to get on petitions to watch, that's for sure.
Is there an antitrust issue? No, I won't raise that.
I guess, can I ask Ilya a question? I'm just like, if you could play out a little bit more what you think a middle ground in the Harvard and UNC cases might look like.
Well, since Harvard and UNC in a different way, this is one way in which you could potentially see different opinions, is such a black box in how they use race. You could see vacating the lower court opinion for factual development of exactly how Harvard uses race. That would be a way to punt the eventual overruling of Bakke, or at least Grutter, into Justice O'Connor's 25-year end of that shot clock. From Grutter, she said, 25 years from now, might not be able to justify this extra constitutional deviation. Well, we're 19 years into that. That's perhaps the most obvious way.
Yeah, I mean, the 25-year sunset is really fascinating to me because it was 2003. My daughter was born in 2003, and she's now a sophomore in college. So, I wonder, I don't think there's any such thing as sort of throwaway lines in Supreme Court opinions, but how seriously do you think the justices will take that?
I don't think anybody on either side of the question takes it seriously.
I have one thought, which was just listening to the various presentations that just struck me how many of the cases that we're talking about first came to the court on the emergency docket. Two of the ones that I discussed did, one of Amy's did. And one thing that we started to see last year, and that I think we continue to see, is the court be more creative in how it deals with this deluge of cases coming on the emergency docket. Obviously, it's received a lot of criticism in recent years about how it resolves those cases, and I think we saw it respond to that criticism implicitly last year by taking cases from that docket and moving them to the merits docket on expedited briefing, for instance, with some of the vaccine cases. And now with the case that I talked about involving the challenge to the immigration guidelines, having the court deny the stay, but then take the case basically from the Fifth Circuit and move it up directly. It's another kind of creative way the court might be thinking about dealing with some of these challenges. I think it's a real challenge for the court to deal with this just deluge of cases.
That's an interesting wrinkle, the difference between the emergency and the regular docket. And I think that difference makes its appearance on, some have called it the 3-3-3 court now, right? The 3 Democratic appointed justices, kind of Alito, Gorsuch, and Thomas on the right, and the other 3 in the center right or middle or something. You don't see that with the main docket. Whether you look statistically, whether you look at the top cases, occasionally Roberts, concurs only in the judgment as in Dobbs, but you don't see a 3-3-3. On the emergency docket, you tend to see more of that. Most recently with the Yeshiva case, where Roberts and Kavanaugh joined the liberals to vacate that stay. I don't know, as we kind of go post-COVID, where at least a third or a half of the at least high-profile emergency docket cases came from, I don't know if that tendency or narrative will continue.
I mean, we are hopefully post-COVID, but then I think we're also coming up on election season, which is another sweet spot for lots of emergency appeals. One of the petitions that I did not have time to talk about in any detail is actually a returnee from the shadow docket, the Biden versus Missouri petition, which about whether or not the Biden administration could impose a vaccine mandate for healthcare workers at federally funded facilities. And the Supreme Court, as Amy said, that was one of the complaints about the shadow docket for a long time. And then all of a sudden we saw, actually, they can fast track cases when they feel like it. And they fast tracked the case, heard oral argument in January, issued a decision, a 5-4 decision in favor of the Biden administration relatively quickly. But now that case has gone back to the lower courts and is back up at the Supreme Court in a petition that I think is scheduled for the long conference.
Will we see them fast-tracking the appeal of former President Trump's legal troubles in South Florida?
I would say in some form or another. It would be hard to imagine that they wouldn't.
And I'll add, if you are trying to keep up with the areas where court doctrine is changing, I would put religious liberty in that category, but perhaps election law counts too. It's really frustrating that it is these emergency cases, an emergency docket on COVID cases, where you have to turn because they simply aren't watched as much by the public, and we know the other problem is they aren't argued in as full-dress a manner. But tracing the development of religious liberty doctrine through the shadow docket cases, you really do see that what a lawyer now has to predict is significantly different than when they last ruled on some of the issues in a full-dress case.
And if I can just add one more thing, again, returning to the shadow docket, the Yeshiva case, which was kind of a roller coaster, and I think will continue to be a roller coaster because initially Justice Sotomayor put the lower court's order on hold and then referred it to the full court, and we got some opinions a couple of days later. And apparently today, since I've been here, Yeshiva has announced that it is putting all of its student groups on hold for now.
Wow. Okay. We are now going to...
of course, with religious liberty, Wally, I don't think any of the panels covered this, but the praying coach case last term, Kennedy versus Bremerton, where Justice Gorsuch, in his majority opinion, announced, oh, by the way, we'd long ago abandoned the Lemon versus Kurtzman test, another 70s throwback, right? And effectively said all the juice had been squeezed out of the lemon, and then we now throw away the rind.
Ooh. Okay. We're going to turn to general questions now, and they will come both from the live audience and from online. Let me say a word about asking a question. If you are one of our online viewers or listeners, you can join the conversation and submit questions on the event webpage or on Facebook, YouTube, or Twitter. Use the hashtag Cato, SCOTUS, Cato SCOTUS. And for those of you in person, we will have a traveling microphone. When the microphone comes to you, please speak, of course, clearly and directly into it so we can all hear the question, but also if you could announce your name and affiliation first. So we have, yes, in back there, first question.
Evan Watkins. My question concerns the Google case in Section 230. The way that you phrased the Ninth Circuit's decision, I want to make sure I understood this. So say, however strict Google was striking down, limiting, censoring videos against American conservatives, if they were not just as strict against, say, the Iranian government, then they would be potentially liable despite 230? Is that the way that it worked out?
The Ninth Circuit in this case held that Google could not be held liable for its recommendations as long as it was treating other recommendations similarly. It said, but if it were up to us without this prior Ninth Circuit precedent, we would hold that Google could be held liable for its recommendations.
Okay, more questions? Sir.
Thank you, Dave Schnarr, FME Law. This is for Ilya, known today also as Amy Shapiro. This question has to do with Dormant Commerce Clause. There are two ways I think this could go, and I'm wondering which direction you think it might. It could be that they'll simply get rid of the Pike test and narrow it to what Scalia wanted, which had to do with looking only for instances of discrimination by one state against another, which has long been held the standard that's applicable. The other is to go the way Justice Thomas has talked about it in terms of trying to put it on privileges and immunities and just get rid of Dormant Commerce Clause altogether. I'm wondering if you had some sense of how that would go.
Well, only Thomas and Gorsuch are cheerleaders of the Privileges or Immunities Clause, although I think this is more about privileges and immunities. I think that's less likely. I think the Scalia route is more likely, but I don't know. I mean, there could be, again, this is very hard to predict because it crosses ideological lines. The statutory preemption cases are also hard to analyze and predict. What about if there's evidence of not discrimination but wanting to interfere with interstate commerce? How do you deal with that? Because there is evidence of that in this case, and in fact, the way that California law operates is Golden State agents are sent all around the country to, visit, inspect agricultural facilities. Clear, the intent and purpose and obvious, consequence of this law is extraterritorial action, at least. So the only thing I'm confident in predicting is that they will replace Pike with something.
Any other comments?
I'm fascinated to see what the court does in that case. I just think that the justices' policy preferences are so in conflict with what they think about the Dormant Commerce Clause, and we were just subjected to a very strident lecture that we don't read things in the Constitution that are not there, and the Dormant Commerce Clause is not in the Constitution. So I'm just really interested to see how that sorts out.
Okay. More questions? Yes, far table there.
Hello, Philip Bohai from AFSA, American Financial Services Association. I'd like to shift your attention for a moment to the Supreme Court confirmation process. So in the past, we've always had the theater of speeches regarding stare decisis and assertions about the importance of precedents. And I think that in the common understanding in the culture right now, Dobbs has kind of maybe torn the veil away from that to some degree. I'd like to ask your thoughts regarding whether the next few Supreme Court confirmation efforts and processes will have a different set of conversations about precedent, about stare decisis, and about what the candidates may or may not do.
Well, I'll go first since I wrote a book about judicial confirmation battles, now available in an updated paperback edition. So, Supreme Disorder. So this could go one of two ways, right? Overturning Roe kind of ends, in a certain sense, the distortion that Roe caused, and we've only seen two justices consistent on stare decisis. Justice Thomas always votes to overturn when he thinks something's wrong. Justice Kagan never votes to overturn even when she thinks something's wrong. The others have, every which way. Not saying that they're unprincipled, but just they're not consistent in terms of stare decisis. Will the questions be, more precise? I mean, the candidates know, the nominees know they can't, predict. They can't, as Justice Ginsburg said, no forecasts, no predictions, no hints, and that's right. You don't want to effectively have judges pre-committing to certain views in order to get confirmed. That's not good. Senators can ask, but the ultimate response won't be the same. So it could be that it becomes less of an issue, and we talk about other things, especially 5 years from now, as the reality that Dobbs is here to stay, and I don't know what if Baki's overruled this term, I don't know what the next big precedents are that people are going to focus on, but it could indeed, as you say, ripping this veil off could have the acute political reaction now, but in the medium to long term diffuse at least that aspect of the confirmation battles.
I agree with a lot of that. I mean, I do think that so much of the stare decisis conversation was about Roe and Casey, and that they have been overruled. And, Justice Jackson, I don't know how long we've had Justice Gorsuch, Justice Kavanaugh, Justice Barrett, and then Justice Jackson now since 2017. I don't know when we're going to have the next confirmation hearing. I don't expect to have one anytime soon. And who knows what, as Ilya says, what the next thing is going to be. Is it going to be Obergefell? Is it going to be Griswold? I'm going to push back a little bit on the Ginsburg rule, the no hints, no forecasts. I mean, Justice Ginsburg in her confirmation hearing actually said a fair amount about her views on various positions. I do wonder whether we will see more, as you suggest, more targeted questions from the senators, more follow-up questions. Okay, so this case is settled precedent, but the Supreme Court can overrule settled precedent. Sort of playing out a little bit more, or whether everything that has been said can be said on that topic by a nominee has already been said.
Yeah, it's hard for me to see a real change. I mean, the senators can ask more targeted questions, but I think the answers are still going to be the same non-answers, and I don't see that changing.
Yeah, it's hard for me to see senators' characters changing or the interest group pressures on them, which helps determine their behavior. Okay, thank you. In front, Ilya Sohman.
At the Ilya Sohman, George Mason University. At the risk of contributing to Ilya confusion, I'm going to ask a question that, in the first instance, maybe to the other Ilya, but I'd be interested in anyone else's thoughts on who cares to opine. Ilya, you said that in the Harvard and UNC affirmative action case, there could be just an overruling of Grutter, which would also have to be an overruling of the Fisher II case as well, but there could also be a compromise. I was wondering, do you think it's possible that what they could say is that diversity is still a compelling state interest, at least in the higher education setting, that could justify racial preferences, but we're going to impose really strict scrutiny on it. We're not going to defer in any way to the educational judgment of the university. We're going to require them to actually explain how you determine which groups are underrepresented and what educational benefits they provide, and why Asian Americans are disfavored if they are, and so on. But that could be a way that they could strike down the Harvard or the UNC programs, or perhaps both, but also not eliminate two precedents. Do you think that's a likely possibility? Do you think it's more likely that Grutter and Fisher II will be overruled, or I suppose there could be some other option besides those two?
I think this is, you get the Amy, that goes to Amy's question about other potential compromises. She's getting the Ilya tag team here. I think that is a possible compromise, that they, in effect, I don't know if it's overruling Fisher, but like taking Fisher I more seriously, because it did seem like there were teeth in, don't defer to educational administrators and all of that, and then they sort of kind of got too tired by the time Fisher II came along and just let it slide. Grutter, in effect, elaborated on Bakke and said, you can use race as one of many factors for this diversity interest that Bakke established. And Fisher 1, I think, was supposed to put teeth into that. So it is possible that they don't overrule Grutter, but they say we really do have to scrutinize, which would, I think, entail sending the case back for more fact-finding, or maybe not. Maybe the record is just so overwhelmingly developed and the statistical inferences so strong, and that they can rule against Harvard without and UNC without overturning Grutter. A more interesting or perhaps nuanced question is, would it be possible to overturn Grutter but not Bakke? And that I have a hard time seeing, just because Grutter got it wrong with one factor among many, non-determinative, but diversity is still compelling. Well, what do you put in its place? I have a hard time seeing that. So I do think there could be some sort of muddled compromise, but if Grutter goes, then I think Bakke goes along with it.
Okay. More questions? Yes, Professor Amar.
Akil Amar. Here's another possible split decision. I'd love to hear all the panelists' thoughts and have the people in this room think about it, because this is an organization that very much respects private choices. Why should the rules for affirmative action be the same for public universities and private? Roger Peelan is shaking and nodding his head. Private universities. Maybe charities must act charitably, and so we shouldn't allow, one could say, this goes back to Bob Jones, that private universities shouldn't be allowed to discriminate against historically underrepresented groups. One could take that position and yet say public universities have to be colorblind, the John Roberts approach, but private charitable organizations should be allowed to take race into account, not just for diversity, but for remedies and all the rest, if they're trying to improve the representation of historically underrepresented groups, given history of exclusion in America. Why shouldn't that be a sensible approach and reinterpret Title VI?
Could I add to that? Excuse me. That's
apparently
exactly
you're going
the position. That's exactly the position we took in the Army recruiter case. What was? That's right. Yeah, that's exactly the position we took there.
And though I can't quite speak for Cato, I will say that exactly the point being made here has a lot of people at Cato who immediately begin nodding their head, because I see no reason myself why the Harvard case should turn out the same way as the University of North Carolina case. They could turn out completely differently, and that might be the best resolution.
They'd have to call.
What is the rationale for treating them the same? I actually don't.
There's jurisprudence that says that imputes 14th Amendment standards into the strings attached to Title VI. But they would have to call for further briefing on it, because that issue has not been briefed at all.
Any other comments? Okay. We have time for maybe one more question. I see Professor Adler over at the end there.
Jonathan Adler. So I guess a follow-up on that. If the court was inclined to go in the direction of treating public and private universities differently for purposes of affirmative action, doesn't the court then have to wrestle with the question of statutory stare decisis? Because part of the reason for that equivalence is not a constitutional holding, but a statutory holding as to what the meaning of the Civil Rights Act is. And even though, as a textual matter, one could argue that the court misinterpreted the statute, as a general matter, the court doesn't like to revisit or reconsider prior holdings as to the meaning of statutes.
Correct.
Good point, and that was a fast enough question that if someone else has a lightning round question, we have 3 minutes left. If I don't see any.
I'm just glad you didn't ask about the Clean Water Act, John, because I think I exhausted my knowledge of it in my presentation.
Okay. I don't see any other questions, but let me just say With 2 minutes left to go, please do not go anywhere. Do not rise from your seats. This program will be followed immediately by the annual B. Kenneth Simon Lecture. They will be refreshing the stage for that, but there will not be a general break for coffee or anything. So please stay where you are. Thank you for your attention, and thank you especially to our wonderful panel.
These are just the books of his that were in my office. Now, the top two were handmaidens of me in law school, the Bill of Rights and American Constitutional Biography. Now, except for maybe Marty Katz, who was my con law professor, who was a Yale grad, and Erwin Chemerinsky's Horn Book, and Roger Pallon, I think Professor Amar, unbeknownst to him, taught me more about constitutional law and history than anyone else on the planet. So I'm very, very excited to have him here. I gotta get his new book, which is available for sale here, which he clearly dashed off in an afternoon, is The Words That Made Us, America's Constitutional Conversation, 1760 to 1840. Now, his bio is long, but I will give an idea of where he comes from. He's the Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law in both Yale College and Yale Law School. After graduating from Yale College summa cum laude in 1980 and from Yale Law School in 1984 and clerking for Judge, then later Justice Stephen Breyer, he joined the Yale faculty at 1985 at the age of 26. is very impressive. He is Yale's only currently active professor to have won the university's unofficial Triple Crown, batting average, Sterling Chair for Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. His work has won awards from both the American Bar Association and the Federalist Society, and he's been cited by the Supreme Court justices across the spectrum in over 45 cases, but not enough, right? There should have been some more, I agree with that. Tops among scholars under the age of 65. He regularly testifies before Congress at the invitation of both parties, and in surveys of judicial citations and or scholarly citations, he typically ranks among America's 5 most cited and mid-career legal scholars. He's the author of more than 100 law review articles and several books. As I've said, one is on sale here. And he's recently launched a weekly podcast, which I do, which isn't as easy as some people might think. America's Constitution. I see what you did there. That's very clever. Please join me in welcoming Professor Akil Amar.
It's such an honor to be with you, and I have had so much fun today. Amazing, and I've learned a lot, and I hope I've made some new friends. So thank you so much. Very kind of you to invite me. Yes, today's talk is entitled Term Limits / Time Rules for Future Justices, 18 Arguments for 18 Years. And there'll be a lot of time afterwards for your comments and questions. So start thinking about possible pushback or helpful suggestions. In a bipartisan op-ed published in the Washington Post on August 9th, 2002, Stephen G. Calabrese, the co-founder and co-chair of the Federalist Society, and I floated the idea that each justice should do 18 years of full and active service on the court and should thereafter have a different portfolio of judicial responsibilities. The bipartisan co-authorship of this 2002 op-ed was purposeful. The 18-year idea was then and remains today neither left nor right, neither blue nor red. I was then and remain today a mainstream Democrat, and Steve was then and remains today a mainstream Republican. For example, in 2000, I voted for Al Gore, whereas Steve voted for George W. Bush. In 2016, I voted for Hillary Clinton, Steve for Donald Trump. When I first publicly embraced the 18-year idea, a Republican sat in the White House, Republicans controlled the House, and the Senate was almost evenly divided. Today, the partisan alignment is almost exactly the opposite. A Democrat sits in the White House, Democrats control the House, and the Senate is almost evenly divided. Yet I still consider the 18-year idea a good one. Indeed, in the 2 decades since I began mulling the 18-year idea, I've become even more persuaded that the root idea is a good one. I've over time tweaked and modified various details of my envisioned reform, but I remain convinced that some version of the 18-year idea can and should be embraced by Congress in a simple statute. Ideally, the statute should itself be bipartisan, drawing support from leaders of both parties and featuring a proper phase-in that respects the settled expectations of the current justices and avoids any appearance of a partisan grab reminiscent of the Midnight Judges Act of 1801. At the end of this lecture, I shall share with you the nuts and bolts of my proposed statute, detailing how my 18-year idea might best be implemented in a fashion that I believe would be an entirely constitutional exercise of congressional power to structure the court pursuant to Congress's explicit power under the Article I Necessary and Proper Clause. And just as an aside, I'm envisioning, in effect, a purely prospective phase-in. So temporarily, the number of justices will increase until it settles back down. So this is emphatically not a throw Clarence from the train proposal to accelerate and force the retirement of the most senior justices. That's just an aside. You'll hear the details. That clause, that is the necessary and proper clause, of course, vests Congress with authority to pass proper laws implementing powers vested by the Constitution in, quote, the government of the United States or in any department or officer thereof, unquote. Ever since the founding, Congress has used this clause to properly prescribe the size and shape of various executive departments, the powers and duties of various executive officers, the size, shape, and responsibility of the Supreme Court, the powers and duties of Supreme Court members, both in active service and after voluntary retirement from active service, both in active service and after voluntary retirement from active service, the rules of procedure and evidence operative in the Supreme Court, the timing of Supreme Court sittings, and myriad other matters of similar scope. In perfect harmony with this well-settled pattern of congressional legislation, Congress should, in the near future, properly prescribe a lifetime duty roster for Supreme Court justices. A quick note on terminology. My specific 18-year idea and its close cousins, that is, variations of this idea that have been embraced in recent years by a wide range of legal scholars across the political spectrum, have often been described as proposals for term limits for justices. Indeed, I myself have frequently used this phraseology and may well lapse into this locution in informal future conversations. Nevertheless, my proposal is strictly speaking not a limit on the official term of any given justice. Each justice is entitled under the Constitution to serve a life term in the federal judiciary, to serve during good behavior, to use a more technical formulation, and I do not propose otherwise. Each justice is entitled to be paid for life/good behavior, and I do not propose otherwise. Each justice is allowed to claim the official title of Supreme Court Justice for life/good behavior, and I do not propose otherwise. I simply propose that we modify the manner in which each justice serves on the court for life/good behavior. Put differently, my proposal merely modifies, and in a purely prospective way, the duty roster accompanying the official office of Supreme Court Justice. Indeed, given that the gist of my plan is purely prospective, it is in effect merely a mechanism by which future justices bindingly announce their retirements long in advance. Not, say, 18 weeks in advance, a la Stephen Breyer, but 18 years in advance in the very process of joining the court. You just heard in the last panel questions about the confirmation hearings. And in effect, going forward, in the confirmation hearing itself, people would commit to and accept the idea that they'll serve for 18 years and then transition to a slightly different set of Supreme Court responsibilities. Under my proposed federal statute, each justice in the process of being commissioned would agree that he or she will be a justice in active service, a member of the court's front bench, so to speak, with the same basic responsibilities as a typical justice in the system today for 18 years. Thereafter, each justice would serve in a relaxed service capacity with a different set of daily Supreme Court responsibilities, including, but not limited to, the responsibilities of current retired justices under 28 U.S.C. Section 294. A relaxed service justice, whom we might also call an emeritus justice, would not routinely sit with active service justices en banc, but would be available to do so in cases where the court is short-staffed, when, because of death or illness or resignation or accusal or the like, 9 active service justices are not available for service. We just heard about, for example, Justice Ketanji Brown Jackson's likely recusal in the Harvard case. An emeritus justice would devote most of her daily attention to court-related administrative, ceremonial, education, public relations, circuit writing, and docket management functions, following a more detailed set of rules to be promulgated and from time to time revised by the active service justices themselves. Strictly speaking, perhaps we should call my idea not term limits, but time rules. In its ultimate constitutional logic, my proposal is broadly analogous to a hypothetical statute, providing that no justice should speak for more than, say, 5 minutes in any hour-long oral argument. This hypothetical oral argument law is also best understood as not as a term limit, but as a time rule. And here, I think, in particular, Justice Scalia, in the so-called line item veto case, Clinton versus City of New York, where he in dissent said, actually, technically it's not really a line item veto, and the justices were just being, quote, faked out by the label. And so when people hear term limits, they immediately say, well, that's unconstitutional, but it's really, the label that's misleading, so maybe we should call them time rules rather than term limits. 18 arguments. In the April 28th, 2021 episode of my free weekly podcast with Dr. Andrew Lipka, America's Constitution, I listed 18 different reasons supporting my particular version of the idea of 18 years of active court service, followed by a lifetime of relaxed court service. So just as an aside, it's free on this podcast. You can find it all sorts of places. Just Google Akil Amar podcast. It's available on a website that I have that also has all sorts of free materials uploaded, links to articles and books and all sorts of other stuff. There are about 90 episodes in all now, so you can binge listen if you like. It took us a long time, my wife and I, to finally get the kids out of the house, and so we're discovering only recently like amazing things like The Crown, and so we're going back and binge listening to all sorts of binge watching all sorts of past episodes, and I do recommend The Crown. It puts in context some of the stuff that's happening now with Charles and Camilla. But if you listen to it, again, it's free, it's weekly, and you like it, you can go all the way back, 90 episodes once a week, about an hour and a half an episode. Here in brief were my 18 arguments for 18 years. 1, the status quo of lifetime active service, when combined with a partisan arms race, encourages each of our 2 major political parties to appoint unduly young and unseasoned jurists to the court in the hopes of entrenching the party vision on the court for as many years as possible. So each one wants to go younger and younger. 2, at the other end of the life cycle, the status quo allows for full service of justices who are too old, whose arteries have literally hardened, and who are not at their prime. Historically, most justices have not done their best work in their superannuated years. There are, of course, exceptions. My friends, of course. I'm going to say, oh, you're the exception. But just on average, that's the average. 3, so we have a problem with too young and too old today. 3, the current system creates the possibility of too long a time lag between initial appointment and current judgment. The most senior active justices may be wildly out of touch with the nation's evolving mood because these justices were appointed long ago, even if they're still relatively young and spry and their arteries have not hardened. This time lag is particularly problematic for younger Americans who were not even voters when many current justices were selected. Many of America's younger generation lack a close emotional connection to the court, in part perhaps because of the long time lag. And I see this in my classes, with my students, undergrads and law students. The reform statute caps this time lag at 18 years for the court's most important function, decision-making in en banc cases. 4, the current system enables justices to strategically and politically time their resignations. This is a less attractive model of judicial independence. Currently, some justices act politically when they time their exits. 5, 18 is a magic number, enabling regular and steady replacement a la the Senate. The Senate's staggered replenishment system adds a new third every 2 years. The 18-year active service plan adds a new 9th every 2 years. 6, 18 is a magic number in a second and distinct way. Appointment power is regularized and smoothed across the presidencies and across quadrennial presidential elections. Each president can count on 2 appointments, and this smoothing makes replenishment less arbitrary, random, and capricious, again on the model of Senate replenishment. Relatedly, regular replenishment of the front bench makes it easier for voters to think about the court's future every presidential election without awkward and indeed ghoulish speculation about the life expectancies and health prognoses of individual sitting justices. I feel this as a commentator when they say, when you heard it from Amy Howe, because we had 4 pretty recently, we're less likely to get an appointment anytime soon. She's implicitly trading on all sorts of actuarial assumptions about the age of the current justices and who's going to get cancer next, and because you can't talk about that openly, so you either don't talk about it at all, or you have these euphemisms, and now we can openly say, well, in the next presidential term, seat 3 and seat 7 are going to come up for replenishment, and that's just, we can have a more grown-up democratic conversation without this awkward, ghoulish speculation. 8, shortened terms of active service will reduce the stakes and the temperature of currently overheated court confirmation battles. So if it's about 40 years on the court, people are going to fight more fiercely than if it's about only 18. 9, shortened terms of active service will increase judicial humility. 10, replenishment every odd year regularizes appointments within each presidential term, with half of the active service justices chosen pre-midterm and half post-midterm. So I'm imagining actually appointments in years 1 and 3 in a typical presidential term. The opening up of vacancies in odd years further reduces the political temperature of court confirmation battles by staging these battles in non-election years. That's the least superheated times you're going to have in our cycle. 11, an 18-year cap on active service brings the U.S. Supreme Court model into closer alignment with the most admirable state Supreme Court systems, almost none of which features active service for life. The federal government can and should learn from the lessons of states, the proverbial laboratories of American democratic experimentation. This is a Brandeisian point, you see. 12, ditto on the comparative international front. Almost no other modern democracy in the world has a lifetime model of active service for its apex court. America as a whole can learn from the experiences of the world's other notable democracies. And here I'm not taking a position on Supreme Court cases borrowing from other societies. I'm saying that when we're passing laws or thinking about amendments, we as a society can look to see what Italy, France, India, Germany, England, Israel, and so on do. 13, unlike current reform proposals to pack the court, the 18-year proposal is not partisan and is unlikely to spiral out of control when party control shifts in Washington, D.C. at some future point. So I think, of course, court packing, if we tried to do it today, the Dems add 6, and then when the Republicans are in control, they add 16, and then the Dems add 26, and this won't happen. In fact, 18 will solidify because of its magic relationship to 9, the current number 9, and I actually like that. Now, I dropped a footnote here. This is all from my podcast, and here's the footnote. On reflection, this podcast point was a bit of a cheat. I did not identify an improvement on the status quo, which each of these is trying to say 18 arguments that were better than the status quo, but merely an advantage over another widely discussed approach to court reform, namely court packing. But here's a true improvement, which the podcast did not count as a separate virtue. So I'm taking one off the list and adding a new one to the list because, I like the idea of 18 arguments for 18 years. The 18-year proposal minimizes the likelihood of a short-staffed, evenly divided court. Whenever one of the active 9 justices is unavailable, a reduced service emeritus justice can easily pinch hit. And we don't have that now with Ketanji Brown Jackson or with Justice Scalia's death and non-replacement for many months, really almost a year. So that's a distinct virtue. You're always going to have 9. You're going to have a pinch hitter on deck. 14. The 18-year proposal not only eliminates the occasional or regular reality of politically timed retirements, it eliminates the public perception of politics and judicial retirements, a perception that may wrongly exist when Justice X in fact retires nowadays for entirely personal reasons, but a perception that adds to the current public cynicism about the court. So we don't know why Justice Kennedy stepped down when he did. Maybe he had all sorts of good personal reasons for it, but why should he have to tell us all of that? But there's a perception, oh, he did it because he's a Republican and this is on Trump's watch, or what have you. So it's not just about the reality of politically timed resignations, it's about the perception of politics in the resignation decision. 15. Under the 18-year plan, every active justice is slated to serve as Chief Justice in her last 2 years of active service. This, too, evens out power across presidents and eliminates the current lumpiness, giving some presidents, for purely accidental reasons, more power than others to pick the court's chief. So I'm imagining you serve for 16 years as an associate, and in your last 2, you're the chief, which is how a lot of circuits sort of do it. They rotate seniority. 16. Rotation of Chief Justice of the Chief Justiceship equalizes power within the court. Relatedly, associate justices will not have incentives to pander to the president in the hopes of one day being nominated by a president, of course, to become Chief Justice. Even if associate justices never in fact pander, the mere public perception that some justices might well be auditioning to be chief is undesirable. 17. Chief Justices will be those who clearly understand the court, having typically served on the active bench for the previous 16 years, and having received, one would expect, special training by their predecessor Chief Justice. So actually, first 14, you're an associate, next 2, you're sort of a vice chief, and you're going to, and then your last 2, you're chief. And that seems actually kind of sensible, which is how lots of apex courts do it, lots of circuit courts do it. 18. Circuit duty of emeritus justices could help reconnect the Supreme Court with lawyers and judges in the hinterlands, a nice echo of the original vision of the court as implemented by the Judiciary Act of 1789. So those are the 18 reasons, and by the way, I just kind of came up with them in the conversation talking with Andy Lipka. You can listen to the podcast episode, but basically every week, he's a retired ophthalmologist, but he's a smart guy, and he asks me questions, and we just talk. He represents sort of the general audience, so I hope you give the podcast a chance, because actually that's where I came up. I thought I might have 5 or 6 arguments, but we just started talking, and I was able to get up to 18. Okay, here's the last section. But is it constitutional? At the end of this lecture, I'll set forth a more detailed description of my proposed reform package. The details will doubtless prompt specific questions that merit further conversation, so be thinking what you want to ask. For now, let me briefly explain why this proposal is, in my view, easily and obviously constitutional, able to be effectuated by a simple congressional statute and not requiring a constitutional amendment of any sort. As mentioned earlier, the Constitution expressly and purposefully vests Congress with broad power to legislate rules structuring the executive and judicial departments. This power is, of course, not unlimited. Congressional legislation must be proper, and I think people in this room really care a lot about constitutional propriety, and I'm with you all. It must comport with the Constitution's letter and spirit, including the specific letter and spirit of Articles 2 and 3. Consider, for example, 2 hypothetical congressional laws that, in my view, would be constitutionally improper. So I'm going to give you an example of what would be wrong and why. First, imagine a congressional statute purporting to dictate to the court how to construe a particular constitutional provision or how to construe the Constitution in general. Such a law would violate the court's power to say what the law is, to quote Marbury versus Madison, the power, that is, of the court to determine for itself in its own independent judgment what the Constitution in fact means. True, Congress has broad power to dictate to the court how to construe a particular federal statute and how to construe federal statutes generally, but this power is largely derivative of the power to enact federal laws themselves. If a law can be written broadly, how is this different from a law written in rather more ambiguous language, but featuring a clause telling the court to, quote, construe this law broadly? Still, the power of Congress to dictate to the court rules of statutory construction, whether local or global, is not infinite. The court may at times read the Constitution itself to require that certain things must be said very clearly and expressly by Congress via a super clear statement. If the court believes that the Constitution itself requires or invites such a clear statement rule, Congress does not have carte blanche to direct the court to ignore its own constitutional beliefs in deciding the cases that come before it. More generally, Congress surely lacks carte blanche to tell the court how to construe the Constitution, either locally or globally. Congress itself did not create the Constitution, cannot change the Constitution at will by ordinary legislation, and is not the sole master of constitutional meaning. The Congress is, of course, free and indeed obliged to construe the Constitution for itself in many situations, and Congress is also free to express its understanding of constitutional meaning. The court may well choose to give weight to Congress's good faith judgment of constitutional meaning, but Congress cannot, by law, require the court to follow Congress's interpretation of constitutional meaning. This basic principle, deducible from the Constitution's structure, has been reinforced by important rulings of the court itself, most notably the 1871 case of United States versus Clyde. In that case, the justices correctly held that Congress lacked power to dictate to the court the meaning and scope of the president's pardon power under Article 2. So that's one example, and I gave that in part because you're hearing all sorts of, I think, crazy reform suggestions by other folks, and I'm saying, here are examples of things that, no, you can't do by mere statute, and you shouldn't do by constitutional amendment, in fact. Second, imagine a congressional statute purporting to restructure the court's decision-making by forbidding the court to strike down federal legislation unless the court vote is at least 6-3. There are suggestions like this out there in the land, and we've seen them actually over the course of American history. Any statute, and I think they're bad, any statute that gave a jurist brandishing a mere congressional law a weightier vote than a dueling jurist wielding the Constitution would improperly invert the clear prioritization of legal norms established by the Article 6 Supremacy Clause, which of course privileges the Constitution over a mere congressional statute. Put differently, thanks to the letter and spirit of the Supremacy Clause, Congress may pass no law giving any judge who sides against a constitutional claim more weight than a judge who sides with a constitutional claim. And if a law may permissibly require 6 out of 9 Supreme Court votes to disregard a congressional statute as unconstitutional, why not 7 or 8 or even 9 out of 9? Given broad congressional power to resize the court, why couldn't Congress require that every congressional law be strictly followed no matter how constitutionally outrageous, unless 99 out of 99 justices on a packed court unanimously agreed that a given congressional law was flagrantly unconstitutional? At that point, indeed well before that point, judicial review itself would have effectively been eliminated in open defiance of Articles 3 and 6, the Federalist Number 78, Marbury v. Madison, and centuries of constitutional law built on this constitutional bedrock. So in case you missed it, that's why I really don't agree with my friend and colleague Samuel Moyne, who writes stuff like this, and many of my students who are writing stuff like this. But my proposed 18-year time rule is entirely different from improper laws of the sort I've just described. The proposal is deeply respectful of the constitutional principle of judicial independence. Indeed, because this proposal would discourage mature justices from timing their resignations in political or partisan ways, it would instantiate a superior version of independence compared to the status quo. Unlike the law in Clyde, which interfered with powers directly and explicitly vested by the Constitution itself in the office of the president, that was a case about the pardon power, my proposal does no violence to the office of Supreme Court Justice as outlined in the Constitution. The Constitution vests no particular power in any individual judge or justice to hear this case or that one, apart from the power of the Chief Justice to preside at presidential impeachments. My proposal in no way intrudes upon that power, even though it does revise the process by which a given jurist becomes the nation's Chief Justice. My proposal does not retroactively deprive any current member of the court of any vested privilege, and its structure provides the same rules for presence of both parties going forward. Under my proposal, every president henceforth will nominate a new justice in year 1 and year 3 of every presidential term. In addition, the law could provide in veil of ignorance fashion that the new system will not go into effect until after the next presidential election, an election that at present is a toss-up, in the opinion of our best political prognosticators. So this is not a partisan scheme. If you're going to do it behind a pure prospective veil of ignorance, fine by me. In essence, the 18-year time limit would simply be a proper and prospective law structuring and shaping the Supreme Court and the office of Supreme Court Justice, constitutionally indistinguishable from a vast number of earlier and current laws shaping and structuring the Supreme Court, lower federal courts, executive departments, and various Article II and Article III offices. For example, and I'm going to give you about 4 or 5 different analogies, you see, to what this plan is, and then I'll read you the plan. For example, 1. Beginning in 1789, in legislation signed by George Washington himself, Congress has prescribed, and over the ensuing years has from time to time modified, the number of justices, the court's overall jurisdiction, and the duty rosters of various executive and judicial officers. How is the envisioned duty roster at the heart of my 18-year proposal any different as a matter of constitutional principle? Second, notably, the first Congress prescribed when, where, and how the justices should sit en banc, including a rule prescribing that any 4 of the court's initial 6 members would compose a proper quorum for the court's en banc decision. How is it any different if today's Congress says the court's proper en banc composition, as a rule, involves its pre-emeritus justices as distinct from its emeritus justices? Congress likewise, in its earliest statute on the judiciary, the landmark Judiciary Act of 1789, prescribed that the proper duty of a Supreme Court justice was to ride circuit at certain times. Although some modern scholars have raised technical questions about the constitutional propriety of circuit riding, this was an enormous and defining feature of the celebrated Judiciary Act of 1789, enacted by the first Congress, which contained many leading framers and ratifiers of the Constitution, and was signed into law by none other than George Washington. Every early justice, in fact, rode circuit. None openly resisted circuit riding on the grounds that this element of the job was unconstitutional. Circuit riding built squarely on earlier practices and traditions in various states and colonies, and in Britain, traditions of assize courts and nisi prius, in which jurists of a legal regime's highest court sat individually or in smaller groups in courts across the countryside, bringing justice to every man's door. If this system, combining local sittings and centralized en bancs, was good enough for George Washington and James Madison and John Marshall and Joseph Story, it should be good enough for us. Modern scholars who are squeamish on this point should yield to the great weight of early liquidation and utterly settled practice. If the first Congress could say that a given justice must sit en banc in month X and ride circuit in month Y, why cannot today's Congress say that a given justice must sit en banc in years 1 to 18 and ride circuit thereafter? In laws stretching back to the Washington presidency, Congress has likewise prescribed various rules of evidence and procedure to be followed by the Supreme Court and other federal courts. Surely, the 18-year time rule can be understood as structuring the procedure of the court. That is, its basic manner of proceeding and conducting itself, as distinct from its substantive pronouncements of the legal rights and duties of proper litigants who come before the court. If all these other procedural statutes are constitutionally kosher, how is our envisioned term limits/time rule statute decisively different? There is virtually no doubt the Congress could legislate proper rules for Supreme Court ethics, including rules specifying situations requiring recusal. How is a rule prescribing en banc recusal in general for any jurist who's already heard her fair share of en banc cases any different from all sorts of other recusal rules that Congress might properly adopt? Why cannot a rule limiting pre-emeritus front bench service to a fixed number of years be justified as a simple judicial ethics regulation discouraging politically timed and partisanship-tinged retirements? My plan also closely aligns with the recent and current practice for sitting and retired justices. In the mid-1990s, William Rehnquist sat by designation while also serving as chief. So he sat on a lower federal court while also being Chief Justice. Since 1937, at least 11 retired justices have sat by designation, and in effect have ridden circuit per 28 U.S.C. Section 94, to wit, Justices Vandervanter, Reed, Burton, Clark, Stewart, Powell, Brennan, Marshall, White, O'Connor, and Souter. I don't know what Justice Breyer's plan is, by the way. If modern justices can ride circuit after voluntarily retiring, why is it any different if the announcement of their voluntary retirement occurs much earlier in the process, namely in the course of joining the court and simultaneously promise to step off 18 years hence? A final point worth reiterating from my April 28, 2021 podcast is that the 18-year reform proposal would bring the U.S. Supreme Court into closer alignment with some of America's most distinguished state court judiciaries, featuring long fixed terms of active service. State constitutions, of course, differ from the federal constitution in important ways. Still, the wide popularity of state judicial time limits for service is one reassuring factor in support of the basic propriety and common sense of the 18-year proposal. In its deep design, and unlike several other high-profile reform proposals currently in the air, the 18-year proposal is entirely and self-consciously in keeping with the American way. Okay, so here are the nuts and bolts, and I'm going to take 2 minutes to just read the proposed statute and then have at me. Congress should enact language along the following lines. The Supreme Court shall henceforth consist of 4 classes of justices. Legacy justices, that would be like Justice Thomas or the current justices. Regularized justices, replacement justices, and emeritus justices. All legacy, so the regularized are just like the 18-year thing. Replacement is what happens if someone steps off a little bit early or dies early. Emeritus is what you do after 18 years, and legacy are the current ones. So all legacy, regularized, and replacement justices shall be considered justices in active service, and then there are emeritus justices. All justices in active service on the date of this law's enactment are hereby designated legacy justices. Their service, tenure, rights, and responsibilities on the court shall remain unchanged, provided that at any time a legacy justice may elect to take emeritus status by becoming an emeritus justice. Regularized justices shall be eligible to receive good behavior commissions that commence no sooner than July 1, 2023, and every 2 years thereafter. 1 regularized commission per every odd year. And if you don't want to pass it now, just adjust it forward to the next year 1 after the next presidential election. No president may nominate, but it's going to be July 1 in every odd year, odd number year. No president may nominate a regularized justice prior to March 1 of the commissioning year. So you nominate on March 1, and the commission can take effect on July 1. Regularized justices shall in all respect be equivalent to legacy justices, except as follows. Each regularized justice who wishes to remain on the court must take emeritus status no later than 18 years after his or her commission-eligible July 1 date. If any justice in active service shall take emeritus status or leave the court at a time when the total number of remaining active service justices shall be 9 or more, so we've got extra capacity, no court vacancy shall thereby be created. If, however, any justice in active service shall take emeritus status or leave the court at a time when the total number of remaining active justices shall be less than 9, the vacancy may be filled upon presidential nomination and Senate confirmation and presidential issuance of good behavior commission by a replacement justice. So just imagine, perish the thought that there were some pandemic or attack or something and a whole bunch of justices, somehow were incapacitated. Well, then you'd want to be able to replenish immediately. But I'm envisioning the idea of a replacement justice if someone leaves before their time. This replacement justice may continue in active service until displaced by the commissioning of a regularized justice in due course, whose addition to the court brings the total number of remaining active justices back to 9. So this is basically like just what happens in the Senate. If someone leaves before 6 years, someone else fills in the rump of their term. And just it maintains every 6 years the staggered replenishment. So you have this idea of a replacement justice. Provided that in no event may any replacement justice continue in active service for more than 18 years. So you just fill the spot of the person who has left early. If at any time there should be more than one replacement justice, the most junior replacement justice shall be the first displaced, the next most junior shall be the next to displaced, and so on. At the end of his or her active service, a replacement justice may elect to remain on the court by taking emeritus status. By the way, they're not going to be, no one's going to want to try to step down to game the system because you're allowed 18 years for yourself. And at best, if you step down early, you're just going to get a clone of yourself, so, just for the remainder of your term. So there's no benefit, just like there's no benefit, for a senator typically. Okay. Whenever the Chief Justice shall take, the current Chief Justice shall take emeritus status or leave the court, the position of Chief Justice shall devolve upon the senior-most legacy justice or regularized justice. So we have a sort of seniority system. And then I added something that you don't have to have at all, but if you want to have a partisan balance on the court, I have some rules about how the court shouldn't be more than 5-4 in either direction, but I'll just pull that out. It's severable. Except as otherwise provided for herein, all justices in active service shall perform the same functions as do the legacy justices on the date of this law's enactment. Emeritus justices shall be eligible to participate in case decisions only when the court is short-staffed. To wit, only in any given when in any given case the number of active service justices shall fall below 9 as a result of vacancy, disability, or recusal. And this is the final sentence. Emeritus justices shall also be eligible to perform ancillary administrative, ceremonial, educational, circuit writing, and docket management, that is even certiorari functions, as shall be outlined in rules to be promulgated and from time to time revised by the active service justices. So I want to enlist the court members themselves in trying to figure out what would make sense for them to do after 18 years, how they want to envision their final years of service and what they actually think they're going to be good at the end. Okay, so that's the proposal, and I invited you to have at me. Thank you very much. Whatever you like. Okay.
To Devin there, Greg, wait, the mic over here. Former legal associate Devin.
Hi. First, I wanted to say this is probably one of the best reform proposals I've heard of the court. So, and then I just had two possible criticisms. The first is that one of the best things I thought about this kind of thing is that it maintains the balance of power based on which party wins elections over the previous 18 years in the far future when there's only those justices on the court. But the problem exists that if it's, say, 2 years into the term or 4 years into the term and there's another president and one of the justices dies, the new president would be selecting the replacement, and so the balance of power on the court would shift based on the death of the justice in that case. Let me suggest an alternative that the justice selects their own understudy, which then must be Senate confirmed. So presumably the understudy would be of a similar judicial mindset of that justice, and therefore would not change the balance of power on the court even if they were to die.
That's a pretty cool idea. It's very similar to an idea that I proposed about House replenishment, because House replenishment can't be done the way the Senate is with the executive. Suppose a House member dies, you can't actually just have the governor pick a replacement. Now the problem is because of continuity in government issues, if there were a nuclear attack or something like that. So I imagine actually that when you're elected, the people on election day elect your vice representative. And so you could imagine each person picking their vice, or the president picking the vice justice at the same time. Now, what happens if there's a double death or something? How long a line of succession are you going to have? But I think that's a cool idea.
And the other thing, I at least value stability in the law more than having justices that are most responsive to the current majority. So in my opinion, it should be a 36-year term, which we would have one justice selected per presidential election.
And that's going to actually superheat the confirmation process rather than cool it down, and I think it will increase judicial arrogance rather than humility. So I had those 18 arguments, but by the way, thank you. I was at first thinking, well, this is maybe better than all these other, daft reform proposals that are out there. I once testified on behalf of a constitutional amendment proposed by a very great patriot. I'm a Democrat. He was a Republican. He was the longest-serving Republican senator in history, or the late, great Orrin Hatch. And it was a proposal to make people who weren't lucky enough, as I was, to be born under the American flag presidentially eligible after a long period of service. And Kennedy loved Hatch, and Leahy not so much. And Leahy gets up and basically in effect says, like, of all the horrible, stupid, outrageous things that Orrin Hatch has ever said, this seems to me the least horrible, stupid, and outrageous, which is the best, Pat Leahy was ever going to say, on behalf of Hatch. So I am glad you like it better than the others. And I'll take that on as a friendly amendment. That's a real possibility. But I think 36 would actually not achieve some of the features that I'm going for.
I saw one back there, yeah.
Andy Hawks. Professor, the recent Presidential Commission on the Supreme Court refused to endorse any form of term limits for justices. Did you have a chance to present your time rule proposal to the commission?
I did, and we actually did 3 podcast episodes. The first one where we just sketched out 18 years. The second one was called Witness, and it was called 18 Arguments for 18 Years. We had a second episode called Witness in the Center Square. It went back to Hollywood Squares. I was actually on the little Zoom grid. I was Paul Lind in the middle. Some of you will remember Hollywood Squares and Paul Lind. I did get a chance to make my pitch, and then when the commission issued its report, we had yet a third episode on this. So lots of binge listening awaits.
What do you think the commission got wrong?
They just didn't want to take a position on anything. That Biden created the commission to basically just let things cool down a bit and to take the pressure off some of these daft ideas like court packing and eliminating judicial review and all the rest. Their basic purpose was to do nothing. And some of you in Cato might think that's as good as you're ever going to get in Washington, D.C. So, but in fact, if you read their report, mine was one of two ideas that basically they hated the least and actually said has some real possibility. Now, several of the commissioners were my former students, Kim Roosevelt, Jack Goldsmith before he stepped off, Caleb Nelson before he stepped off, several more, and several were my colleagues, but I actually don't think there was as much opposition to this, and there was a fair amount of support for it, truth be told. Will Bode, also.
So thank you for that very insightful presentation. As you know, I'm generally supportive of the idea of 18-year term limits, but it's also my view that it probably requires a constitutional amendment. Your proposal is the best I've seen in terms of trying to make an argument that you can do it without an amendment, but I would want to briefly ask about a couple of problems. One is that if you defend the constitutionality of this by analogy to rules about circuit riding and things of this sort, then it seems like not only could Congress do this prospectively, but they could also do it retrospectively even for the current justices, because they could certainly, I would assume you'd agree, they could certainly alter circuit riding rules even for the current justices. And the current justice could not say, like, I was promised I wouldn't have to ride circuit or whatever, but now you're changing this. So it seems like then this would be a power that Congress could use for, in effect, a kind of quasi-court packing. If they don't like what the existing justices are doing, they could say, well, we're going to make certain existing justices emeritus justices, or restructure their duties in other kinds of ways, like you still have the title of Supreme Court Justice, but what you actually do is you hear parking ticket cases in Nome, Alaska on federal property or something like that. So I would worry about that. Then the second related issue is that I recognize there's some fuzziness on the question of what's eliminating or fundamentally altering the office of Supreme Court Justice versus procedural rules, but it does seem to me that unlike circuit riding and these other kinds of things, saying that after 18 years you're effectively deprived of the main power of the office that is sitting in a regular en banc, as you call it, that's going to the core of the office and therefore seems in tension with the constitutional provision of life tenure, even though obviously there could be other issues where that's less clear, like is too much circuit riding, trenching on that or not. Right. So those are my two concerns, but I do think this is much better thought out than other proposals that I've seen which say that this can be done without a constitutional amendment.
So actually, those are truthfully pretty easy, Ilya. Ilya is another former student. No one has a constitutional right to the existing jurisdictional regime in place when they're adopted, and for hundreds of years we've modified the rules, sometimes adding duties, sometimes taking it away, and that's just how we do things. And if you don't like circuit riding, by the way, I have a footnote saying we can eliminate this or anything else. In fact, one of the things I want to do is enlist the justices themselves in actually prescribing what makes sense, for them as individuals and their colleagues to do after a certain point. And forget just for a minute. So that's about Clarence Thomas or Sam Alito. Going forward, this is what you're signing up for, of course, when you when you're confirmed to the court that these are the rules that are in place. But just again to repeat, just in general. We haven't changed the nature of the Supreme Court office. We're not making you, in effect, decide nuclear launch codes or something like that. We're not taking a judicial office and turning it into Secretary of Defense. So we're just tweaking the office as we've done for 200 years, changing jurisdictional statutes all the time, and retroactively, not purely prospectively.
Can we make them actually ride horses again?
Huh? So
Roger Polong gets the last question.
But if again, any specific part of the duty, if you think it's actually like adding too much to what the justice is, just changing the nature of the job, you could just take that off the list. And I would actually welcome in the hearings, the congressional hearings we're going to have on that, testimony from existing justices as to whether they think this is actually too much or too little for existing justices and for future emeritus justices.
Final question to Roger.
Yes, since I hold the B. Kenneth Simon chair, it's fit and proper that I get the last question. Two questions, actually, a technical question and a constitutional. Technical is this. If I understand you correctly, if a justice appointed to an 18-year term leaves the seat, then his replacement doesn't get 18 years.
Correct.
He just fills the slot.
Exactly,
so it's really the slot that is the issue.
Correct.
Okay. All right. The constitutional
Just like the Senate.
Yeah. The constitutional question is this. I assume that you are grandfathering in current justices.
Correct.
Not simply for prudential reasons in order to get this through Congress, but rather for concern about the constitutional implications of applying this to sitting justices.
I think both. It's just
of course.
It's just better rule of law. It's not Clarence Thomas. Look, especially after Bruin and Dobbs, just the optics of we're gonna. This is first throw Clarence from the train and then throw Sam from the train.
Right.
No.
My question is this: is your concern well-founded, as it may be, about applying any of this to sitting justices? Does the concern spill over to what you're proposing? In other words, are you anticipating unconstitutional questions based upon your concern about grandfathering in current justices?
If you had any of those concerns, then just let's have a delayed start date so this doesn't even begin to go. If it goes into action, in 2036. That's going to be fine by me as long as, the bill is entitled the Amar Calabrese Judicial Reform Act of whatever.
As proposed at the Cato Institute on September 16th, 2022. And that actually gives us the end of our program for the day. Thank you to Professor Amar. And we will be having a reception of hopefully good refreshments up on the rooftop, the Canon Liberty Garden on the roof. We will have to kind of wait for some of the event staffer or Cato staffer to let you up to the 7th floor, but we have a pretty nice rooftop where Ilya got married. So thank you.